Serial number 32 at the request of learned counsel for the appellant. Release this matter on 14th of November. Yes.
Submission. Serial number 42 minute. Babu ಅಂತ ಇಶ್ಯೂ ಅಪೇರ್ ಸರ್ ಒಂದು ಅದರೊಳಗೆ ಸಮ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು ಸರ್ ಅದು ಸಮ್ ಗವರ್ನಮೆಂಟ್ ರೂಲ್ಸ್ ಚೇಂಜ್ ಆಗಿದೆ. Serial number 42 ಲೆಟ್ಸ್.
Say group matters. In 2 petitions, I will appear, my lord, respondent, and 2 petitions, my friend will appear, my lord. Government is the appellant. Kindly have it on 22nd, my lord.
Friday
Huh?
Friday 22nd Friday ದಿವಸ ಆಗಲ್ಲ
22nd.
25th 26th ಇಟ್ಬೋದು.
ಅಲ್ಲ 23rd working day.
ಹೌದು ಸರ್ 23rd.
27th.
Yes, my lord.
No, we'll have it on we'll have it on 21st.
No, my lord. Some inconvenience, my lord. 22nd, my lord.
No.
22nd, my lord.
Otherwise, we'll have it on 25th. 25th.
Progress.
Serial number 38 serial number 38 ಮೇಲೆ ಅದರ ಸೈಡ್ ಏನೋ ಚಾಕ್ ಶೀಟರ್ ಬಂದಿಲ್ಲ ಸರ್ ಅದರೊಳಗೆ ಆಕ್ಚುಲಿ 2024 ಮೀಟರ್ ಸರ್ ವಕಾಲತ್ತು ನಾನು ಏನೋ ಇದು ಎಸ್ ಸರ್ ಯಾಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಡಿಟ್ ಇಟ್ಟರೆ ನಾನು ವಕಾಲತ್ ಮಚ್
Yes.
Lordship, serial number 45. Have it on
It's on the other side.
There for respondent 1.
21st, my lord. Senior counsel G.V. Chandrasekhar has made a request that matter will be listed.
Last time time ತಗೊಂಡ್ರಿ ಇದ್ರಲ್ಲಿ.
Respondents were not there.
Huh?
Respondents,
Not there only.
ಮತ್ತೆ ಇವಾಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
senior counsel 21ಕ್ಕೆ time.
ನೀವು ಹಂಗಲ್ಲ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಎಲ್ಲ ಕೇಳಕ್ ಬರೋದಿಲ್ಲ. Senior has to come, let him come. Let him come on the date that is given by the court.
Lordship, after
This is the date given matter.
20th, my lord, please.
Serial number 45 at the request of learned counsel for the learned counsel Shri
V.K. Nayak.
G.B. Yadav.
Yadav is appointed as a government advocate. Pleader. Nayak is appearing.
His name is there.
V.K. Nayak.
V.K. Nayak. Release this matter on 21st. 21st. Let us see. You take a date, and if you don't come, then we'll have to take a strict view then. Yes.
Go on with the matter.
Non-compliance of office objections, 4th time, Veerangoda Mali Patil.
Two weeks time is granted to the appellant for complaints of office objections.
Serial number 2, Harshavardhan or Mali Patil.
Same order.
Serial number 3, AGA.
3 and 4 my lord. 2 weeks time ಬೇಕು.
Same order. The request of learned AGA, government.
Serial number 5, Deepak V. Barad.
Lord's week's time may be granted. Appearing on behalf of appellant.
Week's time is granted at the request of learned counsel for the appellant for complaints of office.
Serial number 6 for 5th time, additional government advocate.
6 and 7 my lord. Finally lots of grant 2 weeks time my lord.
Finally, 2 weeks time is granted. Yes, 6 and 7.
Please.
Order serial number 8, Sanjeev Kumar C. Patil.
Learned counsel for the appellant is directed to serve copy of IAS number 123 of 2023 on the learned counsel for the respondents, including the government advocate. Really, government advocate takes notice for respondents number 4 and 5.
Please.
Learned counsel for the appellant is directed to serve 2 sets of copies of appeal memo along with annexures on the learned government advocate.
Serial number 9, Veeradhar Veerangoda.
Huh? Huh? You are seeking dispensation. A week's time is granted at the request of the learned counsel for the appellant to take steps for service of notice on respond number 1. Full stop. Next para. In the connected matter, however, learned counsel for the appellant has filed a memo seeking dispensation of notice to respond number 4 on the ground that respond number 4 is the driver of the vehicle and no relief is sought against respond number 4. Full stop. Next para. At the risk of the appellants, respond number 4 is dispensed.
CL number 10, Jedage Kailas C.
Yes. Banta. ನಿಮ್ ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಇದೇನ್ರಿ? 2910. Yes. Again, they're asking you to go. Because after directions were issued, they say you have not appeared and they have not conducted the examination. ಯಾವಾಗ? ಯಾವಾಗ್ರಿ? ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಮೇಲ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ರಾ? ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ರೇನ್ರಿ? The director of Nephrology Institute, Nephrology-Urology Institute, Victoria Hospital, has made a communication dated 29/10/2024. Stating that the appellant not be examined and therefore a date may be fixed to ensure that the appellant is present for examination, medical examination. Full stop. Next para. However, learned counsel for the appellant submits that pursuant to the directions issued by this court, on 26/7/2024, the appellant was required to appear before the medical board on 21/8/2024 Stop. Accordingly, the appellant has appeared before the medical board on 21/8/2024. Stop. Further, two dates were given subsequently to the appellant to appear on 8/9, 8/9/2024 and 9/9/2024. Stop. On both the days, the appellant is said to have appeared was present in the institute. Full stop. Next para. Nevertheless, the appellant is once again directed to appear before the medical board on ಯಾವತ್ತು ಹೋಗ್ತಿರ್ರಿ? Huh? On 15th of November. Then we will 15th of November 2024 at 10 AM. Huh? Next para. Registry to ensure that copy of this order is immediately forwarded to the director of Nephro and Urology Institute, Victoria Hospital, forthwith, so that the members of the board will be able to assemble on 15th of November for the medical examination of the appellant. Full stop. Next para. Release this matter on 22nd of November. Nimge angry copy. No. The responsibility of the registry. Yes.
Seal
Yes,
number 11.
officer, please ensure that it is was sent. Tomorrow you will have to inform us. Yes.
Seal number 11, Sachin M. Mahajan.
Pass over. Pass over.
Number 12, BV Prakash Angadi.
He has to furnish correct address of R1 claimant.
Huh?
R1 correct address, he has to produce it.
R1. R1 is the claimant.
Also. He is the contesting.
Where is Mr. Prakash Angadi?
Bangalore.
Huh?
He's from Bangalore only.
Matta, who is going to represent?
He used to appear through VC only. That's. National Highway map.
Matter is called out. There is no representation for the appellant. National Highways Authority of India. Kalaburagi. Full stop. Learned government advocate submits that learned counsel Shri B.V. Prakash Angadi, who is on record for the appellant, He is practicing at Bangalore. Full stop. Next para. Release this matter. On 14th of November 2024 to enable the appellant to take steps for service of notice on respondent number 1.
Please.
Seal number 13, Manvendra Reddy.
These are disposed of matters, my lord. There was some amount, my lord, in deposit before this court by virtue of an interim order that may be transmitted to the, my lord, trial court. I have filed the memo, my lord, for.
Huh?
Disposed of matters. These are, my lord, disposed of matters. There was some.
Justice Srinivas Harish Kumar and Justice Q. Shankar Gowda.
Yes, my lord. There is some amount, my lord, kept in deposit by virtue of a, my lord, the interim order when it was pending. Those amounts may be transmitted to the, my lord, the reference court so that it can be dispersed. Now they have deposited in terms of the modified order, excluding, my lord, the amount which was, my lord, in deposit before this court. In fact, that amount I was permitted to withdraw. Before it could be withdrawn, my lord, the matter was disposed. Lordships may say that, my lord, it can be transmitted to the reference court, my lord, and subject to dispersal in terms of the final order that is passed.
Hey, copy of the order is not here.
Court of
Court of sir. Order copy will read. Final dispose of. Final.
16/2/2020.
ಕೊಡ್ರಿ ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ.
ನಾನು ನಿಮಿಷ.
ಅಲ್ಲ ಕಾಪಿ ಇಲ್ವ ನಿಮ್ಮ ಹತ್ರ ಆರ್ಡರ್ದು?
Compensation was reduced, my lord, in this case from 113 to.
Alright, how is it the both of you don't have a copy of the order?
Kindly pass on, my lord.
And in this order sheet also there is no order.
La court of the main file ಅಲ್ಲಿ ಇರುತ್ತೆ. Main file in the order. ಅದರಲ್ಲಿ
file
connect. Plus.
Seal number 14, Sangangoda V. Biradar.
The owner's appeal, my lords, clemency is also filed one appeal. Kindly, my lords, SS Mamdapur is, my lords, appearing on behalf of claimants.
Huh?
1 to 4, R1 to 4, my lords, in my case.
Learned Counsel Shri SS Mamdapur undertakes to appear for response number
1 to 4.
1 to 4.
Oh, yes.
Full stop.
And second set during the course of day, my lords.
Learned Counsel for the appellant is directed to serve a copy of
Yes, ma'am.
appeal memo along with annexures on Learned Counsel Shri SS Mamdapur. Office is directed to show the name of the Learned Counsel Shri SS Mamdapur in the cause list.
Second set during the course of day, my lords.
Huh?
Second set ಆಗ್ಬೇಕು ಇವತ್ತಾಗ.
ಯಾವ್ದಕ್ಕೆ?
ಇದು ನನ್ನ ಕೇಸಲ್ಲಿ,
First case.
ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ.
A week's time is granted at the request of Learned Counsel for the appellant to furnish second set of the appeal memo in MFA 200-529 of 2020. Yes.
Seal number 15, additional advocate.
For the appellant, due course of the day, my lord, I will pay. I thought that, my lord, others, one of the advocate will take notice, my lord. But nobody has come forward, my lord. I will take notice, my lord. Within 2 days, my lord, I will pay the process.
A week's time is granted at the request of learned government advocate to take steps to furnish the correct address and take steps for service of notice on
Respondent.
respondent.
Seal number 16, Virnugoda Malipati.
ಯಾವ್ದ್ರಿ court fee to be made good? Court fee to be made good, LAO award year and amount to be clarified. Respond number 2 differs between judgment and award, same to be clarified. Award date and year differ between judgment and award. Court fee ಏನ್ರಿ? According to them, it is not correct. Otherwise, they would have said here, what is to be complied, ಇಲ್ಲಿ 3 ಬರ್ತಾ ಇರಲಿಲ್ಲ. ನೋಡ್ರಿ. ಏನ್ರಿ ಸರಿಯಾಗಿ ನೋಡಕ್ ಹೇಳ್ರಿ, ಏನು ಒಂದೊಂದ್ ಕಡೆ ಒಂದೊಂದ್ ತರ ಬರೀತಾರೆ ನೋಡಿ. ನೋಡಿ ಇಲ್ಲಿ ಇನ್ ಟೈಮ್ ಕೋರ್ಟ್ ಫೀ ಸಫಿಶಿಯಂಟ್. ಆಮೇಲೆ ಇಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ರಿಗಾರ್ಡಿಂಗ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಂಬರ್ 3 and 16 that the valuation made by the appellant is correct and accordingly court fee is paid. ಅದನ್ನು ಹೇಳ್ತಾರೆ. ಆದ್ಮೇಲೆ they are again repeating serial number 3. ಏನದು ಯಾವ ಪಾರ್ಟಿ ಹೆಸರು ತಪ್ಪಾಗಿರೋದು? ಅದೇ ಬಟ್ ಅಲ್ಲಿ ಮುಂಚೆನೆ ಹೇಳಿದಾರೆ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಫೀಸ್ ಸಫಿಶಿಯಂಟ್ ಅಂತ. ಹಂಗಿದ್ರೆ ಅವ್ರು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅಂತ ಅದನ್ನ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಅದು ಇಲ್ಲ.
SLA date of forward correct. 15, 12,
3 ಇದೆಯಾ?
ಇದು wrong mention ಮಾಡಿದ್ದಾರೆ. 15, 12, 2015. SLA forward 15, 12, 2013.
So we will overrule all the other office objections except court fee. You please go get it clarified. Or let them give a calculation as to according to them, what is the court fee to be paid. Office objections at serial number 4, 5, 7 and 16 are overruled. Stop. However, insofar as court fee is concerned, office is directed to clarify as to what is the amount, what is the court fee payable. Full stop. If the appropriate court fee is paid, then office may put up a note that court fee paid is sufficient. Yes.
Serial number 17, Irungoda Mali Patil.
Certified copy of award. ಯಾಕ್ರಿ ಸೇಮ್ ಪಾರ್ಟಿನಾ? ಸೇಮ್ ಪಾರ್ಟಿ. ನೀವು ಹಟ್ಟಿಗೊಂಡ್ಮೇಲೆ all these arise out of the same judgment and award. Office objection at serial number 7 is overruled. What is it? As in MFA 202775 of 2022 dated 14/10/2024. Learned ಅಲ್ಲ ಎಲ್ಲ ಬಂದಿದೆಯಲ್ರಿ ಇಲ್ಲಿ?
ಅಲ್ಲ not yet ordered ಅಂತ.
ಅಲ್ಲ ಎಲ್ಲ ಇದೆ ಇದರಲ್ಲಿ ಸೇಮ್ ಆರ್ಡರ್. ಪ್ರಿನ್ಸಿಪಾಲ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಎಲ್ಲ ಇದೆ ಇದ್ರಲ್ಲಿ ಸೇಮ್ ಆರ್ಡರ್.
Serial number 18, Ravi B. Patil.
This matter, my lord, second respondent, I'll take notice, my lord. Connected matter, writ appeal is there. Yes, sir. What's the process?
Bidar.
Like what is the error of the learned single judge order in this case, my lord? What is the error of the learned single judge in this case, my lord? The fact of the case, my lord, be with the landowner, what RTC has submitted to the deputy commissioner.
What have we done in that other matter?
My lord, that is
Reach agli.
I will take, my lord, the quick, within 1 minute, my lord, so that it, my lord, in this case, the petitioner is made an application before the deputy commissioner. The moment made an application, my lord, the time limitation under section 95 of the Land Revenue Act. So it says about the time limitation, assuming that the deputy commissioner is not being considered that applications, it's a deemed conversation, which that part we are not, disputed, my lord. Time limitations is the petitioner grievance before the learned single judge is correct. What was the error in this, my lord? The entire fact has to be looked into by the learned single judge in this case. The reasons for the deputy commissioner to rejection, he mentioned in the order, saying that this property was being declared as, notification by way of notification. This property belongs to Waqf board.
Is the name of the work board found in the RTC?
Well, it is not there in the RTC, so that the notifications have been given to them and communicated to the petitioner. And this fact so was not being considered by the learned single judge. Assuming that the deputy commissioner order, it is an error on the merit of the case.
Of reputation, we are again telling you that this matter has gone up to the Supreme Court and the matter has been dismissed. Your SLP has been dismissed.
I agreed, my lord. My lordship is last
The
occasion.
same set of facts.
I agreed. My lord.
Yes.
My lord, lordship has last occasions, my lord, lordship has expressed that it is went to the Supreme Court. The Supreme Court is confirming the learned single, this honorable court order.
Yes.
What was in that fact of the case, my lord? So, my lord, after work notification is issued in 2019.
Who is the aggrieved person?
My lord,
Who is the aggrieved person?
in this case, my lord,
Yes.
this case, my lord, the aggrieved person is a deputy commissioner because we need to sustain our order, no, my lord.
It's not about sustaining the order, sir.
My lord,
If the contention of the deputy commissioner is that the property belongs to someone else, sir, who is the aggrieved person?
the aggrieved person ultimately that the works board only, I am not denying on that, but since, my lord, I am before your.
Said, it would have been different if you contended that it is a government property. Property belonging to the state. We can understand.
Correct.
That is not so. You are contending it belongs to Waqf board.
My lord, that's it.
Waqf board is not challenging it. We can't understand what you are trying to do, sir.
I fully aware. My lordship is rightly pointed out, saying that property is not belongs to you. You are only the authority of issuing the
Correct.
notification.
Yes.
Why are you so much interested in filing the appeals?
Yes.
That the view of this honorable court, I understood.
Yes.
But matter of fact, my lord, I am before your lordship. I had to be open my mouth and I had to be make my submission in this.
Only for the making.
No, not like
only-
that. But the deputy, the state of the state, my lord, my humble prayer, my lord, the deputy commissioner order is a state order. Deputy commissioner order is a state order. I have to be protected in that manner. We have been before.
Sir, the same matter has been considered by the Supreme Court. It has been rejected. Your submissions have been rejected.
My lord, in that I am able to be distinguished.
Same
just
set of facts.
No, that fact of the case, I am going to be distinguished in that case, my lord.
ಏನು?
My lord, in that case, my lord, see this, the works case issued notice for the works board in 2000. My lord, in this case, 1991 is a sale deed. What I'm submitting with regard to the Supreme Court where it is got a
Could you
dismiss.
please give a copy of that? Could you selfie copy could you?
Copy ಅಷ್ಟೇ ಇದೆ ಡಿಸ್ಮಿಸ್ ಅಂತಿದೆ ಬಟ್ ಐ ಸಬ್ಮಿಟಿಂಗ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್.
Yes.
My lord, it's a para number 4 in this case. Para number 3, my lord. The petitioner has purchased the land bearing survey number so and so, 2 acres 13 guntas situated so and so. The wide registered deed
1991.
1991. My lord, in this, the notifications was issued much prior to that. Thereafter, that has been, I think it's a delinked this property and absolute owner of the property by the petitioner in this case, my lord. So my lord, the last occasions after this, we have also asked the deputy commissioner to give entire details. So that it is the 11th, submitting on that. But in this case, my lord, this is a distinguished this case after the work notification issued and they subsequently release the property in
How
favor
are
of the
you
petitioner.
concerned, sir?
Huh?
How are you concerned? How is the deputy commissioner concerned?
Like, I'm deputy commissioner concerned with regard to the order passing only, the made application. That is only the limited of the deputy commissioner order here. Coming to the appeal on merit of the case,
You are
grievance
trying-
party is required.
What you are trying to do is you are trying to justify the order of the deputy commissioner who has said, no, the property belongs to work board and therefore we cannot convert. The same set of facts.
My lord, anyhow, 11th is there, my lord, 11th or 12th? 11th, same day I will conclude the matter, my lord. This petition copy also, by the time I will secure, my lord, from the deputy commissioner.
Writ appeal ಅಲ್ಲಿ learned counsel Ravi V. Patil takes notice for the respondent. For respondent number 1.
New open.
Work board ಯಾರ appear ಆಗ್ತಾರೆ? Liaquat Farid Ustad.
Liaquat Farid Ustad.
Learned counsel Shri Liaquat Farid Ustad is requested to take notice for respondent number 2. Learned counsel for learned government advocate is directed to serve copies of the appeal memo along with annexures on the learned counsels for the respondents. Release this matter on 11th of November.
In contempt, my lord, I will take notice for R2, my lord. You served, my lord. I'll take notice.
Contempt petition ಅಲ್ಲಿ learned government advocate takes notice for respondent number 2.
CL number 19 SS Alalli.
ಅಲ್ಲ respondent number 1. Respondent number 1 ತಗೊಂಡಿದ್ದೀರಾ ನೋಟಿಸ್ ಆಗ್ಲೇ?
Yes, performer party.
Undertakes to appear for respondent number 2.
Yes.
Release this matter on 11th of November.
CL number 19 SS Alalli.
Appearing for the accused number 2. In this matter, I have filed a reply statement indicating that I have partly complied the direction issued by the learned single judge. Due to the insufficient funds, we could not comply the, in view of the learned single judge order, we have partly
say 82,400. And out of that, Lord, the all have been regularized from 29/3/2023. And in respect of Lord, the complaint number 6 is still daily wager. The entire amount of Lord, the complaint number 6 has been paid. 4,58,240 they have paid in respect of complaint number 6, who is not regularized. So remaining Lord, the complaints have been regularized from Lord 29/3/2023. And Lord, the some amount Lord, in each remaining cases they have paid 1,14,560. And they are saying that there is a paucity of the fund. So we will, they are now filing request undertaking to pay in 1 year this.
1 year.
There is no sufficient fund in the TMC, my lord.
So
We have
they are also
requested
asking for a SRC
the
fund.
concerned government to release for the funds. But they have said that you have to pay the wages from the TMC fund only. They know that there is no funds in the TMC, my lords, as on today. We have been continuously requesting, my lord, since from 2 years.
This arrears is prior to regularization.
On 30/8/2023 itself, as per annexure R1, we have requested the government to release the salary of these complainants. But till today, they have not released the funds, my lord.
ಅಲ್ರಿ ಸಂಬಳ ಕೊಡೋದಕ್ಕೆ ನೀವು 1 ವರ್ಷ ಟೈಮ್ ಕೇಳಿದ್ರಿ ಹೆಂಗ್ರಿ?
ಇಲ್ಲ TMC ಅಲ್ಲಿ ಫಂಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ?
ಪ್ರಾಜೆಕ್ಟ್ ಡೈರೆಕ್ಟರ್ ಮುನ್ಸಿಪಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಬೆಂಗಳೂರಿಂದ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಸ್ಟೇಟ್ ಫೈನಾನ್ಸ್ ಕಮಿಷನ್ ಲಿಂದ ನಮಗ್ ಫಂಡ್ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ನಾವು ಅವ್ರಿಗೆ
ಎಷ್ಟು ಇನ್ನು ಬಾಕಿ ಕೊಡೋದು?
ನಾವು
Right now the arrears will be around Lord the
34 lakhs,
34 lakhs 36,800
will be the remaining balance amount which is yet to be paid, my lords. So again, we have requested the project director to get release.
ಬರೀ 7 ಜನನ ಇನ್ನು ಬಹಳ ಜನ ಇದ್ದಾರ?
ಇಲ್ಲ 6 ಜನ 7 ಜನದ 6 ಜನ ಒಬ್ಬರದು ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದೇವೆ. Entire arrears has been paid in respect of complaint number 6. Now only the persons who have been regularized 8 months salary ಹಿಡ್ಕೊಂಡ್ ಕೇಸಿ ಅವ್ರದ್ದು ಇಲ್ಲಿವರೆಗೂ ಪೇ ಮಾಡಿದ್ದೇವೆ. 8 months salary ಕೊಟ್ಟಿದ್ದೇವೆ. Remaining would be 34,36,800. We have requested the government to release the funds from the State Finance Commission so that it would be cleared. ಅದು ಅವರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಗವರ್ಮೆಂಟ್ ಅವರು. Hence in my applications also I have sought direction to the respond number 1, my lords, for release of funds.
ಅಲ್ಲ ಅವ್ರ ಪ್ರಾವಿಷನ್ ಗೆ ಇವ್ರು ಹೇಳಿದಕ್ಕೆ ಅವ್ರ ಪ್ರಾವಿಷನ್ ಒಪ್ಪಿಕೊಂಡ್ರೆ ಇಟ್ ಮೇ ಬಿ ರಿಲೀಸ್ ಮಾಡಿ. ಅದರ್ವೈಸ್ ದ ಸ್ಟೇಟ್ ಫೈನಾನ್ಸ್ ಅಂಡ್ ದಿ 15th ಫೈನಾನ್ಸ್ ನಾಗ ಇವು ಯಾವ ಇಟ್ಟಿರಲ್ಲ ಅವರು. ಇವನು ಸೇರ್ಸಿದ್ರು ಹಾಕಿರಲಿಲ್ಲ. ಇಫ್ ದ ಕೋರ್ಟ್ ಪರ್ಮಿಟ್ಸ್ ದೆಮ್ ಟು ಇನ್ಕ್ಲೂಡ್ ದಿಸ್, ದೇ ಮೇ ಇನ್ಕ್ಲೂಡ್ ಅಂಡ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಕ್ಲಿಯರ್ಡ್. As it is, but I also have the information that there is no fund as such. If in the state finance, brought the fund, if they can make a provision, state finance is the state brought the and the SFC, 15th finance is from the central government.
Date matter of ಇದು ಸ್ಟೇಟ್ ಫೈನಾನ್ಸ್ ಕಮಿಷನ್ ಫಂಡ್ ಇದ್ರಲ್ಲಿ ನಮಗೆ ಪರ್ಮಿಷನ್ ಕೊಡ್ಬೇಕು ಯುಟಿಲೈಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅವ್ರಿಗೆ ಏನು
Not if this courts can direct the state government to include in the state finance commission this arrears.
In paragraph number 11, you have said
please
that for the years 2025-26, State Financial Commission funds is going to be released by the government. Yavaga?
ಈ 15th ಕಮಿಷನ್ ಅಂತ ಇಯರ್ಲಿ ಏಪ್ರಿಲ್ ಗೆ ಒಂದು ಫಂಡ್ ರಿಲೀಸ್ ಆಗುತ್ತೆ ಸ್ಟೇಟ್ ಫೈನಾನ್ಸ್ ಕಮಿಷನ್ ಇಂದ. ಅದರಲ್ಲಿ ಅವ್ರು ನಮ್ಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ನಾವು ಇವ್ರದ್ದು ಸ್ಯಾಲರಿ ಎಂಟೈರ್ ಪೇ ಮಾಡ್ಬೋದು.
The second respondent has filed a reply statement along with affidavit. Stop. It is stated that the arrears of salary insofar as complaint number 6 is concerned, namely Shri Shivappa, son of Shivaputra Arekar, has been fully paid. Stop. However, in respect of the other components,
each has been paid 1,14,056.
Huh?
560.
Each remaining each have been paid 1,14,056.
A sum of rupees 1,00,000.
14,560.
ಎಲ್ಲಿ ಹೇಳಿದ್ದು?
ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ ಬಟ್ ನಾವು ಪೇ ಮಾಡಿದ್ದೇವೆ.
14,000.
14,056.
500.
ಅಲ್ಲ, 5,6.
1,14,560.
560
In
has
respect of
been paid.
By check, my lord.
Each has been paid to the other complainants.
complaint.
Full stop. However, arrears of rupees 6,87,360. ಅದೇನ್ರಿ ಒಬ್ಬೊಬ್ರದ ಅದು?
ಹೌದು ಸರ್.
ಹೌದು ಒಬ್ಬೊಬ್ಬರು.
ಅದ್ ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ? 8 months salary ಅಂತಾರೆ. 8 months salary 6,87,000 ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ ಅವ್ರಿಗೆ?
ಇಲ್ಲ ಅಷ್ಟು ಕಂಪ್ಲೇಂಟ್ ಕಲ್ತೆ.
ಆ?
6 complainants.
Entire not all 7 together.
So what is required to be paid is only less than 7 lakhs, not 34 lakhs.
ಇಲ್ಲ ಎಲ್ಲರೂ ಸೇರಿ ಆಗುತ್ತೆ ಸರ್.
34 lakhs.
ಎಲ್ಲರೂ ಸೇರಿ ಆಗುತ್ತೆ. 17ರಿಂದ ಇದೆ ಇದು.
8 months salary ಅಂತ ಹೇಳಿದಾರಲ್ರಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 8 ಅಲ್ಲಿ. ಹಾ?
ಇಲ್ಲ ಇಲ್ಲ ಅಷ್ಟಾಗಲ್ಲ.
Yes, my lords. 1,14,560 into 6, my lords. That will come to 6,80,000.
Now they say that now they are paying it.
ಈಗ ನಾವು ಇದು ಕೊಡ್ತಾ
Now they
ಇದ್ದೀವಿ.
have paid for all the remaining 6 they have paid.
ಪೇ ಮಾಡಿದೀರಾ?
ಇವಾಗ ಪೇ ಮಾಡಿದ್ದೇವೆ.
ಯಾವಾಗ?
ಅಲ್ಲ,
ಪೇ ಮಾಡಿದಾರಲ್ರಿ?
ಹಾ ಮಾಡಿದ್ದಾರೆ.
On
They
file
have
level.
given check.
ಹಾ?
They have given check to the all complainants.
On 5/11.
What is the balance?
Balance would be, my lords, 34 lakhs,
ಎಲ್ಲಿ
36,000.
ಹೇಳಿದೀರಾ ಹಂಗಂತ?
ಅಲ್ಲಿ ಹೇಳಿದ್ಲ. But remaining balance.
Total 45 lakhs 82,400 ಆಗುತ್ತೆ.
ಯಾಕಂದ್ರೆ ನಿನ್ನೆ ಅವರು ಚೆಕ್ ರೆಡಿ ಮಾಡ್ಕೊಟ್ರು.
In their reply, my lord, page 8, my lord, R3. Page 8. They reply.
So further, another sum of rupees 6,87,360 is said to have been paid.
Yes.
After the reply statement was filed at the hands of respondent number 2. Stop. Nevertheless, the balance payable is
34 lakhs, 36,800.
about rupees 34 lakhs.
36,800.
Stop. For that purpose, it is stated that the salaries of the Paura Karmikas that the contribution of the state government towards payment of salaries of the Paura Karmikas is limited to the existing devolution under SFC bracket only United Grants close bracket as per the recommendation of State Finance Commission. Stop. Any additional financial implications has to be borne out of municipal own funds. Full stop. it is also stated that for the next financial year, that is 2025-26, the State Finance Commission is going to release funds, and the arrears of salary payable to the other complainants will be paid. Stop. Next para. The second respondent. Chief Officer of the Town Municipal Corporation.
Afzalpur.
Town Municipal Council ಬಂದ್ರೆ
ಹೌದು. ಹೌದು.
ಕಾರ್ಪೊರೇಷನ್ ಅಲ್ಲ ಇದು,
Corporation,
ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್.
council.
Afzalpur shall be bound by the statement made in the reply and the affidavit. Stop. Next para. This matter shall be kept out of circulation. Full stop. Liberty is reserved to learned counsel for the appellant, complainant, to move a memo after the funds are released for the next financial year, that is 2025-26. Yes.
Lord, there could be direction to the state government to include in the state.
ಮಾಡಕ್ ಬರುತ್ತೆ, ಹಾ?
Allah, to include this arrears of salary in the.
ಅಲ್ಲ, now they have made a statement.
ಹೌದು.
When the next financial, this one is
ಅಲ್ಲ, ಅವ್ರು
released.
ಹೇಳ್ತಾರ normally my lord, they would, unless it is included, it is very difficult for the even TMC.
ಅದಲ್ರಿ,
ಅಲ್ಲ, ಗೊತ್ತಾಯ್ತದೆ.
in that a portion of the this budget will be earmarked for salaries. Out of that, they will have to pay you.
ಅಲ್ಲ, ಪ್ರತಿ ವರ್ಷ ಹಾಕಿರ್ತಾರೆ, ಇಲ್ಲಿವರೆಗೂ they have not approved it in the SFC. State Finance.
Next academic year ಗೆ ಎಲ್ಲಾರ್ದು ಹಾಗೆ ಆಗುತ್ತೆ ರೀ. For the payment of salaries of the staff of the municipality, a portion is allocated. Out of that, they have undertaken to pay.
ಅಲ್ಲ, that I am not saying.
Yes.
If that observation is that it may government.
That is why we have said you'll be bound by this undertaking given. And we have given liberty to you. As soon as it is released, you come and move the memo, we will issue directions. Yes.
CL number 20 hearing on a Babu H Metagudda.
Case of death, the claimant appeal for enhancement also challenging liability. His liability, his vehicle is a lorry, as per pleadings, evidence, is working as a labor. The deceased was working as a labor.
Jeremiah, you are ready?
Yes.
Ready.
Labor. His deceased was working as a labor on the lorry. But the para 12 of the judgment come to conclusion the deceased was cleaner of lorry at the time of accident. But come to conclusion he was traveling as a passenger, paid passenger and but their cross examination also they admitted he was a labor. In my PW2 the cross examination of the insurance companies admitted the deceased was working as a labor on the lorry. Kindly see the PW2 my pleadings also lorry working as a labor. The findings is para 12 of the judgment is totally against the evidence and the cross examination. My pleadings is working as a labor and a lorry. But the cross examination also they are not disputed in the PW2 permit me to read.
ಯಾರು dispute ಮಾಡ್ತಾ ಇಲ್ಲ?
Company ಅವರು
How can you say that they are not disputing? It is for you to place material.
My pleadings is, this was
Use of just pleading, sir. What material have you placed?
lorry, my lord. Labor, my lord. My pleadings is
What material have you placed, sir, to show that you are working as a coolie?
labor, my lord, ಏನ್ ರೆಕಾರ್ಡ್ ಇರಲ್ಲ ಸ್ವಾಮಿ, ಲೇಬರ್ ಏನ್ ರೆಕಾರ್ಡ್ ಇರುತ್ತೆ
So
ಸ್ವಾಮಿ.
ನೀವು ಹೇಳಿದ್ರೆ ಅದನ್ನ it should be taken as a proved, is it?
ಅದೇ ಡಿಸ್ಪ್ಯೂಟ್ ನಾವು
ಅವ್ರು ಏನ್ರಿ dispute ಮಾಡೋದು? If it is for you to prove,
my pleadings is
it is for you to plead and prove. Just because they have not put any questions to you, it doesn't mean that they have accepted it. And that is not the way of proving that you have been working as a coolie. ಹಂಗಾಗೋದಿಲ್ಲ.
My lord, as for Supreme Court, labor, there is no evidence, my lord, expectation of the court, my lord.
That is
Labor
why
ಗೆ expect,
they will
ಏನು
take
labor
it-
ಗೆ ಇರಲ್ಲ
That
ಸ್ವಾಮಿ.
is why they will take it as no proof of salary.
ಅಲ್ಲ, ಈಗ ಕಂಪನಿ ಅವರು ಲೇಬರ್ ಅಂತ ಅಡ್ಮಿಟ್ ಮಾಡಿದಾಗ, my lord,
ಏನ್ರಿ ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡೋದು? What do you mean by they are admitted?
ಅವ್ರದ್ದು ತಾವು ಕ್ರಾಸ್ ನೋಡಿ ಸ್ವಾಮಿ, ಅವ್ರದ್ದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೋಡಿ ಸ್ವಾಮಿ.
Not the way of
ಅವ್ರು
proving.
ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಪ್ರೊಸೀಜರ್ ನಾವು ಏನಾದ್ರು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ಅವರೇ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಲ್ಲ
No
ಅಂದ್ರೆ
evidence that the deceased was traveling as a cleaner in the said lorry. The evidence placed by the petitioner itself goes to show that he was traveling in the lorry as paid passenger. This is the tribunal has come to this conclusion.
ಈಸ್ ಲೇಬರ್
Lodge to dislodge that opinion. What material have you
ಇಲ್ಲ,
placed?
ಇದನ್ನ ರೀಡ್ ಮಾಡಿಲ್ಲ ಅವ್ರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ದ ಮಿಲಾಡ್ PW1 ಮಿಲಾಡ್ ಅವ್ರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮಿಲಾಡ್ ಫೈಂಡಿಂಗ್ಸ್ ಇಸ್ ಮಿಲಾಡ್. ಈ ಫೈಂಡಿಂಗ್ಸ್ ಮಿಲಾಡ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅವ್ರು ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಪ್ಯಾರಾಟೋಲೋಲ್ ಮಿಲಾಡ್.
ಈ ತರ ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ? There is a collusion between the insurance company and the claimants ಅಂತಾರೆ. Please understand. We can't become parties to these kind of submissions, sir. No, it's not possible. Already there are a lot of allegations against insurance companies.
ನಮಗಿರೋದು ಒಂದೇ ಎವಿಡೆನ್ಸ್ ಮಿಲಾಡ್. ಓನರ್ ಈಸ್ ಪ್ಲೇಸ್ಡ್ ಎಕ್ಸ್ಪರ್ಟ್ ಮಿಲಾಡ್.
ಒಂದು ಬಾಕ್ಸ್ ಹಾಕಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಅವ್ರನ್ನ ಅದನ್ನ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ನೀವು. You can't say
ಅವ್ರು owner ಮಿಲಾಡ್,
admitted. How can
owner-
they admit?
he owner also expert, he is not denied milad, is a relationship between milad employer and employee milad.
You know?
He owner is expert milad, he is not denied milad.
You will have to get him. If you say you are working as a cleaner under the owner of the vehicle, he have to enter the witness box and say, yes, he was working as cleaner with me.
He milad ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೋತಾರ ಸ್ವಾಮಿ ಅವರು.
ಏನು?
To take all the difference which are taken by the owner.
170 ಕೆಳಗಡೆ ಹಾಕಿರ್ತಾರ ಸ್ವಾಮಿ
ಹ್ಮ್.
ಅವ್ರ ಮೇಲೆ 170 ಆದ ನಂತರ ಬರ್ಡನ್ ಅವ್ರದ್ದೇ ಇರತ್ತ ಸ್ವಾಮಿ. ಈಗ ನಮ್ ಪ್ಲೀಡಿಂಗ್ ಇದೆ ಎಕ್ಸ್ಪರ್ಟ್ ಇದ್ದಾನೆ ಸ್ವಾಮಿ, ಈಸ್ ಪ್ಲೇಸ್ಡ್ ಎಕ್ಸ್ಪರ್ಟ್ ಮಿಲಾಡ್. Then milad they under 147 170 ಕೆಳಗಡೆ ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ.
MB Act. Sir, this is regarding the employment and employer relationship. It is not about correct.
Place compensation.
Correct. The claimants are required to prove that this was the salary being earned by the person.
ಇವನ್ ನಾವು ಎವಿಡೆನ್ಸ್ ಇವನ್ ಮಿಲಾಡ್ ಸಾರಿ ಮಿಲಾಡ್, ಇವನ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರು ಓನರ್ ಯಾರು ಡಿನೈಡ್ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ. ಈ ಟೈಪ್ ಕೇಸ್ ಓನರ್ ಡಿನೈಡ್ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಎಕ್ಸೆಪ್ಟ್ ಮಾಡೇ ಮಾಡ್ತಾರ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಡಿನೈಡ್ ಮಾಡಿದ್ರೆ ಡೈರೆಕ್ಟ್ ಅವ್ರ ಮೇಲೆ ಬರತ್ತ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ ಮಿಲಾಡ್ ರಿಲೇಶನ್ಶಿಪ್ ಡಿನೈಡ್ ಮಾಡಿದ್ರೆ ಡೈರೆಕ್ಟ್ ಓನರ್ ಮೇಲೆ ಬರತ್ತ ಸ್ವಾಮಿ.
It is not only the relationship, sir. It is also to prove what was the salary being paid to you.
Salary ಮಿಲಾಡ್
It is not about the relationship. How do you prove the salary? It is for you to prove that you are
ಇವಾಗ ಓನರ್ ಸ್ಯಾಲರಿ ಮಿಲಾಡ್ ಅವ್ರು 10,000 ಕೊಟ್ರು ನಮಗೆ ಮಿಲಾಡ್ ಟೋಟಲ್ ಚಾಟೆ ಪ್ರೂವ್ ಆಗುದು ಸ್ವಾಮಿ. ಅವ್ರು 1,000 ಕೊಟ್ಟರು ಚಾಟ್ ಅಪ್ರೂವ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ನಮಗೆ ಅವು ಓನರ್ದ ಅಮೌಂಟ್ ಎಷ್ಟು ಕೊಡ್ತಾನ ಬಿಡ್ತಾನ, ನಮಗೆ ಅದು ಅಮೌಂಟ್ ಇಷ್ಟೇ ಬೇಕಂತ ನಮ್ಗೇನಿಲ್ಲ ಸ್ವಾಮಿ. ತಾವು ಕೋರ್ಟಲ್ಲಿ ಏನ್ ಚಾರ್ಟ್ ಪ್ರಕಾರ ಕೊಟ್ರೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ನಮ್ಗೆ ಅಮೌಂಟ್ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ನಮಗೆ
ಚಾರ್ಟ್
ಅವ-
ಪ್ರಕಾರ ತಗೊಂಡಿಲ್ವಾ ಈಗ?
ಇಲ್ಲ ಅದ್ರ ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನು?
ಇನ್ಕಮ್ ಕಡಿಮೆ ತಗೊಂಡಿದ್ದಾರೆ ಆಮೇಲೆ. ನಮ್ಗೆ ಇನ್ಕಮ್ ಹೆಚ್ಚಿಗೆ ಬೇಕಂತ ಇಲ್ಲ ಸ್ವಾಮಿ. 6,000 ತಗೊಂಡಿದ್ದಾರೆ, 7,000 ತಗೋಬಹುದು ಸ್ವಾಮಿ. ನಮಗೆ ಅಮೌಂಟ್ ಬಗ್ಗೆ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಈ ನಮ್ಗೆ ಚಾರ್ಟ್ ಪ್ರಕಾರ 7,000 ಬರತ್ತ ಸ್ವಾಮಿ, ಅಷ್ಟು ಕೊಡ್ಬೋದು. ನಮಗ್ ಇಲ್ಲಿ ಬಂದಿರೋದು ಸ್ವಾಮಿ, ಅವ್ರ ಕಂಪನಿ ಅವ್ರು ಏನಾರ ಡಿಸ್ಪ್ಯೂಟ್ ಪ್ಯಾಸೆಂಜರ್ ಅಂತ ಫೈಂಡಿಂಗ್ಸ್ ಮ್ಲಾಡ್ ನಮ್ದು ಪ್ಲೀಡಿಂಗ್ಸ್ ಲೇಬರ್ ಅಂತಿದೆ. ಅವ್ರದ್ದು ಕ್ರಾಸ್ ಕೈಲಿ 1 ಮಿನಿಟ್ ಮ್ಲಾಡ್ ಪರ್ಮಿಟ್ ಮೀಟ್. ಮೃತ ಮಹಬೂಬ್ ನನ್ನ ಮಗ ಇರುತ್ತಾನೆ, ತೀರಿಕೊಂಡಾಗ ಆತನ ವಯಸ್ಸು 22 ವರ್ಷ ಇತ್ತು. ವಯಸ್ಸು ಸಂಬಂಧ ಯಾವುದೇ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನನ್ನ ಮಗ ಕೂಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದನು. ಆತನು ಲಾರಿಯಲ್ಲಿ ಕೂಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದನು. ಲಾರಿಯಲ್ಲಿ ಸಾಮಾನು ತರುವ ಕೆಲಸಕ್ಕೆ ಹೋದಾಗ ಕರೆಂಟ್ ವೈರು ತಾಗಿ ನನ್ನ ಮಗ ತೀರಿಕೊಂಡಿರುತ್ತಾನೆ. ಅವ್ರು ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಪ್ರೊಸೀಜರ್ ಮೇಲೆ ನಮ್ಮ ಓನರ್ನ ಇದು ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ನಾವು ಅವ್ರನ್ನ ಕ್ರಾಸ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
So he is treated as a gratuitous passenger.
ಹಾ ಮಿಲಡ್.
Further it is said, ನನ್ನ ಮಗ ಲಾರಿಯಲ್ಲಿ ಕೂಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದನು ಅಂತ ಸುಳ್ಳು ನುಡಿತಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ.
ಅದೇ
ಆತನಿಗೆ ಪ್ರತಿದಿನ 300 ರೂಪಾಯಿ ಕೂಲಿ ಕೊಡುತ್ತಿದ್ದನು ಅಂತ ಸುಳ್ಳು ನುಡಿತಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಿಲ್ಲ. He has denied that fact.
ಇಲ್ಲ
Further in the cross examination. And
ಇಲ್ಲ.
moreover,
ತಾವ್ ನೋಡಿ.
everything is very clear, my lord.
ಮಿಲಡ್ ತಾವು
The
ಫ್ರಂಟ್
contents of FIR, complaint and charge sheet show that the marriage party was going in the lorry and he was also one of them. And he was traveling to attend a marriage. They attended the marriage and while returning the accident.
ಅವ್ರ ಅದನ್ನೇ ಅವ್ರು ಕ್ರಾಸ್ ಅಲ್ಲಿ ಡಿನೈ ಮಾಡಿಬಿಟ್ರೆ ನಮ್ದು ಮುಗೀತು ಸ್ವಾಮಿ. ನಂದು ಏನಿಲ್ಲ. ಬಟ್ ಅವ್ರು ಅದನ್ನ ಏನು ಇದು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಕ್ರಾಸ್ ಆಗಿ ಮಿಲಡ್
ಅಡರಲ್ಲ ಮುಂದೆ
ಇಲ್ಲೇ ಇದೆ ನೋಡಿ.
ನನ್ನ ಮಗನು ಲಾರಿಯಲ್ಲಿ ಒಂದು ಮದುವೆ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಹೋಗಿ
ತಾವ್ ನೋಡಿ ಸ್ವಾಮಿ
ವಾಪಸ್
ಕ್ರಾಸ್
ಬರುವಾಗ
ಯಾವ ತರ ಇದೆ ಅವ್ರ ಕಂಪನಿ ಕ್ರಾಸ್ ಯಾವ ತರ ಇದೆ ತಾವ್ ನೋಡಿ ಸ್ವಾಮಿ. ಮಿಲಡ್ ಪರ್ಮಿಟ್
See, having filed the application, taking on the responsibility or stepping into the shoes of the owner of the vehicle. You said they have filed an application. Insurance company has filed an application. And they have stepped into the shoes of the owner of the vehicle. They have put all these questions to you. Which means they are denying the fact that you are a cleaner in the cleaner with the owner of the vehicle.
ಮಿಲಡ್ ಡಿನೈಡ್ ಮಾಡಿದ್ರೆ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ. ಅವ್ರು ಡಿನೈಡ್ ಮಾಡಿಲ್ಲ, ನನಗೆ ಅದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
Oh, that is why she is reading that.
ಅಲ್ಲಿ ತಾವ್ ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡಿ ಸ್ವಾಮಿ. ಒಂದ್ ಸೆಕೆಂಡ್ ನೋಡಿ ಸ್ವಾಮಿ. ಅವ್ರ ಕ್ರಾಸ್ ಚೀಪ್ ನೋಡಿ ಸ್ವಾಮಿ. ಕ್ರಾಸ್ ನೋಡಿ ಸ್ವಾಮಿ. ನಾನು ಕೊಟ್ಟಿರೋದು ಮಿಲಡ್. ಅದ್ರಲ್ಲಿ ಡಿನೈಡ್ ಮಾಡಿದ್ರೆ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಮಾರ್ಕ್ ಇದು ಹೈಲೈಟ್ ಮಾಡಿ ಕೊಟ್ಟಿನಿ ನೋಡಿ ಸ್ವಾಮಿ.
ತರ್ಸಿಲ್ವಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ತರ್ಸಿಲ್ವಾ?
ಅದು
and you are arguing the matter.
Each year ಬೇಕಾದ್ರೆ
ಹೇಳಿ ಸರ್.
each year ಬೇಕು ಇಲ್ಲ ನೀವಿದ್ರೆ ಕೊಡ್ರಿ.
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅದೇ ಅವ್ರ
pleadings ಅವ್ರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನಾಗ್ತಾರೆ?
Call for trial court records.
ಆಯ್ತು, ಅವ್ರದ್ದು ನನ್ನ ಕಡೆ ಇಲ್ಲ ಸ್ವಾಮಿ.
This written statement in para 3 we have taken a count.
Bill number 21, Harshvardhan R. Mali Patil.
ಸರ್ ಕಾಪಿ ಕೊಡ್ರಿ.
Appeal by the claimant, my lord, he is due to pay, my lord, about 2 lakhs and odd as the court fee. It's matter. It's an appeal by the claimant, my lord, arising from the land acquisition matters. Court fee of rupees 2 lakhs and odd is required to be paid. But I have sought for, my lord, an application for enlargement of time. But this will be a recurring issue, my lord, before this court.
You know?
My lord, I have filed the appeal, my lord, against the award, seeking, my lord, further enhancement. Court fees, my lord, of 2 lakhs and odd is required to be paid. I have sought for, my lord, enlargement of time, my lord, for payment of court fee. My lord, that could be considered. It is put upon, my lord, that application. My lord, what has happened is, my lord, now that 120 days cap has been introduced in the new act, Lord, we are required to file, my lord, appeals immediately, or else, my lord, we'll lose our rights. Lord, in no event, my lord, that compensation will be paid within that, my lord, hurried time. Lord, this will be a recurring issue, my lord, if your lordships, my lord, could devise something, my lord, to provide some relief, my lord. ಅವರು ದುಡ್ಡೇ ಬರೋದಿಲ್ಲ ಸುಮ್ಮನೆ land is taken over, no payment is made. We are required to, my lord, arrange court fee and, my lord, fight an appeal.
That is because you are asking for enhancement.
Yes, yes.
Yes.
But, my lord, that's the situation, my lord.
That's also you want to depend on their payment only, means what can we do?
ಅಲ್ಲ ನಮ್ದು situation your lordships may, my lord, consider.
See, if you are
No, I'm not-
accepting.
No, I'm not saying that, my lord, I'm excused from the court fee. My lord, I'm saying that, my lord, this could be deferred, my lord, still I could, my lord, get some money, my lord, or arrange some money. I'm only seeking for, my lord, enlargement of time. That is, my lord, extension of time for payment of court fee, my lord, till
148.
Lord, one.
Section 148.
For enlargement of time to pay the court fee.
Order pass ಮಾಡಿದಾರಾ court
ಇಲ್ಲಿ some
earlier? Such orders have been passed.
my lord, yes, my lord. So one matter, my lord, about 8 weeks time was granted. I had sought time, my lord, till, my lord, till they deposit at least the part of the amount, my lord, or Lord, one my lord, way of Lord, one methodology, my lord, followed by earlier courts, my lord, subsequently it is not followed. This Gopal Gowda, my lord, did that, my lord. He, my lord, said that this application could be taken up, my lord, at a later stage. So, my lord, the notices, other things were done, my lord. By the time we could be, my lord, deposited, that would, my lord, fit in the legal framework, and, my lord, still, my lord, the harshness of, my lord, payment of court fee, my lord, is, my lord, negated on the claimants, my lord, for the time being, my lord, till they get some amount, my lord, for.
But how can we issue notice without you paying the court fee?
Yes, my lord. That is why, my lord, in earlier cases, my lord, that is how it was devised. The application was said to be taken up along with the main, and, my lord, and the notices were issued. It is not that I have not paid the court fee. Paid, my lord, very small portion, part, my lord. Because, my lord, I am worried about, my lord, the recurring, my lord, these applications will, my lord, come up again. Because if you lordships, my lord, grant me 4 weeks or 8 weeks, that can be done. My lord, I will still be stuck with the same thing, because 8 weeks, my lord, I don't see, my lord, any compensation being dispersed. It's only, my lord, the concern, my lord, of, my lord, burdening the court and, my lord, to come out of this situation. Otherwise, my lord, what we would do was, my lord, earlier, we would, my lord, pay the court fee and, my lord, file the appeal as and when, my lord, they deposited the amount and seek for, my lord, condonation of delay based on that. Lordships, my lord, generally condoned those delays, saying that he did not have the resources to pay the.
So
Now, my lord, I could not do that. I would lose my right of appeal on.
This is better. This position is better.
Yes, this is better, my lord. This is
ಇಲ್ಲ ಅಂದ್ರೆ
just time.
so much of delay, and yesterday you heard the submission of the learned senior counsel.
Yes.
In many such matters.
Yes.
We have ignored so many other things.
No, my lord. My lord, that I would reply to him, my lord. In his absence, I would not make. My lord, only part of the judgments were read, my lord, the other day.
No.
The other parts.
I remember I also passed an order.
Yes.
You were referring to, I think, in the same bench. A week ago or 2 weeks ago.
Yes.
We passed such an order.
Yes.
Based on the order of the division bench, coordinate division bench. You are now seeking to make a claim that ಆ ಜಮೀನಿಗೆ ಅಷ್ಟು ಕೊಟ್ಟಿದ್ರು, so I am also entitled for the same. ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ ಅಲ್ಲಿಗೆ, if 1000 acres of land are acquired, compensation should be given similarly in respect of all the properties. ಹಂಗಾಗೋಗುತ್ತೆ.
ಇಲ್ಲ. My lord, that's the view, my lord, that is put in by the learned senior counsel, my lord, in the court. I would rebut that. Aday same judgments, my lord, which was remanded. Adaralli court ಏನು ಹೇಳುತ್ತೆ ಅಂತಂದ್ರೆ, if there is, my lord, similarly placed lands, my lord, I don't say that, my lord, give them uniformity. Similarity has to be ascertained. that similarity can be basis, my lord. They propose that, my lord, there are 200 kilometers, the distance between two notifications. Gulbargadalli, one end in the one end, it is, my lord, hardly 80 kilometers. The way it was put across.
There can be a difference between the neighboring property.
I'm not on that.
About,
I'm not
kilometers.
I am not on that, my lord. I'm not on that. I'm not saying that, my lord, for every case, my lord, similarity has to be, my lord, at least where cases.
Okay, we will-
Yes,
we will
yes,
come to it
my lord.
later.
That
We
is
are
where,
now
my lord,
only concerned about payment of court fee.
yes. My lord, one way of doing this would be, my lord, the application could be considered, my lord, or the consideration could be deferred and notice could be ordered. My lord, till that time, my lord, because this case will not progress, my lord, until I pay the court fee. At least the first stage will be over, and by the time, my lord, that happens, my lord, the court fee could be paid, and this would come up, my lord, for hearing as well. Earlier, what was done was, my lord, it was ordered to be taken up along with the main.
Pending consideration of IA number 1 of 2024 regarding 23 regarding enlargement of time for payment of court fee. Come on. Learned government advocate is directed to take notice for both the respondents.
3 respondents.
Huh?
Special Land Acquisition Officer, Commissioner.
For all the respondents. Yes. For all the respondents. Learned counsel for the appellant is directed to serve 2 sets of copies of the appeal memo along with annexures on the learned government advocate.
Right.
Yes.
Records also may be called for.
Huh?
Records also may be called for.
Call for trial court record.
Great.
Seal number 22.
Lord, in this matter, my lord, appear for the appellant, my lord.
This is a matter, my lord.
84 days delay, my lord. In, my lord, one, my lord, circumstances, my lord, coordinate bench, my lord. When there is a direction to deposit, my lord, 50% of amount, my lord, that was not deposited by the state. Then, my lord, chief secretary, additional chief secretary and advocate general was directed to be present before the court. Then, my lord, after hearing the, my lord, the said order is passed by the, my lord, coordinate bench, my lord, directing the state to deposit, my lord, 25% of the amount and 10% has to be released to the owner in the case of taking the over the possession. May I read, my lord? This is a very important. Serious matter was, my lord, taken place at Narrow bench, my lord, for that is the reason. These appeals call in question the order of the reference court arguably enhance the compensation in multiple units. While admitting these appeals and granting interim stay, the coordinate bench has stipulated the condition of the depositing 50% of the award amount in registry of the court below. The condition having been not complied with, despite granting accommodation, we had shown our red eye to the appellants inasmuch as contempt proceedings were initiated by the landowners. Nothing concrete having happened towards compliance of the condition. We had sought for the personal presence of the additional advocate general, additional chief secretary, government of Karnataka. This day, the additional chief secretary, Mr. So-and-so, managing director of so-and-so, and Upper Krishna project were personally present. Mr. Gupta explained the matter in greater details than was warranted as to what all steps have been taken in the matter. He mentioned about the high-level meeting held in the presence of the Honorable Chief Minister, Portfolio Minister, other high functionaries. Obviously, the implementation of the mega project like the one in the question would involve huge investment. Learned Advocate General so-and-so and the Additional Advocate General so-and-so that may, given the financial implications, complying with the condition of stay order is bit difficult, and therefore their application for modification of the said orders be favored. This is opposed by the side of the land losers, inter-alia, contending that the applicants are treating the land losers in the discriminatory way when it comes to the dispositing the amount or paying the compensation of the lands acquired. Very fairly, learned AAG tells us that some mistake on the part of the official appears to have happened. Having heard all the stakeholders, these cases, we are the considered opinion that the subject application supported by the narrative affidavit need to be favored, and the condition of require 50% deposit has to be relaxed to the reasonable extent, Mr. So and so AZ and AZ, all fairness agreed with us view that the whatever position has been taken, the appellant should deposit 25% of the enhanced compensation and 10% should be permitted to withdraw by the landlords against some security for repayment. Whenever possession is yet to be taken, the appellant should deposit 10% of the enhancement compensation and the same should be permitted to withdraw by the landlords against some security for repayment. These minor should be deposited, should be deposited in the registry of the reference court within 5 weeks from this day. In the above circumstances, the subject applications having been forwarded, the interim order of stay granted in these appeals are modified to the following effect. Whenever possession has already been presumed to the acquisition process, the requirement of depositing 50% of the enhanced amount of compensation is relaxed. Instead of the appellants shall deposit 25% of the enhanced compensation and 10% of such enhancement shall be released in favor of the claimants against guarantees bond in favor of the reference court. Wherever possession has not yet been taken, the condition required deposited 50% enhanced compensation amount is relaxed and the appellant shall deposit only 10% and further that the same shall be permitted to withdraw by the landlords against guarantee bond executed in favor of the reference court. The payment shall be made in the registry of the reference court within an outer limit of 5 weeks, failing which the appeals run the risk of dismissal on that ground per se. The proceedings directed at annexure so shall apply to all the appeals wherever any interim order is granted or not, inasmuch as that has been the broad understanding between the parties and the court. All these appeals parties have agreed before us to argue in the last week of November 2024 without seeking any adjournment. We make it again clear that non-compliance of the above direction may result into dismissal of these appeals. So for here, my lord, the present case.
ಅದರಲ್ಲಿ more than crores rupees, my lords. ಇದರಲ್ಲಿ
ಅಲ್ಲ ಎಲ್ಲದ್ರಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಆಮೇಲೆ
pending cases also, my lord.
Cannot be taken as a benchmark now.
ಅಲ್ಲ that is my
ಆಮೇಲೆ
lord.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ in that case, my lords, ಒಂದು ಯಾವ್ದೋ
36 ಅಂತಂದ್ರೆ
I am told my learned brother, ಅಲ್ಲಿ per square feet 6,000 square feet 6,000 rupees.
ಹೌದು
1,615 ರೂಪಾಯಿ per square feet.
And odd is not per gunta, which works out to
7
7
lakhs.
50,000 or 53,000.
ಅದರಲ್ಲಿ ಅಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ ಸೇಮ್ ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಸೇಮ್, my lord. In that case also, my lord,
Same per acre, ಅದು square feet.
1,615 ರೂಪಾಯಿ ಒಂದು per square feet per square feet ಮಾಡಿದ್ದಾರೆ.
Square feet ಮಾಡಿದ್ರು.
ಇದರಲ್ಲಿನೂ ಕೂಡ kindly ಸುಮಾರು
ಮಕ್ಕಳದ್ದು
kindly ಸುಮಾರು 18,000 18,000 my lord 834 per ಗುಂಟಾ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
ಎಷ್ಟಾಗುತ್ತೆ?
That is my lord, if it calculated my lord, that is announced the 36 lakh ಏನೋ ಬಾರಿ.
Divide it and convert it to into per square feet ಎಷ್ಟಾಗುತ್ತೆ?
ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಗೆ ಅಂದ್ರೆ
17 ರೂಪಾಯಿ.
17 ರೂಪಾಯಿ.
17 ರೂಪಾಯಿ.
ಹೌದು.
What comparison?
7.5 ಲಕ್ಷ ಪ್ರತಿ ಎಕರೆ.
We can't take this as a benchmark. No, no.
that is my lord.
ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ ಹಿಂಗೆ ಮಾಡಿ ಅನ್ಬಿಟ್ರೆ
Kala for that is addition. Advocate General only my lord requested me to bring to notice of lordship, my lord.
Yes, yes.
This is the order is passed, my lord, in all the cases.
That cannot be taken as a benchmark now. In all the cases, ಹಿಂಗೆ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ.
That is
ಬಹಳ
also
ಕಷ್ಟ.
mentioned, not that is also mentioned in the my lord, even pending appeals and also my lord, that is that which wherever not, that is also.
If pertaining to that project.
Same, lord, this is also same project, my lord. Project is same, my lord.
Huh?
Project is same. This is, my lord, run with the Bagalkot and my lord, Bijapur district. Bagalkot is coming under the my lord, jurisdiction of Dharwad. Same project. This is Almaty, my lord, project, my lord. Same project. We acquired, notification is one. But the lands is, my lord, fallen to the my lord, district of Bagalkot. They
ಅದು
approached
city
the
limits,
Dharwad.
square feet ಆಗಿದೆ, correct.
Same project, my lord.
For them,
But that
Lord,
is the reason, my lord, this order was
10%
taken
will be
into
Lord
consideration. Even
100 rupees.
50% of the compensation amount is not deposited by the state.
You know,
50% amount, my lord, is
that the
granted.
amount was very huge. That is
Yes,
why.
my lord, that's reason.
That's why, my lord, even
Not so here.
ಇದ್ರಾಗನು ಕೂಡನು ಎಲ್ಲ
ಟೋಟಲ್ 7 crores per acre ಬರುತ್ತೆ ಅಲ್ಲಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ಬರೋದು
ಇರೋದು 7 ಕೋಟಿ.
Per acre.
ಅವರು ಅಡಿಷನಲ್ ಸಾಲಿಸಿಟರ್ ಜನರಲ್ಲೇ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಡಿಪೆಂಡ್ ಅಪಾನ್ ದಿ my lord.
Correct. It depends on where the property is situated.
Yes.
And now you can't make it a rule, apply this to everyone ಅಂತ. ಹಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಇದರಲ್ಲಿನೂ ಕೂಡನು ಇದರಲ್ಲಿ
ಆಗುತ್ತೆ ಇಲ್ಲಿ.
ಅಲ್ಲಿ
What is the
ಇಲ್ಲಿನ
amount?
ಇಲ್ಲಿನ ಸೇಮ್ ವಿಲೇಜ್ my lord, that is also my lord, granted more amount, even square feet also.
36 lakhs 3,674.
ಬೇರೆ ಕೇಸ್ ನಲ್ಲಿನೂ ಕೂಡ ಇದು ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮೇಲೆನೆ ಹೋಗಿದ್ದಾರೆ.
ಇಲ್ಲ, ಎಲ್ಲಾನು ಇದ್ಮೇಲೆ.
1 acre 18 ಗುಂಟಾಸ್ಗೆ ಎಲ್ಲ ಒಟ್ಟು ಸೇರಿ 36 lakhs 3,674. ಅಲ್ಲಿ 1 ಎಕರೆಗೆ 7 ಕೋಟಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ಅಷ್ಟು ಅಂದ್ರೆ ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮೇಲೆನೂ ಮಾಡಿದ್ರು, ಇಲ್ಲಿನೂ ಮಾಡಿದ್ರು.
Please come to page number 27. Ink page number 27.
Yes. ಅದು 18,834 per ಗುಂಟ ಅಂತ ಮಾಡಿ. 18,834 per ಗುಂಟ.
ಅದೇ.
That is more 1 acre 18 ಗುಂಟ total extent.
1 acre 18 ಗುಂಟಾಗೆ 36 lakhs 3,670.
That is along with the consequence.
ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 27 ಡಿಗ್ರಿ ಅದರಲ್ಲಿ ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಬರೆದಾರೆ. 36,03,674.
ಹೌದು. Difference amount which is already paid, that is already paid, my lord, that is deducted, and this is the amount we have to pay. Now, my lord, the subsequent interest also we have to pay.
10% will be around 100 rupees square feet. 45 lakhs
In the
ರೂಪಾಯಿ
interim
ಪ್ರತಿ
order
ಎಕರೆ
also, my
principal
lord,
amount
interim
ಸಿಗುತ್ತೆ.
order also, my lord, if you not paid that amount also, my lord, there is a penalized interest also, my lord. If you not deposited that amount also, my lord, within the stipulated period, then further interest is also, my lord, added.
And the similar, my lords, connected metal 50%.
ಅಲ್ಲ ಆಗಿದೆ ಇದ್ರಲ್ಲಿ ನಾನೆಲ್ಲ ಸಾಹೇಬ್ರೆ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲ ಅಂತಲ್ಲ ನಾನು, ಬಿಕಾಸ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ my lord, after conducting the meeting by the my lord chief minister, my lord, this was the informed to the my lord ಯಾವ್ಯಾವ ಡಿಪಾಸಿಟ್ ಆಗಿ 50% also, my lord, there is a my lord request that has to file the application for modification of that order also.
TPC ಕೊಡು. ಹೌದು. that's it. Wherever possession already been assumed, it is reduced to 20%. Where it is not taken 10%.
That is the, my lord, request, my lord, of the additional clerk. But otherwise, my lord, you will appear, my lord, on 12th, my lord. Another matter, your lordship fix the date on 12th, my lord. You will appear and lord make the submission.
Who will appear?
Advocate General. my lord.
Ah.
And the one matter is your lordship is posted on 12th, my lord.
Ah.
On the same day, my lord, you will appear and make the submission. Because, my lord, there is a full, my lord, regarding financial, my lord. But that I don't want to say, my lord, that is, but that is the reason, my lord. The Chief Minister only conducted the meeting and that is the, my lord, policy has taken. But that is the reason, my lord, I am making the submission. Otherwise, my lord,
You want it on 12th?
please, my lord.
At the request of the learned government advocate, take this matter on 12th of November.
Please.
We will see, let him come.
Award copy.
October.
Amount.
Yes, ma'am.
Yes.
October.
Money, so that we'll have a,
Reference ಇದೆಯಲ್ಲ, there is award copy.
we can have a clear comparison.
The reason is this, my lord, the financial strain.
ಅದೇ.
ಅದಕ್ಕೆ there is huge uptrend in my lord land acquisition appeals and my lord cases by the state.
My lord, I'm told that, my lord, even, my lord, when the Chief Minister was conducted the meeting, my lord, all the farmers was also present before in that meeting, my lord. Then, my lord, government come to the conclusion that, my lord, project itself is going to be dropped. Then farmers say that, no, don't drop it. We are ready to accept that. But that is the reason, my lord, happened this. We wanted, my lord, government is decided to drop this project.
Award ಮಾಡಿದ್ರೆ denotify ಮಾಡೋದು.
There is a, my lord, my lord, cabinet is taken the decision, my lord, that is, can do it. But when, my lord, farmer himself also participated and requested not to drop.
I don't know, it is up to you. The consequences of such decision will clearly be reflected in the public.
That is happening, my lord.
ನೀವು ಇಂಥ ಪ್ರಾಜೆಕ್ಟ್ಗಳನ್ನ ನಮಗ್ ದುಡ್ಡು ಕೊಡಕ್ ಆಗಲ್ಲ, ಆದ್ರಿಂದ ನಾವು ಡ್ರಾಪ್ ಮಾಡ್ತೇವೆ ಅಂದ್ರೆ ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ ಪ್ರಾಜೆಕ್ಟ್ ಇದು? ಫೋರ್ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಆಗಿರೋದು ಯಾವಾಗ?
2014 ಲಿಂದ ಎಲ್ಲ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ ಸರ್. 2014, 15, 16, 17, 18. By step, we issued the notification. 2000 notification amount is also not paid. Even interim order is granted by the, my lord, honorable court. So for that is the reason, my lord, honorable court taken very seriously and directed the concerned officer to be present before the court. Then, my lord, after conducting the meeting by the Chief Minister, my lord,
You take note of their submission, you get that relevant information.
I will get it, that copies and also award and also I'll get. it. Same, my lord, that is 23 and 25 also.
23 and 25.
For 25.
23 and
23 and 25.
All right.
Cell number 24, Priti Patil Nalkundi.
Yes.
Proxy council will be taken next week, my lord.
Huh?
And proxy council will be taken next week.
For release of the amount.
It is shall liability and matter. Liability, my lord.
Liability.
Please, my lord.
Help of principal, in this case, private vehicle is there, but liability only act policy is there, but
Huh?
liability only act policy is there. Is a driver not covered policy conditions. Kindly next week is delay may condone or
50%, at least 50% will be released, madam.
Huh?
50% amount will be released.
At the request of learned counsel for the appellant, release this matter on 14th of November.
much.
Cell number 26, Sanjeev Kumar C. Patil.
Lord, this appeal by the claimant seeking enhancement. Injury case, my lord. He has suffered the loss of one eye and other, my lord, multiple fractures. The disability is given by the code, the doctor is 48%.
India.
Net.
United India.
Any Mr.
Sharan Basappa,
Learned counsel P. Sharan Basappa and Patil, who is present in the court, takes notice for respondent number 2.
R1 and R3 may be dispensed. They are owner. Liabilities on.
Counsel for the appellant has filed a memo seeking dispensation of notice to response number 1 and 3 on the ground that respond number.
They place ex parte even before the
Huh?
trial. They place ex parte before the tribunal, my lord. And one and
Driver.
ಅಲ್ಲ both are owner, my lord. ಅವ್ರು
Huh?
ಇಬ್ಬರು ಇದ್ದಾರೆ ಓನರ್. ಒಬ್ಬರು ಮತ್ತೆ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ. ಅದೇ RC ಹೋಲ್ಡರ್ ಒಬ್ರು ಇದ್ದಾರೆ, ಓನರ್ ಆಕ್ಚುಯಲ್ ಓನರ್.
Respondents number 1 and 3 claim to be the owners of the vehicle. And liability has been passed on respondent number 2. Friends, come. Stop. Next para, at the risk of the appellant.
And
notice to response number 1 and 3 is dispensed with.
and they have placed
Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures and learned counsel for respondent number 2. Next para. Delay of 45 days in filing the appeal is condoned. Full stop. IA number 1 of 2024 is accordingly disposed of. Yes. Lokadalata.
ಲೋಕದಲ್ಲಂತೂ ಕಳಿಸ್ಬೋದು.
Yes, it may be referred. It is injury case. It may be referred to Lokadal.
Matter stands referred to Lokadala.
Appeal number 27, Bapugoda Siddhappa.
And repeat for the appellant, the claimant's appeal for seeking enhancement. Mons. The notice to the respondent number one may be dispensed. Mons. The second, the
Yaru
second
insurance
respondent
company
is Tata A General Insurance. ಅವ್ರು ಇಲ್ಲ ಮೇಡಮ್ ಪ್ರೀತಿ ಪಾಟೀಲ್ ಸುಭಾಷ್ ಮಲ್ಲಾಪುರ್ ಸುದರ್ಶನ್ ಎಂ
ಡಿಸ್ಪೆನ್ಸೇಷನ್ ನೋಟಿಸ್ ಮೆಮೋ ಹಾಕಿದ್ದಾರೆ. Respondent number one is the owner of the vehicle.
ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಮೋಸ್ ಓನ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಒನ್.
This is to be referred to local.
Yes, Murs. There is delay is there, Murs. 85 days.
85 days is controlled, same order.
Yes.
Seal number 28, Muhammad Abdul Kayam. Seal number 28.
Matter is called over. There is no representation for the appellant. Release this matter on 12th of November.
Seal number 29, Puneet Markal.
Claimant's appeal for enhancement, my lord. I am seeking dispensation with regard, notice with regard to respondent number one, my lord. R1 is owner.
209 days delay.
There is delay 209 days.
ಯಾವ್ದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ?
Tata AIG, my lord.
ಇನ್ನೊಬ್ರು ಯಾರಿದ್ದಾರೆ? ಸಂಜಯ್ ಎಂ ಜೋಶಿ.
Please.
ಇಲ್ವಾ? ಒಬ್ರೇನಾ? ಎಂ ಸುದರ್ಶನ್ ಒಬ್ರೇನಾ?
Please.
ನೀವು ಇದ್ದೀರಾ? ಮಿಸ್ಟರ್ SS ಹಾಸ್ಪಿಟಲ್. For respondent number 2.
2, man.
Officer ಮಾಡಿ ಅವರಿಗೆ.
Please, my lord.
What do you say?
It may
Matter
be-
to be referred to local.
Please, my lord. Matter may be referred to local, my lord.
209 days delay.
It may be condoned
Huh?
without interest.
Condoned without interest for the delayed period. I referred.
Seal number 30, 30, Basappa M Patil.
Appearing for appellant, my lord, this is insurance appeal, my lord. I'm challenging on the liability, my lords, as well as quantum, my lords. The deceased also has been charge sheeted, abated charge sheet has been filed against him, my lords. And there were no passengers in the auto while moving in the auto and truck. I have met with an accident, my lords. And date of accident is of the year he was consumed alcohol, my lords.
Anyway, you have to deposit 50%.
Yes, ma'am. Please.
Delay of 61 days, huh?
Yes. Ma'am. Notice.
So there is a delay of 61 days in filing the
My lords,
appeal.
one submission. Notice has to go. Notice.
Learned counsel for the appellant submits that the claimants have filed execution petition and therefore the impugned order has to be stayed. Impugned judgment is required to be stayed while imposing conditions on the appellant. Stop. Next para. Accordingly, issue notice to the respondents. Full stop. However, there shall be an ad interim order of stay of the impugned judgment in MVC 35 of 2023 on the file of the on MACT 3, Kalaburagi till the next date of hearing, subject to the appellant depositing 50% of the award amount before the reference court within a period of 6 weeks from today.
Please.
Seal number 31, GG Chakshakti.
I am from the. This honorable court directed the party must be present before the court.
Huh?
Party is directed to present before the court, must they are present.
One is a respondent.
Well, the divorce decree is granted.
Seal number 31.
31.
31.
Please.
Huh.
Must divorce decree have been granted by the family court.
Hmm.
That was not challenged, must. In so far as the
permanent liability is fixed on the appellant is 10 lakh rupees minutes. Against that order, I have prepared this appeal only for permanent elimination. That is because he is a driver. He is unable to pay the 10 lakh rupees and he sought for some reduction of that amount in 10 lakh rupees minutes. Magala.
They have not awarded only to the wife. 10
Wife minutes. They are not sought for minutes. Only permanent elimination sought only minutes, and that was not charged. Divorce is not questioned before this honorable court or anything. They have accepted the divorce.
Yeah, the husband filed the petition.
Yes, miss. Against the only picture, permanent elimination is challenged before this court in this amendment. Page number 18, months. Page number 18 may kindly be seen, para 3. The petitioner is hereby directed to pay 10 lakhs permanent alimony to the respondent.
Then what about the education of the daughter?
That not, they have not filed any petition, but not, I'll advise to pay. I'll advise my client to pay the maintenance of the children. There's no problem. Whatever his income, he is ready to bear some expenditure will be spent for the education purpose or other things. That let's family courts come to a conclusion that he is running a travel agency. That is not correct. His name is also Vinod and not.
What are your instructions? ಸ್ವಲ್ಪ ಮುಂದೆ ಬನ್ನಿ. ಇವಾಗ ನೀವೇನು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ ಇದ್ರ ಮೇಲೆ? ಮಾಡಿದೀರಾ? ಹಾಕಿದಾರಾ?
ಎಲ್ಲಿ? ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟಲ್ಲಿ ಹಾಕಿರಾ ಮೇಂಟೆನೆನ್ಸ್?
ನೀವು ಕ್ರಾಸ್ ಅಪೀಲ್ ಏನಾರು ಹಾಕಿದ್ರಿ?
ಹಾಕಿವ್ ಸರ್, ಅವ್ರು ಏನು ಅಟೆಂಡ್ ಆಗಿಲ್ರಿ, ಇನ್ನೊಬ್ರಿಗೆ ಕೋರ್ಟಿಗೆ ಅಟೆಂಡ್ ಆಗಿಲ್ಲ ಸರ್, ಇದಕ್ಕೂ ಸ್ಟೇ ತಗೊಂಡ್ ಕೂತಾರ.
ಹಾಕಿದೀರಾ?
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿದಾರೆ, ಕಾಸ್ ಅಪೀಲ್ ಫೈಲ್
ಸ್ಟೇ ಇದೆ ಸರ್, ಅದಕ್ಕೆ ಅವ್ರು ಏನು ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಇಲ್ಲಿ ಹಾಕಿದ್ರಿ?
ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ.
ಅಲ್ರಿ ಅಮ್ಮ, ನಿಮ್ಗೆ ಇವಾಗ ಈ ಮ್ಯಾರೇಜು ನಿಮ್ಮ ಮದುವೆನ ಡಿಸಾಲ್ವ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಹಂಗೆ ಅವ್ರಿಗೆ ಡೈವರ್ಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನೀವು ಅದ್ರ ಮೇಲೆ ನಿಮ್ಗೆ ಅದು ಓಕೆನಾ ಆರ್ಡರ್? ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಕ್ ಹೇಳಿದೀರಾ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ಗೆ?
ಇಲ್ಲ, ಅಪೀಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಯಾಕೆ ಮಾಡಿಲ್ಲ ಅಂತ ಸರ್, HIV ಇದೆ ಅಂತ ತಿಳ್ಕೊಂಡು ಅವರು ಡೈವರ್ಸ್ ಹಾಕಿದ್ರು ಸರ್.
HIV ಅಂತ
HIV ವಾಸ್ ಪ್ರೂವ್ ಆಗ್ಬೇಕಂದ್ರೆ ಡೈವರ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಡೈವರ್ಸ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್.
ಡೈವರ್ಸ್ ಕೊಟ್ಬೇಕಾ?
4 minutes they are not filed. Only
ಅದಕ್ಕೋಸ್ಕರ ನಾವು ತಗೊಂಡಿಲ್ಲ, ಯಾಕಂದ್ರೆ HIV ಅಂತ
permanent
HIV ಅಂತ ಅವರೇ ಪ್ರೂವ್ ಮಾಡಿದ್ರಲ್ಲ. ಸೊ HIV ಪ್ರೂವ್ ಆಗ್ಬೇಕಾದ್ರೆ ಆಟೋಮೆಟಿಕ್ಲಿ ಡೈವರ್ಸ್ ಪಿಟಿಷನ್ ಅಲೋ ಐತೆ ಸರ್. ಪರ್ಮನೆಂಟ್ ಅಲಿಮನಿ ಇವ್ರು ಕೇಳಿದ್ರು, ಅದ್ರ 10 lakhs ಫೀಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. Out of that 10 lakh, the petitioner
have deposited 2.5 as per the order of this.
Is it a fact that
yes,
is she admitting that?
Yes.
Admit ಆಗಿದೆ ಸರ್, HIV ಅಂತ ಬಂದಿದ್ದಾರೆ.
There are medical.
Yes,
sir. On the HIV ಬಂದಾರೆ.
Medical report on the basis of the medical report.
But she looks all right.
ಬಟ್ ಈಗೆಲ್ಲ ಕ್ಯೂರ್ ಆಗಿದ್ದಾರೆ.
ಅದು because of floods,
ಅಂತಂದು ಕೋರ್ಟಿಗೆ ಹಾಕಿ ಡೈವರ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಒಳಗೆ ಆರ್ಡರ್ ಆಗತ್ತೆ, ಅದು ನಮ್ಮ ಆಗ್ತಾ ಕೋರ್ಟ್ ಆಗಂಗಿಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ. ಈಗ ಅದು 10 lakh ಆರ್ಡರ್ ಆಗಿ ಎಜುಕೇಶನ್ ನಮ್ಗೆ ಸಾಲ ಇರ್ತದೆ. ಈಗ ಮುಂದೆ ನಮ್ಮ
ಏನು ಕೇಳೋ ಇಲ್ವಲ್ಲಮ್ಮ? ಕೇಳ್ತಾ ಇರೋದು ನಿಮ್ಗೆ, ನೀವೇನು ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ ಇದ್ರ ಮೇಲೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ.
ನಮ್ಗಷ್ಟು ನಮ್ಗೆ ದುಡ್ಡು ಖರ್ಚು ಮಾಡಿ ನಮ್ಗಷ್ಟು ಇಲ್ಲಿ ತನಕ ಬರುವಂತದ್ದು ಇದು ಇದೆ ಸರ್ ನಿಮಗೆ. ಅದಕ್ಕಾಗಿ ನಮ್ ಬರಕ್ ಆಗಿಲ್ಲ. ಈಗ ಲಾಸ್ಟ್ ತಿಂಗಳ ಇಲ್ಲ
ನೋಡ್ರಿ ಚಾಕ್ ಶೆಟ್ಟಿ ಅವರೇ,
Please, madam.
ಯೋಚನೆ ಮಾಡಿ.
Yes, madam.
He may also file an appeal now.
No, madam, she is educated, become passed, and he doing work also. She is working in one Nirmita Kendra and getting salary also, madam. And she having full, even though she not filed appeal, but madam, I have advised my client to pay something to the children. For that purpose, I have already instructed my client, madam. So far as this concerned, madam, that your lordship kindly it may be reduced or may be dismissed, madam. 10 lakhs rupees is ordered by the Honorable Family Court. Plus, against that order, I have approached this Honorable Court. Plus, because he is a driver, Lordship kindly consider his a hardship also and pass orders.
Please ask him, what is he, what has he thought, even thought of the daughter? And what has he done for her till now?
ನನ್ನ ಕಡೆ ಎಷ್ಟು ಸಾಧ್ಯ ಆಗುತ್ತೆ ಅಷ್ಟು ಕೊಡ್ತೇನೆ. ಈಗಂತೂ ನಾನು ಡ್ರೈವರ್ ಅದೇನಿ ಸರ್.
ನಿಮ್ ಮಗಳಿಗೆ ಏನ್ರಿ ಮಾಡಿದಿರ ನೀವು?
ಸರ್ ಈಗ ಸದ್ ನಾನು ಡ್ರೈವರ್ ಇರೋದೇ ನಾನು.
ಮಗಳಿಗೆ ಏನ್ ಮಾಡಿದಿರ ನೀವು ಇದುವರೆಗೂ?
ಸರ್ ಏನು ಇಲ್ಲ ಸರ್, ಅವ್ರ ಹತ್ರನೇ ಅದಾಳ ಸರ್. ನಾನು ಅವಾಗೆ ಕೇಳಿದೆ ಕೊಡಂತ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಮಗಳನ್ನ ಕೊಡುವಂತ ಕೇಳಿದಾರೆ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ನಾನೇ ಸಾಕ್ತೀನಿ ಕೊಡು ಅಂತ ಕೇಳಿದೆ ಕೊಟ್ಟಿಲ್ಲ ಸರ್. ಆದ್ರೆ ಮತ್ತೆ ಅವ್ರ ಹತ್ರನೇ ಇಟ್ಕೊಂಡ್ರು ಅವರೇ
ಸಾಕ್ತಾ ಇದಾರೆ ತಾನೆ?
ಅದೇ ಸರ್
ನೀವೇನ್ ಮಾಡಿದೀರಾ ಮಗಳಿಗೆ?
ಇಲ್ಲ ಸರ್, ನಾನ್ ಸಾಕ್ತೀನಿ ಕೊಡು ಅಂತ ಕೇಳಿದೆ ಸರ್.
ಅದ್ ಬಿಡ್ರಿ, ಅವ್ರ ಜವಾಬ್ದಾರಿ ತಗೊಂಡಿದ್ದಾರೆ, ಮಾಡ್ತಾ ಇದಾರೆ. ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ನಾನ್ ಡ್ರೈವರ್ ಅದೀನಿ ಸರ್. ನನ್ ಏನ್ ಅಷ್ಟು ಏನು ಇದನ್ನ ಅಮೌಂಟೇ ಬರಲ್ಲ ಸರ್ ನನಗೆ. ನನಗೂ ಹೆಲ್ತ್ ಇಶ್ಯೂ ಐತ್ರಿ, ನಮ್ಮ ತಾಯಿಗೂ ಹೆಲ್ತ್ ಇಶ್ಯೂ ಐತೆ.
ಮ್ಯಾರೇಜ್ ಆಗಿದ್ದಾರೆ ಸರ್. ಈಗ ಇಶ್ಯೂ ಕೇಳ್ತಾರಲ್ರಿ, ಈಗ ಸ್ಟೇಟ್ ತಗೊಂಡೋಗಿ ಮ್ಯಾರೇಜ್ ಆಗಿದ್ದಾರೆ ಸರ್. ಇದು ಯಾವ ಇದ್ರ ಮೇಲೆ ಮ್ಯಾರೇಜ್ ಆಗಿದ್ದಾರೆ ಸರ್? ಇಲ್ಲಿ
ಡೈವರ್ಸ್ ಆಗಿದೆ. ಡೈವರ್ಸ್ ಇಸ್ ನಾಟ್ ಕ್ವಶ್ಚನ್ಡ್. ಡೈವರ್ಸ್ ಇಸ್ ನಾಟ್ ಕ್ವಶ್ಚನ್ಡ್.
ಈಗ ಸಾಕಕ್ ಆಗಂಗಿಲ್ಲ ನಮಗ್ ಹೇಳ್ತಾರೆ. ಇನ್ನೊಂದ್ ಮ್ಯಾರೇಜ್ ಆಗಿತ್ತು, ಅವ್ರಿಗೆ ಹೆಂಗ್ ಸಾಕ್ತಾರೆ ಸರ್? ಅದು ಹೇಳ್ರಿ. ನಮ್ಗೆ ಹಿಂದೆ ಏನು ಸಪೋರ್ಟ್ ಇಲ್ಲ, ಏನೋ ದುಡ್ಡಿನ ಪ್ರಾಬ್ಲಮ್ ಅದ ಅಂತಂದ್ರೆ ನಾವು ಇಷ್ಟ ದಿನ ಬರಕ್ಕೆ.
You should have made some claim at least on behalf of the daughter. Why are you keeping quiet?
ಡಾಕ್ಟರ್ ಇದ್ದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಮಗು ಇದೆ ಅಂತ ಗೊತ್ತು. ಇವತ್ತು ಮಗು ಇದೆ ಅಂತ ಅಷ್ಟೇ ಗೊತ್ತಿತ್ತು. ಕರೆಕ್ಟ್ ಸರ್, ನಾನು ಮಗು ಇದೆ ಅಷ್ಟೇ ಗೊತ್ತು. ಇವತ್ತು ಅವ್ರ ತಾಯಿ ಕರ್ಕೊಂಬಂದ ನಾನು ನೋಡಿ ನಾನೇ ಆ ಫೀಲಿಂಗ್ ಆಗಿನಿ ಸರ್. ನಾನೇ ಆಕ್ಚುಲಿ ಫೀಲ್ ಆಗಿನಿ. ಮತ್ತೆ ಅವ್ರು ಹೇಳೋದೇನೇ ಇಲ್ಲ ಸರ್.
We will dismiss the appeal.
Please.
Worker. The appellant who had filed a petition under section 13 bracket 1 bracket B bracket 5 of the Hindu Marriage Act of 1955 seeking dissolution of the marriage between the parties herein has preferred this appeal aggrieved of the fact that while dissolving the marriage between the parties, the family court has directed the petitioner to pay rupees 10 lakhs as permanent alimony to the respondent. Full stop. Next para. The contention of the petition appellant is that he is working as a driver and he has no means to pay rupees 10 lakhs as permanent alimony to the respondent. Full stop. Having heard the learned counsels for some time on the previous occasion, we had directed that the parties be present before the court along with the daughter. Full stop. Today, both the parties are present before this court along with the daughter. Full stop. The ground on which the appellant sought for dissolution of the marriage was that the respondent suffered from HIV infection and other communicable diseases. Full stop. The respondent who is present before the court submits that from the time when such allegation was made against the respondent and medical reports were sought to be relied upon, she has not undergone any difficulty in life. Full stop. Even today, she is hale and healthy. Full stop. The respondent submits that if she had suffered from such serious disease which is communicable, then the child also would have suffered. Full stop. No such difficulty is faced by the child also. Full stop. On the other hand, it is alleged by the respondent that the allegations were only cooked up by the appellant, and immediately after the marriage was dissolved in terms of the judgment passed by the family court, he has remarried full stop. The appellant has not cared for the child and the respondent has been taking care of the child. ಎಷ್ಟು ವರ್ಷದಿಂದಮ್ಮ ಅವರು ದೂರ ಇರೋದು? 11 ವರ್ಷ ಆಯ್ತು. 11 ವರ್ಷ.
No, 2019 divorce ಅಲ್ಲಿ ತನಕ ಕೂಡಿ ಇದ್ದಾರೆ. 2019 order.
2017 MC case.
17. No, MC case is 2017. Order passed by the.
ಇದಕ್ಕಿಂತ ಮುಂಚೆ how from when they were away from each other?
ಎಷ್ಟು ದಿನ ಇದ್ರಿ ಕೂಡಿ? ಒಂದವರು ನಿಮಗೆ ಬಿಟ್ಟು ಹೋಗಿದ್ರು.
2013
11 years. 11 years.
Same thing.
ಆ ಮಗುಗೆ ಎಷ್ಟಮ್ಮ ವಯಸ್ಸು? 12. ಅಂದ್ರೆ 1 ವರ್ಷದಿಂದ ದೂರ ಇದ್ದಾರೆ.
But he has requested, he has requested to hand over the match.
Request. But what has he done for the child? Is it not his responsibility?
Yes, he is responsible.
Then, what has he done then?
But he has requested,
What request? Just because she has not sent her, it absolves him of all liabilities.
Not absolved. He is a responsible man.
That is why we are asking him, what has he done for the child? And you are aggrieved of this alimony.
So for that much, you will also pay the cost.
For 11 years now. Full stop. The respondent submits that the appellant has left the respondent and the child 11 years ago, when the child was only 1 year old. Full stop. It is submitted that the appellant has not cared to even find out as to how the respondent is able to manage the upbringing of the child. Full stop. It is submitted that till date, the appellant has not paid any amount.
I have paid 2,50,000. A pursuance of this. 2,50,000.
In respect of the child.
Please.
towards the health and education and the upbringing of the child. Full stop. Next para. For contra, the appellant seeks to contend that the respondent is well educated and she is working as
In Nirmita Kendram, getting salary of 2000 in the year 2011.
2000 per month.
Per month. Nirmita Kendram. That was only contention is taken.
ಈಗ ಕೆಲಸ ಮಾಡ್ತಾ ಇದೀರಾ ನಮ್ಗೆ ಏನ್ ಓದಿ
Private become that is
BCom.
yes.
ನೀವಿಬ್ರೇ ಇದ್ದೀರಾ ಈಗ ಇಬ್ರೇ ತಂದೆ ತಾಯಿ ಇದ್ದಾರ ಜೊತೆಗೆ
Just salary.
She was earlier working
Till today she is working.
in Nirmiti Kendra.
Yes.
Earning rupees 2000 per month. Full stop. Now she is working in a private
Private
establishment.
is getting salary of more than 12,000 as per the instruction of like.
Full stop. It is also submitted that the respondent is staying with her father.
Please.
Who is running a kirani shop. Full stop. Learned counsel for the appellant would submit that the family court should have taken into consideration the fact that the appellant is working as driver.
Please.
And he does not have the capacity to pay rupees 10 lakhs as permanent alimony to the respondent. Full stop. Moreover, the appellant is also remarried and he has a family to take care of.
Mother and old age.
Next para. We have heard the learned counsels on both the sides and we have interacted with the parties who are present before the court. Full stop. Having personally interacted with the parties and having found that the appellant has not taken care of the child, let alone the respondent for the last 11 years and no efforts have been made by the appellant to at least lend a supporting hand to the respondent for taking care of the child, we do not have any sympathy towards the appellant. Full stop. The fact that the appellant has remarried immediately after the judgment was passed by the family court goes to show that
1 year after this 1 year yet marriage.
Goes to show the intention of the appellant. Full stop. Nevertheless, since the respondent has not filed any cross objections to the impugned judgment, insofar as the dissolution of the marriage is concerned, but she has expressed her intention to seek enhancement of the permanent alimony granted by the family court, we have considered the submissions made on behalf of both the parties insofar as the grant of permanent alimony is concerned. Full stop. Taking a overall view of the facts narrated as herein above, comma, we are of the considered opinion that the permanent alimony granted by the family code is not too exorbitant. Full stop. Next para. Consequently, the appeal stands dismissed.
Much.
Babu H. Metagudda.
Claimant, case of death, claimant appeal for enhancement. Case of death, claimant appeal for enhancement. Date of accident of 2017, as per local chat, 10,250 bar.
Coming up for admission.
Admission, only quantum is disposed. Some calculation ಮಾಡಿದೀವಿ sir.
Ready?
ಅವ್ರಿಗೆ ತೋರಿಸಿದೀನಿ calculation.
Ready.
ಹೇಳಿ.
10,250 ಬರತ್ತಾ 7,000 ತಗೊಂಡಿದ್ದಾರೆ.
Injury case.
ಈ ಡೆತ್ ಕೇಸ್ ಮೇಲೆ ಇನ್ಕಮ್
Case.
ಡೆತ್ ಕೇಸ್ ಮೇಲೆ ಇನ್ಕಮ್ ಮಿಲಾಡ್ 7,000 ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 10,250. 10,000
ಚಾರ್ಟ್.
as per ಲೋಕದಲ್ಲಿ ಚಾರ್ಟ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಂಡ್ ಮಿಲಾಡ್ to 25% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಬರತ್ತೆ ಮಿಲಾಡ್ ತಗೊಂಡಿಲ್ಲ. ಓನ್ಲಿ 2 ಗ್ರೌಂಡ್ಸ್.
10,250.
250. Plus 25% future pass.
$25% was to be deducted towards expenses.
ಇಲ್ಲ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಆಡ್ ಮಾಡ್ಬೋದು.
Add. Addition. One third deduction.
1/3. And plus 40,000, 40,000, 80,000 conventional rates. Plus 30,000. And medical bill 11,000 ಇದೆ ಸ್ವಾಮಿ as it is. Total 14,53,000 ಬರುತ್ತೆ. Lords.
Increase 10% increase 2017 ಇದು.
ಆಯ್ತು ಸರ್.
ಅದೇ ಬರಲ್ಲ 80,000 ಅಷ್ಟೇ.
ಆಯ್ತು ಅಷ್ಟೇ ಇಲ್ಲ.
17 ಇಂದ 2020 MEC ಆದ್ರೆ 10% ಆಡ್ ಆಗುತ್ತೆ.
ಆಯ್ತು ಸರ್.
80,000.
ಆಯ್ತು ಅಷ್ಟೇ ಕೇಳ್ತಾ ಇತ್ತು.
ಇದು
80 plus 30 plus 11,000. Medical bill. Medical bill as it is. Total 14,53,500 ಬರುತ್ತೆ ಸ್ವಾಮಿ. After deduction 6,44,448.
ಆಗ್ಬೋದಾ? Disposed of accordingly. ಇದೇ ಚೇಂಜ್ ಅಷ್ಟೇ. 88 ಬದಲು 80,000 ಅದು.
80,000 plus 30%, 30,000 plus 11.
Serial number 34 SS Aspalli.
I am for the respondents, paper time.
At the request of learned counsel for the respondent, just release this matter
Next week or
on 14th of November.
Serial number 35 Narendra Reddy, Manvendra Reddy.
Matter pertains to the excess land utilized by the state authorities, my lords, after acquisition, my lords. So, on last date of hearing, my lords, the honorable court had observed and directed the respondents to secure instructions, my lords. And also in connected matters, my lords, the
Government.
Additional government advocate, 1 to 4.
Pass over.
Please.
Bill number 36. Sachinam Mahajan.
Here, the matter and Mulad, I had made a submission that I'll be personally visiting the place and Mulad making submissions. What has happened is Mulad, decades ago, Mulad, there was a allotment letter issued to a lady by name Shobha. After Mulad, more than 1.5 decade, Mulad, she sells to one Basavaraj, and from that Basavaraj, Mulad, after almost 17, 18 years, Mulad, looking at the fact, Mulad, that the Tahsildar has issued the letter of allotment, I purchased the property, I put up construction. That there are Mulad, several rounds of writ petition. The last round of writ petition, Mulad, this Mulad Honorable Court, learned single judge of this Honorable Court was pleased to issue direction to dispose of the matter by the Deputy Commissioner. Taking into consideration, Mulad, since so much time has elapsed, whether it will be proper on the part of the Deputy Commissioner to now cancel the Hakkupatra. That was, Mulad, the realm of Mulad inquiry that was to be conducted by the Deputy Commissioner. Deputy Commissioner exceeded his brief, Mulad, and he brought the angle, Mulad, of encroachment, which, Mulad, was not the part and parcel of the earlier round of litigation. Nevertheless, Mulad, there was a report which was filed. Now, before this Honorable Court, Mulad, there was a direction to file the report. I have personally visited the spot, Mulad, and I see, Mulad, that the construction is confined to 30 into 40. However, Mulad, in the light of the fact, Mulad, of there being a report and there being a contravention to that report, this gets into the area of, Mulad, disputed question of facts. My respectful submission, Mulad, would be that I may be permitted to place my objections to the Commissioner's report. At the same time, Mulad, I may be permitted to go and approach the civil court and establish, Mulad, my rights before the. Iga idralli, the peculiar circumstances, Mulad, this is a corner site. Your Lordship, Mulad, will find this. The photographs of the property.
Filed the writ petition.
I filed the writ petition.
For what?
Deputy Commissioner, Mulad, had passed the order in the proceedings, holding that, Mulad, I am an encroacher, when, Mulad, the scope of inquiry was whether the Hakkupatra is proper or not. It is in that regard, Mulad, the learned single judge was pleased to dispose of the writ petition, directing me to go to the civil court. I was on the line, Mulad, that the direction in the earlier round of writ petition was altogether different. The Deputy Commissioner could not have gone into all these areas.
The challenge, which order?
Mulad, I am referring to the earlier order in the writ petition. It is, Mulad, at page number 104, Mulad, WP number 82199 of 2010. A detailed order was passed, Mulad. It starts at page number 104. If I mean,
What is that annexure A dated 27/4/2010?
in that, Mulad, Hakkupatra was cancelled.
Where is that?
The
Hakkupatra.
Hakkupatra was cancelled by the Deputy Commissioner. That was challenged in the writ petition.
Hakkupatra, that was
initially given to Shobhavati. Thereafter, Mulad, almost 1.5 decades after that, Mulad, Shobhavati sells to Basavaraj. About 2 years after that, Mulad, I purchase. What I see, Mulad, is the long-standing entries, undisputed, Mulad, for a very long period of time. And I believe the Hakkupatra issued by the Tahsildar and purchased the property. It is not, Mulad, as though overnight some document is created and immediately, Mulad, the property has changed hands. That is not the case, Mulad. The page number 110.
Even at that point of time,
please, Mulad.
This Sriniwas is respondent number 5.
Please.
Why?
He was, because, Mulad, it was on his complaint, Mulad, this was done.
What was his complaint?
His complaint, Mulad, that my Hakkupatra is not proper and correct. And, Mulad, Deputy Commissioner, in fact, Mulad, on the basis
Allotment was made to him
Yes,
also.
allotment was made to him also. He was a rival claimant.
Ah.
Now, his Hakkupatra was cancelled by the Deputy Commissioner. He did not challenge it.
Ah.
It was the petitioner alone who challenged, Mulad, and, Mulad, the order was set aside.
Both the Hakkupatras were
Both the Hakkupatras were cancelled.
cancelled.
Yes.
Why?
My Hakkupatra was cancelled on the ground, Mulad, that the original grantee, she was not a beneficiary. But subsequently, my lord, inquiry was conducted. There was, my lord,
She was allotted more than one shop.
fortunately, this happened to be the first allotment.
So the
All
subsequent,
subsequent allotments, my lord, if they are, they have to go, my lord.
if liable to
Yes.
be cancelled,
The subsequent.
those subsequent
Yes, yes,
allotments
yes,
that are to be
yes.
cancelled.
Now, in the light of that, my
What
lord,
about this Srinivas?
Srinivas's allotment, my lord, was cancelled. He never challenges that.
Why it was cancelled?
It was cancelled, my lord, because holding that, my lord, the manner in which it is done and the Hakupatra itself, my lord, was held to be illegal. Page 110, if I may invite your lordship's attention.
Is there any overlapping of the allotment?
He claims, my lord, there is overlapping. But now decades for decades,
We
my
are
lord,
the municipality, my lord. Contesting party is Srinivas.
Huh?
Contesting
Andre,
party.
you are the municipality, isn't it?
Please, my lord.
The orders are passed by whom?
order is passed by the deputy commissioner.
Deputy commissioner.
Deputy commissioner.
Chief
Under which
officer,
provision?
chief
Under which
officer has
provision?
passed this order.
Which order, my lord?
Chief officer, municipality, annexure W.
Well, the subject matter is before this honorable court by challenging the order of the deputy
Pursuant to
commissioner.
the order of the deputy commissioner, my lord,
He is complied the order of deputy commissioner, my lord.
Huh?
Chief officer is complied the order of deputy commissioner, my lord. Original order is passed by the deputy commissioner, my lord. That was subject matter of writ petition, my lord. In writ petition is dismissed on the ground that there is a disputed facts, my lord. For that reason, directed the petitioner to approach to the civil court. By challenging that order, my lord, petitioner is before this honorable court, my lord.
Page number 110 onwards, my lord, there will be clarity because there is a lengthy discussion, my lord, as to what all happened in the earlier rounds. If I may, my lord. Para 3 of the earlier writ petition, my lord.
No, you please read paragraph number 11.
Paragraph number 11 in the present writ petition, my lord. Please.
Page 116.
116, my lord. The authorities are required to examine whether the allotment made in favor of the respondent number 3 in the year 1988 can be revoked at this stage. Respondent number 3, my lord, is my vendor's vendor. Yes.
Yes.
At this stage. In the present case on hand, the court is of the view that action is grossly delayed and the action is said to be initiated beyond reasonable time, particularly for the fact that allotted plot was transferred several times during this period. Obviously, in the faith that it is not encumbered by any rights, the authorities are required to take action within reasonable time, and the time must be reckoned reasonably, not only in order to preserve rights and advantage of party possessors, but equally to protect each party from the losses he ought not to suffer. Thus, when the action is sought to be taken after inordinate delay, it has to be examined from the point of view of the party who might suffer losses, though he is not directly responsible, warranting action. However, the family of the third respondent is entitled for allotment of one plot, and the material placed by the Tahsildar indicates that there are other 3 plots which are allotted. In this background, the second respondent, deputy commissioner, is required to examine whether the plot number 4, which is allotted to in the year 1988, can be taken as an allotment under the scheme, and thereafter take appropriate action in respect of these plots, which are secured by third respondent's family. All these aspects of, are to be examined by the second respondent deputy commissioner, bearing in mind the third party's rights are created, and after securing the permission from the competent authority, the petitioner has put up construction. The second respondent deputy commissioner requires to redo by holding a fresh inquiry by issuing notice to all the interested parties and take appropriate action thereon. Now, my lord, the scope of inquiry is this: whether a long-standing, my lord, Hakupatra.
What happened after this order?
Now, the deputy commissioner, my lord, he altogether changes the course of the inquiry itself. He goes into the aspect of the alleged encroachment. The order of the deputy commissioner, my lord, is at annexure V, my lord, page number 143. This is the impugned order.
You do not dispute the fact that the deputy commissioner is the competent authority?
Deputy commissioner, my lord, right or wrong, my lord, he is holding the inquiry.
Wrong. Have you raised a challenge?
At the first instance, my lord, yes.
Powers.
Yes, and in the first round of writ petition, my lord, when the Hakupatra was cancelled, I had, my lord, raised the objection on the ground, my lord, that the deputy commissioner has passed the order invoking section 192A, holding that, my lord, I am the illegal encroacher. My lord, that
192A of the
Karnataka Land
Municipalities
Revenue
Act.
Act, my lord.
Land Revenue Act.
Land Revenue Act, where my lord, the action is,
Revenue Act.
where the action is,
Land Revenue Act.
Revenue Act ಅಲ್ಲಿ ಮಾಡಿದ.
ಹೆಂಗ್ರಿ
where
ಬರುತ್ತೆ?
action is to be taken against the encroacher, my lord.
Huh? No. These are shops allotted by the municipality, isn't it?
No,
This-
my lord.
Huh?
By the Karnataka Niravari Nigam.
No, Tahsildar had
The land losers.
the
Through
Tahsildar
Tahsildar,
issued
my lord.
certificate.
Karnataka Neeravari
Nigam is allotted the sites to the land losers through the Tahsildar, my lord, who is the competent authority.
Project displaced persons.
Yes, ma'am.
I'm sorry, my lord, I stand corrected, section 94, my lord,
94 of
the Karnataka Land Revenue Act.
land.
Unauthorized occupation ಅಂತ Land Revenue Act 94 ಅಲ್ಲಿ initiate ಮಾಡಿದ್ರು. The first round of my lord order was passed invoking section 94. I took an exception, my lord, and approached this honorable court stating that this is on the basis of an allotment. And my lord, it cannot be brought under the purview of my lord section 94, which deals with my lord the matter of unauthorized occupation. Writ petition came to be disposed of, matter was sent back.
Yes, Mr. Government Advocate.
Page 76, my lord.
How can he invoke section 94 of the Karnataka Land Revenue Act? Please see the provision.
Lecture V, my lord, report order.
Huh?
94, my lord. Under the
94.
occupant of land, any person who shall unauthorizedly
Unauthorizedly enter upon,
occupation of any land set
set apart for any special purpose or any unoccupied land.
which has not
See, it talks of unauthorized entry. Admittedly, this is not unauthorized entry. It was an allotment made in favor of the third respondent. Isn't it? It's an allotment made in favor of third respondent. Thereafter, two hands have changed. This person has purchased the property under a sale deed. So therefore, how can the deputy commissioner invoke section 94?
that is, my lord, false, my lord, statement made before the authority
Please
regarding.
read the provision. It does not talk of that one. Please read the provision.
Yes, my lord, that is not been alienated and any person who uses or occupies any such land to the use or occupations of
Who is
which
not entitled or has ceased to be entitled
shall
shall
pay.
pay twice the amount. That's the penalty. Primarily, this is not the provision that could be invoked by the deputy commissioner.
My lord, we'll get the instruction, my lord, get the records, my lord, whether my lord.
Who is you are appearing for that Srinivas? Huh?
Karnataka Neeravari.
94?
ಅದನ್ನೇ
Four features under this section be adjudged by deputy commissioner and any property so forfeited shall be disposed of. Four feature ಹೆಂಗ್ ಬರುತ್ತೆ? ಬರೋದಿಲ್ಲ. This provision can be invoked only if there is unauthorized occupation.
Yes, my lord, that's.
Or if action was taken in accordance with law
The PPR.
after allotment for contravention of any condition, then forfeiture order.
True.
This is not a case where this provision could be invoked at all.
My lord, this is, my lord, the order is passed, my lord, regarding encroachment only, my lord, page number 145, my lord. Page number 145.
Because as we said, it has now shifted to the neighboring property.
That is the malad direction, even malad this on.
ಯಾರ್ದು ಪ್ರಾಪರ್ಟಿ ಅದು?
It is state malad. ಅಧಿಕಾರಿಗಳು ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ.
ಎಲ್ಲಿ where are you reading?
That is malad. Report is also filed malad. Report is also filed by the municipality.
Report
145 malad filed.
145 was initiated. I was held to be in possession of the property.
Or 145 malad. Before that malad, last para will start malad. ಪ್ರಸ್ತುತ 144 malad. ಪ್ರಸ್ತುತ ಮರು ವಿಚಾರಣೆಯಲ್ಲಿ ಪ್ರತಿವಾದಿ ಮೂರರವರ ನಿವೇಶನಗಳನ್ನು ಅತಿಕ್ರಮಣವಾಗಿರುವುದರ ಸಂಬಂಧ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಹುಮ್ನಾಬಾದ್ ತಹಸೀಲ್ದಾರ್ ಹುಮ್ನಾಬಾದ್ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರಿ ಕನನಿ ಬಿದರ್ ಮತ್ತು ಸಹಾಯಕ ಆಯುಕ್ತರು ಬಸವ ಕಲ್ಯಾಣ ಒಂದು ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ವರದಿಯನ್ನು ಪಡೆಯಲಾಗಿ ಸದರಿ ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ವರದಿಯಲ್ಲಿ ಸದರಿ ನಿವೇಶನ ಲೇಔಟ್ ನಕಾಶೆ ಪ್ರಕಾರ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸಲಾಗಿರುತ್ತದೆ. ಇದಕ್ಕೆ ಯಾವುದೇ ನಿವೇಶನ ಸಂಖ್ಯೆ ಇರುವುದಿಲ್ಲ. ಕಾರಣ ಸದರಿ ನಿವೇಶನದ ಅನಧಿಕೃತವಾಗಿ ಒತ್ತಾಯವಾಗಿರುತ್ತದೆ ಎಂದು ಜಂಟಿಯಾಗಿ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ ಎಂದು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಜಂಟಿ ಸ್ಥಳ ತನಿಖಾ ವರದಿ ದಿನಾಂಕ 15/11/2023 ಅನ್ವಯ ಪ್ರತಿವಾದಿ ಮೂರರವರ ನಿವೇಶನದಲ್ಲಿ ಅತಿಕ್ರಮಣ ಮಾಡಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಸದರಿ ಅತಿಕ್ರಮಣವನ್ನು ತೆರವುಗೊಳಿಸುವ ಸಂಬಂಧ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶ. ಪೀಠಿಕೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಗಳಲ್ಲಿ ಅಧಿಕಾರಿಗಳ ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ವರದಿ ಅನ್ವಯ ಶ್ರೀಮತಿ ಸರಸ್ವತಿರವರು ಶ್ರೀ ಶ್ರೀನಿವಾಸ್ ರವರಿಗೆ ಹಂಚಿಕೆಯಾದ ನಿವೇಶನದಲ್ಲಿ ಅತಿಕ್ರಮಣ ಮಾಡಿರುತ್ತಾರೆ. ಕಾರಣ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ. This is substituted by the.
Please read the first paragraph of that order.
First paragraph.
First paragraph.
Please. ಹುಮ್ನಾಬಾದ್ ತಾಲೂಕಿನ ಹಳ್ಳಿಕೇಡ್ ಗ್ರಾಮದ ಭೂ ಸರ್ವೆ ನಂಬರ್ 7 ಮತ್ತು 8ರಲ್ಲಿ ಕಾರಂಜ ಯೋಜನೆಯಡಿಯಲ್ಲಿ ಮುಳುಗಡೆಯಾದ ಗ್ರಾಮಗಳೆಲ್ಲ ಪೂರೈಸುವುದಕ್ಕಾಗಿ ಮನೆ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದ್ದು ಸದರಿ ನಿವೇಶನ ಸಂಖ್ಯೆ 4 ಶ್ರೀಮತಿ ಶೋಭಾ ಅವರಿಗೆ ಮಾಡಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿದ್ದು ಹಾಗೂ ಸದರಿ ನಿವೇಶನ ಪಡೆಯಲು ಅರ್ಹ ಫಲಾನುಭವಿಗಳಾದ ಪ್ರತಿವಾದಿ 3ರವರಿಗೆ ಹಂಚಿಕೆಯಾದ ನಿವೇಶನದಲ್ಲಿ ಅತಿಕ್ರಮಣ ಮಾಡಿರುವುದರಿಂದ ಸದರಿ ಪ್ರತಿವಾದಿ 1ರವರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಲಾದ ನಿವೇಶನವು ಕಾನೂನು ಬಾಹಿರವಾಗಿರುವುದರಿಂದ ಸದರಿ ನಿವೇಶನವನ್ನು ರದ್ದುಪಡಿಸಲು ದಿನಾಂಕ 16/12/2006 ದೂರು ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದಕ್ಕೆ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸದರಿ ದೂರು ಅರ್ಜಿಯ ಕುರಿತು ವಿಚಾರಣೆ ಮಾಡಲಾಗಿ ಪ್ರತಿವಾದಿ 1ರವರ ಹೆಸರಿನಲ್ಲಿ ದಿನಾಂಕ 2/8/88 ಹಕ್ಕುಪತ್ರ ಮತ್ತು ಪ್ರತಿವಾದಿ 3ರವರಿಗೆ ದಿನಾಂಕ 8/9/2004 ನೀಡಲಾದ ನಿವೇಶನಗಳನ್ನು ರದ್ದುಪಡಿಸಿ ಈ ನ್ಯಾಯಾಲಯದಿಂದ ಆದೇಶ ಸಂಖ್ಯೆ 27/4/2010 ಆದೇಶ ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಈ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ವಿರುದ್ಧ ಪರಿಷ್ಕರಣಾ ಅರ್ಜಿಗಳು ಅಂದರೆ ಶ್ರೀಮತಿ ಸರಸ್ವತಿರವರು ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ WP ರಂತೆ ಪ್ರಕರಣ ದಾಖಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 3/2/2020 ಆದೇಶದಲ್ಲಿ ಪ್ರಕರಣವನ್ನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹೊಸದಾಗಿ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಮರು ವಿಚಾರಣೆ ಮಾಡಿ ಆದೇಶ ಹೊರಡಿಸಲು ನಿರ್ದೇಶನ ನೀಡಲಾಗಿರುತ್ತದೆ. ಕಾರಣ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನೋಟಿಸ್ಗಳನ್ನು ಜಾರಿ ಮಾಡಿ ಅವುಗಳನ್ನು ಶಾಮೀಲು ಮಾಡಿ ಎಲ್ಲಾ ಪಕ್ಷಕಾರರಿಗೆ ಅಥವಾ ಪಕ್ಷವನ್ನು ಸಮರ್ಥಿಸಿಕೊಳ್ಳಲು ಸಾಕಷ್ಟು ಸಮವಕಾಶಗಳನ್ನು ನೀಡಿ ಪ್ರಕರಣವನ್ನು ಆದೇಶಕ್ಕಾಗಿ ಮುಂದೂಡಲಾಯಿತು. ಪರಿಷ್ಕರಣಾ ಅರ್ಜಿದಾರರಂತೆ ಶ್ರೀಮತಿ ಸರಸ್ವತಿ ಪರವಾಗಿ ನ್ಯಾಯಾಲಯವಾದಿಗಳು ಹಾಜರಾಗಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ದಿನಾಂಕ 3/2/2020 ನೀಡಲಾದ ನೋಟಿಸ್ಗೆ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಶ್ರೀಮತಿ ಸರಸ್ವತಿರವರು ಸರ್ವೆ ನಂಬರ್ 7 ಮತ್ತು 8ರಲ್ಲಿನ ಪುನರ್ವಸತಿ ಕೇಂದ್ರದಲ್ಲಿ ಪ್ರತಿವಾದಿ 1ರವರಿಗೆ ಅವರ ಕೃಷಿ ಜಮೀನು ಭೂ ಸ್ವಾಧೀನವಾಗಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅವರಿಗೆ ದಿನಾಂಕ 2/8/88 ನಿವೇಶನ 4ಕ್ಕೆ ಸಂಬಂಧಿಸಿ ನೀಡಲಾದ ಹಕ್ಕುಪತ್ರದ ಆಧಾರದ ಮೇರೆಗೆ ಸದರಿ ಶ್ರೀಮತಿ ಶೋಭಾರವರು ಮಾಲೀಕತ್ವ ಪಡೆದಿರುವುದರಿಂದ ಶ್ರೀಮತಿ ಸರಸ್ವತಿರವರು ನಿವೇಶನವನ್ನು ನೋಂದಾಯಿತ ಕ್ರಯ ಸಂಖ್ಯೆ ದಿನಾಂಕ 1/9/2005 ಖರೀದಿ ಪತ್ರ 2ರಿಂದ ಖರೀದಿ ಮಾಡಿದ್ದಕ್ಕೆ ಸದರಿ ನಿವೇಶನ ಮಾಲಕರಾಗಿರುತ್ತಾರೆ ಎಂದು ಸಲ್ಲಿಸುತ್ತಾ ಪ್ರತಿವಾದಿ 1ರವರು ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಗಳಲ್ಲಿ ನೀಡಲಾದ ನೋಟಿಸು ಮತ್ತು ಐತೀರ್ಪು ಸಹ ಆಗಿರುತ್ತದೆ ಎಂದು ಸಲ್ಲಿಸುತ್ತಾ ಸದರಿ ಪ್ರತಿವಾದಿಗಳಿಗೆ ನೀಡಲಾದ ಹಕ್ಕುಪತ್ರವು 22 ವರ್ಷಗಳ ನಂತರ ರದ್ದುಪಡಿಸುವುದು ಕಾನೂನು ಬಾಹಿರವುದರಿಂದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಸದರಿ ಆದೇಶ ರದ್ದುಪಡಿಸಿರುತ್ತದೆ. ಪ್ರತಿವಾದಿ 3ರವರಂತೆ ಪ್ರತಿವಾದಿ 3ರು ಪರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣೆ ಹಾಜರಾಗಿ ಪ್ರಕರಣ ಸಂಬಂಧಿಸಿದಂತೆ ಲಿಖಿತವಾದ ಮಂಡನೆಯನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಅರ್ಜಿದಾರರು ಸದರಿ ಕಾರಂಜ ಯೋಜನೆಯಲ್ಲಿ ಅವರ ಜಮೀನು ಕಳೆದುಕೊಂಡಿರುವುದು ಸಹ ಅವರಿಗೆ ನಿವೇಶನವನ್ನು ಹಂಚಿಕೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಕಾರಣ ಸದರಿ ನಿವೇಶನದ ಹಂಚಿಕೆಗಾಗಿ ಸಲ್ಲಿಸಿದ ಮನವಿಗೆ ಸ್ಪಂದಿಸದ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರರು ಕಾರಂಜ ಯೋಜನೆರವರು 30-40 ವಿಸ್ತೀರ್ಣ ನಿವೇಶನವನ್ನು ಹಂಚು ಮಾಡಿದ್ದು ಸದರಿ ಹಂಚಿಕೆಯನ್ವಯ ತಹಸೀಲ್ದಾರರು ಹುಮನಾಬಾದ್ ರವರು ದಿನಾಂಕ 8/9/2004 ಹಕ್ಕುಪತ್ರವನ್ನು ಒದಗಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಹಕ್ಕುಪತ್ರದ ಆಧಾರದ ಮೇರೆಗೆ ಎಸ್ ಶ್ರೀನಿವಾಸ್ ರವರಿಗೆ ಹಂಚಿಕೆಯಾದ ನಿವೇಶನದ ಕಬ್ಜೆಯನ್ನು ಪಡೆಯಲು ಹೋದಾಗ ಸದರಿ ನಿವೇಶನದಲ್ಲಿ ಪ್ರಸ್ತುತ ಪರಿಷ್ಕರಣ ಅರ್ಜಿದಾರರು ಕಾನೂನುಬಾಹಿರವಾಗಿ ತನ್ನ ನಿವೇಶನದಲ್ಲಿ ಅನಧಿಕೃತವಾಗಿ ಅತಿಕ್ರಮಣ ಮಾಡಿರುತ್ತಾರೆ. ಕಾರಣ, ನಾನು ಈ ಹಿಂದೆ ಸದರಿಯವರ ಹಂಚಿಕೆ ಬಗ್ಗೆ ಹಿಂದಿನ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ದೂರು ಸಲ್ಲಿಸುವುದಕ್ಕೆ ಸದರಿ ದೂರು ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿ ಅವರ ಹಂಚಿಕೆಯನ್ನು ರದ್ದುಪಡಿಸಿರುವುದು ಕಾನೂನಾತ್ಮಕವಾಗಿ ಕ್ರಮವಾಗಿರುತ್ತದೆ. ಸದರಿ ಕಡತಗಳಲ್ಲಿ ಇತರ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಪರಿಷ್ಕರಣಾ ಅರ್ಜಿದಾರರಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಕಾರಂಜ ಯೋಜನೆ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕರಣ ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆ 1994 ಕಲಂ 1 ಮತ್ತು 6 ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಶ್ರೀಮತಿ ಶೋಭಾ ತಂದೆ ದೊಂಡಿಬಾಯಿ ಇವರು ಮನೆ ಮುಳುಗಡೆಯಾಗಿರುವುದಿಲ್ಲ. ಆದಾಗ್ಯೂ ಕೂಡ ಇವರು ಸುಳ್ಳು ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ಸದರಿಯವರ ಮನೆಯ ಕಾರಂಜ ಯೋಜನೆಯಲ್ಲಿಯ ಮುಳುಗಡೆಯಾಗಿದೆ ಎಂದು ಸದರಿ ಶೋಭಾರವರಿಗೆ ಕಾಯ್ದೆ ಬಾಹಿರವಾಗಿ ದಾಕುಳಿಕಿ ಗ್ರಾಮದ ಪ್ಲಾಟ್ ನಂಬರ್ 4 ದಿನಾಂಕ 2/8/88 ಹಕ್ಕುಪತ್ರ ಮಂಜರಿಸಿ ವಿತರಿಸುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಮರು ವಿಚಾರಣೆಯಲ್ಲಿ ಪ್ರತಿವಾದಿ 2ರವರ ನಿವೇಶನವನ್ನು ಅತಿಕ್ರಮಣವಾಗಿರುವುದು ಸಂಬಂಧ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಹುಮನಾಬಾದ್ ಎಲ್ಲ ಜನರು ಒತ್ತುವರಿಯಾಗಿದೆ ಎಂದು ಜಂಟಿಯಾಗಿ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ಕಂಡುಬರುತ್ತದೆ ಎಂದು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ವರದಿ ದಿನಾಂಕ 15/11/2023 ಪ್ರತಿವಾದ 3ರವರ ನಿವೇಶನ ಅತಿಕ್ರಮಣ ಮಾಡಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುವುದು ಈ ಕೆಳಗಿನಂತ ಆದೇಶ.
Yes.
We are only directed to.
This is the subject.
Now it is only concerning the property by the side of your allotted property.
Yes.
If you have encroached upon that one,
Yes.
kindly remove the encroachment.
My lord, kindly see, my lord, page number 76, my lord. I may invite your lordship's attention to page number 76.
Yes. Yes.
Order. This is the order passed by the Deputy Commissioner in the earlier round, 27/4/2010. In view of the facts mentioned in the preamble, in exercise of the power conferred upon me under section 94 of the Karnataka Land Union Act, I, Harsh Gupta, so and so, by hereby cancel the following Hakkupatras. The Hakkupatra dated.
That order has been set aside.
Both the Hakkupatras were
That
cancelled.
order has been set aside now.
Yes. Now it was, my lord, at
Only concerning the property by the side of your property.
yes, my lord.
Yes.
The question,
I am
To admit that there is encroachment, kindly remove it.
Your
in
lordship,
that
kindly
extent,
for-
my lord, last date of hearing, this honorable court directed me to ascertain the actual facts, my lord. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, respondent ಗೆ I have received instruction, my lord. Respondent Srinivas ಗೆ allot ಆಗಿರೋದೇ only 13/40.
Correct.
13/13/40. Entire 13/40 is encroached by the petitioner ಅಂತ survey ಅಲ್ಲಿ report ಬಂದೆ ಸ್ವಾಮಿ. Even before the deputy commissioner also, it is very clearly stated that petitioner was encroached the entire 13/40. Based on the direction of this honorable court, respondent authorities were conducted and Scott Panchnama, where also it is clearly stated that 13/40, that was corner site allotted to the 6th respondent. Entire property was encroached. That is
Now-
the report submitted by the
First photograph your lordship will peruse.
Yes.
That is, my lord, a corner site.
Yes.
On the northern side and, my lord, on the,
Is your property a corner site?
my lord, it's a corner site.
Your property?
Yes,
Your property?
yes, my lord.
Please
That
show.
is where, my lord, the construction is put up.
So,
Kindly see the other two photographs also, my lord. I'll kindly explain.
let us see your document.
Yes, see one. Property sold is
48, 49.
Where is the sale deed?
My lord, Hakkupatra is at page number 48, my lord. The typed copy 49. ಪೂರ್ವಕ್ಕೆ 1, ಉತ್ತರ 3, ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ, ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ.
ಏನಿದು ಉದ್ದ ಅಗಲ, it is in the feet or what is it?
ಇದು in the original thing, my lord, it is not mentioned. ಗಡಿಗಳು 24/15.
58.
It is neither feet nor meter, my lord.
ನಿಮ್ಮ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ 30 into 40 feet ಅಂತ
Feet ಅಂತ ತೋರಿಸಿ.
30 into 40 feet.
40 feet.
ಹಾ
Please, my lord.
ಕಾರ್ನರ್ ಸೈಡ್.
ಇಲ್ಲ ಕಾರ್ನರ್ ಇಲ್ಲ ಸ್ವಾಮಿ. It is plot number 4. It is plot number 4 allotted to the petitioner. ಕಾರ್ನರ್ ಸೈಟ್ ಗೆ ನಂಬರೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಎರಡು ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ. ಡೆಪ್ಟಿ
ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 48 ಸರ್, ಹಕ್ಕುಪತ್ರ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ಈಸ್ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್ ಪಶ್ಚಿಮ ಮತ್ತೆ ದಕ್ಷಿಣ ಎರಡ್ ಕಡೆ ರಸ್ತೆ ಇದೆ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
Then you are saying no, not corner side.
ಆಸ್ ಪರ್ ನನಗೆ ಇಲ್ಲಿ ಮ್ಯಾಪ್
ಹಕ್ಕುಪತ್ರ ನೋಡಿ ದಯವಿಟ್ಟು.
ಪಶ್ಚಿಮ ದಕ್ಷಿಣ
ಎರಡ್ ಕಡೆ ರಸ್ತೆ ಇದೆ.
ಒಂದು ಮೈ ಲಾರ್ಡ್
ಪೂರ್ವಕ್ಕೆ
ಸೈಟ್
ನಂಬರ್
ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ 1, ಉತ್ತರಕ್ಕೆ ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ 3, ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೂ ಸೇಮ್ ಇದೆ.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೂ ಸೇಮ್ ಇದೆ.
Now, your lordship sees the other two photographs. Immediately after my building, my lord, there are two property which are already constructed. Now my construction is within the limits of 30 into 40. I have, my lord, personally gone there and measured with the tape. And immediately thereafter, my lord, there is property of others. I do not know, my lord, where this property of the respondent number 3, my lord, is going to be fit into that area. That is, my lord, an area of concern. As your lordships observed, the
What type of a report is this?
ಅಲ್ಲ ಫಾರ್ ದಟ್ ರೀಸನ್ ಓನ್ಲಿ ಐ ರಿಸೀವ್ಡ್.
ಸಾಕೇನ್ರಿ?
ಅದನ್ನ ಪ್ರಾಪರ್ ಆಗಿ ಅದನ್ನ ಆಗಿಲ್ಲ.
Can you make out?
ಅದನ್ನ ಪ್ರಾಪರ್ ಆಗಿ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಆಲ್ಸೋ ಐ ಮೇಡ್ ಸಬ್ಮಿಷನ್.
Then what is the ground on which you are trying to take this action?
ಅಲ್ಲಿ ಓನ್ಲಿ 13 into 40 ಎನ್ಕ್ರೋಚ್ಡ್ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. ಎಲ್ಲಿಂದ ಎಲ್ಲಿ
ಅವ್ರದ್ದು 30-40 ಸೈಟ್ ರೀ, ಕಾರ್ನರ್ ಸೈಟ್.
ನಾನು ಈಗ ಬೆಳಗ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಈವನ್ ಟುಡೇ ಮಾರ್ನಿಂಗ್
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬಿಟ್ಬಿಡಿ, ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ಇಲ್ಲಿ.
ಅವ್ರು ಒಂದು ಮ್ಯಾಪ್ ತೋರಿಸಿ.
They are wrongly instructed. ಇವರು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅಷ್ಟೇ. ಐ ಡೋಂಟ್ ಥಿಂಕ್ ಯು ವುಡ್ ಹ್ಯಾವ್ ಗಾನ್ ಟು ದಿ ಸ್ಪಾಟ್. ಆಫೀಸಲ್ಲಿ ಕುತ್ಕೊಂಡ್ ಬರ್ದಿರೋ ಆರ್ಡರ್ಗಳು ಇವು. ಆಫೀಸಲ್ಲಿ ಕುತ್ಕೊಂಡು ಬರ್ದ್ರೆ ಇದೇ ಆಗೋದು.
and the joint inspection report, page number 142, it is as cryptic as, my lord, the present report. Doesn't make any mention. It merely says there is encroachment. From which side, what is the extent, how it is encroached. And above anything, my lord, the scope of inquiry in the earlier writ petition, my lord, there was nothing, my lord, no allegations of encroachment. Whether the certificate, my lord.
See, your property is now protected.
Yes.
They cannot do anything.
Yes.
That order has been passed in the year 2020 itself. That order has been set aside.
That is true.
That order has been set aside. That is why the deputy commissioner has not said anything about your property now.
He says, my lord,
only saying about the
Hakkupatra being illegal, he makes a remark, my lord.
So we will confine the entire exercise only to the property adjacent to your property.
I may also, my lord, examine the fact whether I am required to go before the civil court, my lord, with my.
We will direct them to conduct a resurvey in your presence and in the presence of the fourth respondent with proper information. Now that you are saying yours is a corner site.
Please.
They have to undertake the entire exercise afresh in the presence of both the parties. They will have to first get the records. If yours is a corner site, then they will have to first identify that one.
Yes.
30-40.
Yes.
Thereafter, if there is any
yes,
other property, Whether you have encroached is something that they will have to say. I think it is clear from the photograph itself. You have put up only in the corner
There's a
property,
corner immediately, my lord, there are properties of others.
and that does not belong to you.
That does not belong to me. There are, my lord, other persons who are in possession of the property. They have put up constructions long back.
One submission, your lordship. So for respondent number 6, senior counsel is appearing, your lordship. He is on his VC, your lordships. For that reason, he has sought 230 if it could be taken. 230 if it could be taken.
No, we are not disposing of the matter. We are conducting of a resurvey in the presence of both the parties. We have heard the learned counsel for the petitioner, appellant, learned counsels for the respondents, and the learned government advocate. Having regard to the report filed at the hands of the chief officer of the 5th respondent, Town Municipal Council, Halliked -B. Stop. However, we find that there are lot of discrepancies on facts. Even after perusing the orders passed by the deputy commissioner. Full stop. We find that the learned single judge, in WP number 82199 of 2010, dated 3rd of February 2020, clearly held that the action of the deputy commissioner is grossly delayed and action is not within reasonable time, which would warrant cancellation of the allotment made in favor of the predecessor of the appellant herein. Full stop. The original allotment was admittedly made in the year 1988. Full stop. After more than a decade, the site was sold by the original allottee to the predecessor of the appellant hearing.
Namely Basavaraj.
Namely Shri Basavaraj. Full stop. The appellant herein purchased the property on
1/9/2005 from Basavaraj.
1/9/2005. And thereafter, she has put up construction of shops over the property in question. Full stop. Next para. The most important aspect of the matter is that as pointed out by the learned counsel for the appellant is that the allotment made in favor of Srimati Shobha, the original allottee, was a property measuring 30 into 40 and it is a corner site having roads on the southern and western side. Full stop. It is pointed out from the photographs filed along with the report that
Along with the statement of objection. I have filed photographs and statement of objections today by way of affidavit.
ಇದು ಪೀಠಲಿಲ್ಲ ಇದು ಪೀಠಲಿಲ್ಲ 79 ಅದೇನೋ ಬರ್ದಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಪೆನ್ಸಿಲ್ ಬರ್ದಿರೋದು ಇಲ್ಲಿ 24/15 ಅಂತಿದೆ. We do not know what is the measurement
Either it is meter or feet.
standard,
Yes.
we do not know. But in your sale deed, it says 13 to 40 feet. Huh?
Yes, ma'am.
ಏನ್ ಹೇಳಿದೆ? Report and the photographs filed along with the objection. To the report dated 29/8/2024. The appellant has put up the construction of shops only to the extent of 13 to 40 feet. Full stop. The shops found after found thereafter is not put up by the appellant.
They are belonging to one. The neighboring landowner, my lord, is one Sujauddin. my lord.
It is submitted that one Sujauddin is the owner of the neighboring property and he has put up
Both the sides.
the shops abutting the shops belonging to the appellant here.
On both the sides.
Full stop. Next para. This court is therefore of the opinion that, of the prima facie opinion that there is no clarity in the report filed by the chief commissioner. Full stop. Neither is there clarity in the orders passed by the deputy commissioner. Full stop. Next para. Therefore, we direct that a resurvey be conducted in the presence of all the parties concerned. After obtaining the records to show what was the extent of property allotted to Srimati Shobha, which was subsequently purchased by the appellant. Full stop.
I'll make one submission, my lord, in the meantime, with the help of approved layout map. Adun easy, with the help of approved layout map.
Road ಯಾರು ಫಾರ್ಮ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ ಅದಕ್ಕೆ ಲೇಔಟ್ ಮ್ಯಾಪ್ ಇಂದ ತಗೊಂಡ್ರೆ ಯಾರ್ಯಾರ್ದು ಎಲ್ಲೆಲ್ಲಿ ಬರುತ್ತೆ ಅನ್ನೋದನ್ನ ಕ್ಲಿಯರ್ ಆಗುತ್ತೆ. ವಿತ್ ದಿ ಹೆಲ್ಪ್ ಆಫ್ ಲೇಔಟ್ ಮ್ಯಾಪ್ ಆದ್ರೆ
ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಹೇಳಿರೋದು.
ಪ್ಲೀಸ್,
ಇಟ್ ಈಸ್ ಫಾರ್ ಯು ಟು ಸೇ, we do not know what records, whether a layout was formed after obtaining.
That is also part of the record. That is also part of the writ appeal record, my lord.
ಎಲ್ಲಿದೆ?
Page number 156, my lord. ಯಾಕಂದ್ರೆ ಅಥಾರಿಟಿ ಅವ್ರಿಗೂ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಇಟ್ ವಿಲ್ ಬಿ ಹೆಲ್ಪ್ಫುಲ್, ಮೈ ಲಾರ್ಡ್.
The approved layout plan shall also be looked into.
Please.
Before conducting the survey. Full stop. The survey shall be conducted by the chief officer of the town municipal council, Hallikeda P.
Hallikeda P.
Full stop.
With the assistance of the surveyor, my lord, because we do not know, my lord, whether he is competent to.
With the assistance of the competent officers.
Please.
Full stop. The chief officer is required to give the following information. 1. What was the extent of land allotted to Srimati Shobha along with the property number? 2. Was the same extent of land passed on to the appellant, or was the sale deed executed in favor of the appellant exceeding the original allotment? 3. Which is the neighboring property abutting the property belonging to the appellant?
Yes.
And to whom the said property were allotted? Next. Was the property adjacent to the property of the appellant allotted to the sixth respondent, Shri Srinivas? Next. Has the appellant put up construction only to the extent of the land originally allotted to Srimati Shobha? Next. Is there any encroachment made by the appellant beyond the entitlement of the original allotment? Saka?
And one more submission, my lord. Kindly direct the respondent state to place the all original records for conducting an inquiry, my lord, before the chief officer. ಯಾಕಂದ್ರೆ original records is with the ತಹಸೀಲ್ದಾರ್.
ಹಕ್ಕುಪತ್ರ ಎಲ್ಲ ಅವ್ರ ಹತ್ರ ಇರ್ತಾವ ಸರ್, ನಮ್ಮ ಹತ್ರ
ಅಲ್ಲ, ಒಂದ್ ಕಾಪಿ ಆಫೀಸ್ ಕಾಪಿ ಇರ್ಲೇಬೇಕು.
ತಹಸೀಲ್ದಾರ್ ಅಂತ ಕೊಟ್ಟಿರೋದ್ರಿ. ತಹಸೀಲ್ದಾರ್ ಕೊಟ್ಟಿರೋದು.
ಯಾಕೆ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ ಇಸ್ ವಿತ್ ತಹಸೀಲ್ದಾರ್.
Next para. The chief officer shall secure all necessary information from the concerned Tahsildar, since the allotments were made by the Tahsildar. Full stop.
And kindly direct to the Tahsildar also to play, cooperate with the chief officer.
Tahsildar party idara illi.
Easy.
Then let him only conduct the survey then.
Yaru sir?
Tahsildar.
Maadi sir.
He will be competent.
Please, ma'am.
He will have the survey officers with him.
He is the
Huh?
party.
Respond number 4, my lord.
Chief officer talbuttu shall be conducted by the Tahsildar. Unnabad anta. Respond number 4. Huh? Next para.
ಈಗ ಮ್ಯೂಟೇಶನ್ ಆಗಿರೋದ್ರಿಂದ ಲೆಟ್ ದೆಮ್ ಇವ್ರು ಬೇಕಾದ್ರೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ಲಿ ಅವ್ರಿಗೆ, ಯಾರು ಚೀಫ್ ಆಫೀಸರು. ಹಾ,
ಬೇಡ ಬೇಡ.
ಬೆಟರ್.
The survey shall be conducted on ಯಾವತ್ತು?
ಮುಂದೆ ಬರಂಗ್ ಹೇಳ್ಬಿಡು.
19th of November ಆಗ್ಬೋದಾ? 19th of November.
Direct the parties to be present, my lord,
Yes,
without
yes.
insisting.
ಅದಕ್ಕೆ
Please.
we will fix the date and we will direct the parties to be present. 19th of November at 10 AM.
Please, ma'am.
Huh?
Yes. Whether they will be able to secure all the records before 19th, Lord, they should not.
No, Tahsildarಗೆ direct ಮಾಡಿದೀವಲ್ಲ,
Please,
so all
please,
information is with him only. At 10 AM, full stop. The appellant, respondent number 6. And respondent number 7 shall be present at the spot for survey. Full stop. No notice will be issued to the parties. Stop. Next para. A report shall be submitted by the Tahsildar before this court on the next date of hearing. Stop. Release this matter on 25th of November.
Please.
Grateful. Yes.
Also, direct the register to serve the copy to.
A copy of this order shall be served on the learned government advocate for complaints.
That's one kind submission.
Serial number, my lord, 40, my lord.
Serial number 35, my lords. May I request for,
Adjournment.
may I request for
Please
two?
mention at 2:30.
Serial number 34 may be referred to Lok Adalat. Music is.
No, 2:30. Yes.
ನಾನು ಹೋಗೋದಿದ್ದು ನಾನು ಮಧ್ಯಾಹ್ನ ನಾಳೆ ರೈಟ್ಸ್ ಬರಂತ ನಾನು ಹೇಳ್ಬೋದು 3:30ಗೆ
Mention matter. ಅಲ್ಲ ಅದು ಹಂಗಾದ್ರೆ ಮತ್ತೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಬೇಕು.
ಸರಿ ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೊರಿ.
ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೊಂಡಿರ್ರಿ. ನಿಮ್ಮ ಹತ್ರ ಇರ್ಲಿ ಒಂದು ಕಾಪಿ, ನಮ್ಮ ಹತ್ರ ಇದೆ.
ಫೈಲ್ ಹೋಯ್ತು ಅದಕ್ಕೆ.
ಇಲ್ಲಿ ಅಲ್ಲಿ ನಿಮ್ದು ಅದ್ರಾಗ ಇಟ್ಕೋತಿದ್ರು. ಇರ್ಲಿ.
ಬೇಡ ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೊರಿ.
ಇಲ್ಲ ಸರ್, ಅದ್ರಾಗ ಇಟ್ಕೋರಿ.
ಮಿಸ್ ಆಗ್ಬಿಡ್ತು. ಇಲ್ಲ ನಾಳೆಗೆ
ಅಲ್ಲ ಇದ್ರಾಗ ಇಟ್ಕೊಳ್ರಿ ಅಂದ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಒಂದ್ ಇರ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ. ನಮ್ಮ ಹತ್ರ ಇದೆ.
ಆ ಫೈಲ್ ಹೋಯ್ತು ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಕೊಡ್ತೀನಿ.
ನಿಮ್ಗೆ ಎಕ್ಸ್ಟ್ರಾ ಇಟ್ಕೊ. ಸಾಹೇಬ್ರು ಕೇಳ್ತಿರ್ತಾರಲ್ಲ ಅದಕ್ಕೆ.
ಎಕ್ಸೆಪ್ಷನಲ್ ಅಲ್ಲ ಸೆಕ್ಷನ್ 74.
ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೋರಿ ಬೇರೆ.
ಇದು ಇಲ್ಲ ಫೈಲ್ ಹೋಯ್ತಾ?
ಅಲ್ಲ ಫೈಲ್ ಬೇಡ, ನಿಮ್ಗೆ ಇದಕ್ಕೆ ಬೇಡವಾ?
ರಿಸರ್ವ್ ಅಲ್ಲ.
Your Lordship, serial number 52, Your Lordships. In 52.1 and 52.2, the first appellant has expired, Your Lordships. I have to take steps, Your Lordships. 2 weeks time be granted, Your Lordships. I have informed the other side also, Your Lordship.
52,
Your Lordships. In 52.1 and 52.2, Your Lordships.
Many other advocates.
Your Lordships, I have informed them.
Nishti,
I have informed,
Kashampur.
I have informed Nisti, Mr. Nisti and Mr. Gaurish Kashampur also.
If they are not here, we can't adjourn it now. We'll adjourn if the matter reaches.
Yes, sir.
Yes. Pass out.
Past government. Bill number 11, Sachin M. Mahajan.
Litigation is settled in full and final proceeding. Appeal may be dismissed as interest.
Told. Learned Counsel for the appellants has filed a memo dated 7/11/2024 stating that the parties before the court have amicably settled the dispute by way of a compromise petition filed in the FTP number 16 of 2020 before the learned first additional senior civil judge at Raichur. Accordingly, a final decree has been drawn. Stop. Therefore, the learned counsel submits that the appeal may be dismissed as having become infectious. Full stop. Next paragraph. The memo is taken on record subject to all just exceptions. Stop. Accordingly, the regular first appeal stands dismissed as the prayer made in the writ petition has become infectious. The trial court records may be returned to the trial court.
Seal number 13, Manvendra Reddy.
For the appellant.
This
On the case.
these MFAs were disposed of by order dated 16th of February 2023. Full stop. However, memo dated 22/10/2023 2024. Date first. Has been filed by learned counsel for respondent number 1, the Harshvardhan or Mali Patil. Stating that the appeals were allowed and the compensation was reduced. Stop. The appellant beneficiary has deposited the award amount excluding the amount deposited before this court. Full stop. Therefore, respondent number 1 claimant is seeking directions to the registry to transfer the amount deposited by the appellants to the reference court. Full stop. Next para. Learned counsel for the appellant Union of India does not have any objection to the memo and the prayer made by respondent number 1. Full stop. Next para. Accordingly, registry is directed to transmit the amount deposited by the appellant herein to the reference court.
Yes.
Bill number 35, passed over matters. Manvendra Reddy.
Appellant in this matter, my lords. It's a matter wherein, my lords, the land was acquired.
ಅವಾಗ್ಲೂ ಇರ್ಲಿಲ್ಲ. ಸರಿ, ಆಮೇಲೆ ಕರೀರಿ. ಇಲ್ಲ ಬರಬೇಕು, ಇನ್ನು ಬೇರೆ ಮ್ಯಾಟರ್ಗಳು ಇದಾವೆ. ಆಮೇಲೆ
Bill number 37, H.M. Patel.
Yes.
My lord, I am the owner of special plot number 8 allotted by the respondent number 4. The respondent number 1 and 2 farmed the road in my plot without following the Land Acquisition Act. Then I moved a representation to the municipal corporation respondent number 1 to send the acquisition proposal to the deputy commissioner for necessary action. My representation not considered. I have been filed read petition. The read petition came to be allowed with a direction to the respondent number 1. Then even respondent number 1 not send the proposal. Then the contempt petition was filed. In the contempt petition, the respondent number 1 submitted the report that I am in possession of the area more than the sale deed. Then my contempt petition came to be closed, giving liberty for getting proper relief before the competent court. Then I have been filed a suit. In the suit, the respondent number 1 to 4 appeared, filed the written statement. Then with the plaint, my lord, I have filed an application under section 482, my lord, for dispensation of notice to municipal commissioner. So my suit came to be registered. Again, the respondent number filed interim application. That application came to be rejected.
What was the total extent of land utilized by them? Huh? What was the allegation?
1040
Huh?
meter, 1040 meter
Were utilized?
square meter for
And
road.
What are they saying now?
They are not sending a acquisition proposal. And
Sir, what was it that was told before the contempt court?
I am in excess. I am in excess than the area in my sale deed. That they have filed affidavit.
ನಿಮ್ಮ sale deed prakara, you had purchased 10, what was the total extent of land you had purchased? In terms of the sale deed? 1677 square meters,
1 minute. 1679 square meter.
This is an RFA.
RFA.
Only notice has to be issued, ಅಷ್ಟೇ ತಾನೆ? ಇನ್ನೇನಿದೆ ಇದರಲ್ಲಿ?
The order passed by the trial court, my lord. Order passed by the trial court is.
What is the interim prayer, sir? What do you want now?
You want the order passed by the trial court.
To be issued, isn't it?
My lord, even notice is not required, my lord. My submission is interim
RFA
order.
ಇದು?
My kindly in page number 71, my lord. IA number 9.
Order
number-
IA number 9.
IA number 9 filed by defendant number 4. Under order 9,
Order 7 rule 11D.
order 7 rule 11D
For rejection of the plaint.
for rejection of the plaint.
So the plaint is now rejected.
Plaint is rejected.
Ah.
My lord, this order came to be, this application came to be rejected.
How is it that RFA has been filed?
That is, I'm coming to that point. My application, sorry, application of respondent number 4, filed under order 7 rule 11D, came to be rejected.
Rejected.
Yes, my lord. Came to be rejected. That page 6, my lord, 76. IA number 9 filed by the defendant number 4
ಆಯ್ತು.
under order 7 rule 11D.
ಹಾ.
So in this application, the contention was taken that notice under section 482 was not issued to the municipal corporation. Then again, the trial court, the plaint is rejected and the plaint is not maintainable as notice is not issued. That is, can be permitted to read the trial court order.
Sir, we are not able to understand. Application was filed by defendant number 4.
Yes, my lord.
You are the plaintiff.
I am plaintiff.
That application has been rejected.
Rejected. Again, the trial court on maintainability, my plaint is rejected.
By which order?
Page number 17, my lord.
17.
Yes, my lord. Fourteen, my lord.
Due to non-issuance of notice under section 482 of the KMC Act.
Yes.
Ah.
In order of IA number 9.
Application of section 480 KMC.
No, suit is rejected. Suit of the plaintiff is not maintainable in the present form.
The distance ಮಾಡಿಲ್ಲ.
Notice issue ಮಾಡಿಲ್ಲ ಅಂತ. Notice was not, prior notice was not issued in terms of.
Not issued.
482
My lord,
of
with
KMC
my,
Act.
with my plaint, my lord, I have filed application for dispensation notice.
Dispensation.
Yes, my lord. With my plaint.
See, what do you want now? You want the matter to be disposed of without
Yes.
issuing notice to the other
Yes, my
side?
lord.
How, sir?
That order passed by the trial court itself is against the order of his own predecessor.
So? You want this court to consider your appeal and dispose it of without even issuing notice to the other side.
This is the factor.
How is it possible, sir?
Otherwise,
It was in terms of the objections raised by the other side.
yes, madam.
This order has been passed. So if we pass an order saying this order is not proper, will the other side not be aggrieved?
Even that order itself is,
How can you make this submission that don't issue notice, you dispose of the appeal anta? Angala madak baradilla. They will also come and raise an objection as to how this RFA is maintainable. Everything is possible.
yes, maybe.
Not now. Issue notice to the respondent. Yes.
Seal number 38, GE.
And for the appellant. Please.
Yes.
It may be referred to Lok Adalat. please.
Lok Adalat.
Yes.
Matter stands referred to Lok Adalat.
Seal number 39.
39, I am appealing for appellant, my lord. This is the owner appeal, lordship. Owner appeal, lords, who prepared by the owner, my lord. No any insurance, lordship. The ex parte order, my lord. Case of death, lordship. This is 19,80,000 is awarded.
Owner of the vehicle.
Owner of the vehicle. This is there is no any insurance, lordship. This ex parte order is passed by tribunal, my lord.
What do you mean ex parte? ನೀವು ನೋಟಿಸ್ ತಗೊಂಡು ನೀವು ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್
ಅದೇ
ಮಾಡ್ತಾರೆ?
ಎಕ್ಸ್ parte ಅಂತ ಆಗಿದೆ ಒಂದು ಅಪರ್ಚುನಿಟಿ. ಇನ್ಕಮ್ ಹೈಯರ್ ಸೈಡ್ ತಗೊಂಡಿದ್ದಾರೆ ಮತ್ತೆ 1/5 ಆಗಿದೆ 1/4 ಎಲ್ಲ ಆಲ್ ಮೇಜರ್ ಸನ್ಸ್ ಇದ್ದಾರೆ. Is ready to, my lord, 20-25%. Respondent have filed a executive petition, my lord. EP is filed also.
ಏನ್ ಮಾಡ್ಬೇಕೀಗ?
Is deposit in 20-25%, my lord, is interim. Interim order is granted.
25%.
25% ಕಟ್ತಂತಾರೆ interim order. 6 weeks. Amount ಜಾಸ್ತಿ ಇದೆ 19,80,000 ಇದೆ.
No delay.
ಇಲ್ಲ ಡಿಲೇ ಇಲ್ಲ ಸರ್.
Delay ಇಲ್ಲ.
ಡಿಲೇ ಇಲ್ಲ ಸರ್. ಡಿಲೇ ಇಲ್ಲ ಇನ್ ಟೈಮ್. ಇನ್ ಟೈಮ್ ಫೈಲ್ ಮಾಡಿ.
What is this IA 1 of 2024?
ಅದೇ interim order stay application. Stay application.
Stay na?
Yes.
Issue notice to the respondents. Stop. In the meanwhile, there shall be an ad interim order of stay of the impugned judgment in MBC
101.
101 of 2023 on the file of the
senior
MACT at Sindhanur.
Yes.
Till the next date of hearing, subject to the appellants depositing 25% of the
reference
award amount.
Please.
Before the tribunal.
Yes.
Within a period of 4 weeks from today.
Please.
Yes.
Please.
Preliminary D group matter. Moment advocate.
Short accommodation is in BC melody. Age is going to appear. Age is going to appear. Short accommodation.
Manner, where manner the mandamus direction, like the nature of mandamus, where the
Respondent number 3 is a private party. You are appealing for a private party.
so it's in the nature of my mandamus. Direction manner, they have preferred. Another two writ application against that they have not preferred. So far as this application, they have preferred the petition. May I- Annexure 124, number 1.
To redo the seniority list.
To the senior as per the rules, my lord. So this came to be allowed. Subsequently, this is my lord, Mangalore unit, my lord, they have preferred. These constables. Subsequently, my lords, Tumkur district division also, they also preferred, my lord. It is along with the memo. The state have not filed those documents, my lords, which we have produced before the tribunal. One more order of the tribunal. In application number 516, 514 of 2013. Same direction, my lord, same effect as full has to be tested. Yes, also, my lord.
See, there was no direction. It was only an observation. Therefore, they have not challenged that order. Now, probably there is a specific direction now.
So after the, that is also a direction, my lord.
Techniques are allowed. Impugned endorsements are quashed. Is directed to consider the case of the applicant's afresh on the basis of the final common seniority list of the police constables, keeping in mind the date of entry of the applicants into the service as police constables.
Yes, that's.
This order was not challenged.
Yes.
The question is whether it was implemented.
They have not, the question is that, my lord, against that they have not.
They may not have preferred appeal, but have they implemented it? But what is the use?
Party have not gone, become.
So therefore.
Our case, my lord. On the parity, that is annexure A, my lord. Annexure A. We also thought only in accordance with that rule, the seniority has to be considered. Only prayer is consider our seniority in accordance with the rules, my lord. The order portion in page number 32.
ಇದೇನಿದು ಏನು district wise or state wise ಆಯ್ತು?
ಇದು district wise ಆಗುತ್ತೆ. PSI ಬಂದಾಗ PSI ಹೋಗುವಾಗ state wise ಹೋಗುತ್ತೆ. So insofar as
This is seniority list of the police constable.
police constable and head constables and ASI
Hmm.
and PSI.
Hmm.
When PSI comes malo state level hoಗುತ್ತೆ. 2004 ಅಲ್ಲಿ merge ಮಾಡಿ common seniority ಮಾಡಿ ಅಂತ as per that rules malo, but they have not implemented. When they have implemented, there is some anomaly.
Hmm.
That is what observed by the IGP malo.
Hmm.
Not state that anomaly.
Hmm.
Well, in event of that, my lord, this orders have been passed. Only our request is that as per the rule 2004, it has to be considered and date of entry of my service into as a constable has to be considered.
Hmm.
If I fall in that, my lord,
Hmm.
like your management, my lord.
But this aspect of the matter has been noticed in the impugned order itself.
Yes, my lord.
Just before the operative portion, they have noticed that such orders passed in application number 5137. Therefore, the government.
For the government. We've seen is that applicant.
Hmm.
Cases has been allowed by the tribunal and second respondent hearing was directed to consider the case of the applicant update on the basis of final common seniority list of the police constable, both men and women.
Hmm.
Keeping in mind the date of entry of applicant into service as a police constable. Further review application were filed where also came to be dismissed as per annexure 15 and 16. While dismissing the review application, liberty has been granted. Review applicant here bearing to produce all the relevant documents to second respondent. In time, the second respondent in accordance with law before considering the case of the applicant basis in application number 51. Government has not for appeal against the order application number 5137, 5143 of 2013. Since the government has directed the Director General and Inspector General of Police to implement the order passed in application number 5135. So now,
So what is the use? See, this order was passed on 31st of July 2020. At that point of time itself, it was noticed that orders passed in application number 5137. Houdamma, that itself is not implemented. What is the use of simply saying, no, they have not preferred appeal in that one? It may be true that they have not preferred appeal, but question is whether it is implemented. They have not implemented.
Then my lord, they said to implement. Here, they have not implemented in our case. We have put the content. Pursuant of that content, they shall.
ಅದೇ ಸರ್ಕಾರದವ್ರು ಯಾವಾಗ್ಲೂ ಹಂಗೇನೆ. ನೀವು ಏನಾದ್ರು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಕಂಟೆಂಪ್ಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಸಾರಿ, ನೀವು ಕಂಟೆಂಪ್ಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. This is how it is. Otherwise they'll keep quiet. ಮಾಡೋದಿಲ್ಲ, ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಲ್ಲ.
So what we are saying, according to rules.
Yes, what are your instructions? It is said that the government has directed the DG and IG to implement the orders passed on so and so.
Yes.
What has happened after that?
But regarding that, my lord, I have to get the instruction, my lord. Here also, my lord, they've taken, my lord, 18 years.
One district ಅಲ್ಲಿ ಅದನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ರೆ it has to be implemented in all the other districts. ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the respondents has drawn the attention of this court to the observations made in the impugned order. Full stop. Just above the operative portion, it has been noticed that such directions were already issued by the Karnataka State Administrative Tribunal in applications number 5137-5143 of 2013 to consider the case of the applicants afresh on the basis of final common seniority list of police constables, bracket ali, both men and women, close bracket, comma, keeping in mind the date of entry of applicants into service as police constables, full stop. The government had issued directions to the Director General and Inspector General of Police to implement the orders passed in application number so and so, disposed of on 28/3/2018. Full stop. The learned counsel for the respondents would therefore submit that when the government has taken a conscious decision not to challenge the orders passed in application number so and so, comma, it could not have filed this writ petition calling in question similar orders that were already passed by the tribunal. Full stop. Next para. Learned government advocate is directed to secure instructions as to whether the orders passed by the tribunal on 28/3/2018 in application number so and so have been implemented. Avudamma, what is the use? Ultimately, if that is implemented, you can also say, yes, it is already implemented because the government itself had directed the DG and IG. Illa antandre we'll have to consider it on merits now. You can't say dismiss the appeal because they have not preferred the appeal in other appeal. Angelak paradilla.
They have to follow as per the 2004 rules. When they
That will be on merits. So, if they have not already implemented, then we'll have to hear the matter on merits. We can't issue directions like that. ನೀವು ಅದರಲ್ಲಿ appeal prefer ಮಾಡಲಿಲ್ಲ ಇದರಲ್ಲಿ ಮಾಡ್ರಿ ಹಂಗೆ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. And why would they keep it without filing contempt?
ಕಾನ್ಸ್ಟೇಬಲ್ ಮೇಲೆ ಡಿಸಿಪ್ಲಿನರಿ ಕೋರ್ಟ್
ಅಲ್ಲಮ್ಮ, ನೀವು ಹೈಕೋರ್ಟ್ ವರೆಗೂ ಬರಕಾಗುತ್ತೆ, ನೀವು ಕಂಟೆಂಪ್ಟ್ ಫೈಲ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಅರ್ಥ ಏನು? ಆಲ್ ಯುವರ್ ಬ್ರದರ್ಸ್ ಅಂಡ್ ಸಿಸ್ಟರ್ಸ್ ಓನ್ಲಿ. ಮತ್ತೆ
ಅದು ಯಾಕೆ ಅಂದ್ರೆ ಅದು ತಮಗೆ ಕೊಟ್ಟಿದ್ದು
ಏನಂದ್ರೆ implemented. Even otherwise, the appellant state is required to submit as to why these appeals are preferred in spite of the government taking a conscious decision not to prefer appeals in application number so and so. Next para. Release this matter on 14th of November. Huh? 15th illa.
Number 41, additional government advocate.
41, my lord, what we have it, my lord, next week, my lord. These, all the, my lord, respondents is already on the service, my lord. We rejected their candidature. Thereafter, my lord, there is a direction to consider their eligibility also, my lord. We consider it and subject to the result of the writ petition, my lord, that is, they are in service. This matter has to be heard, my lord. Any date may be fixed, my lord, and after 19th, my lord, any date may be fixed, my lord.
ಏನು? ಏನು?
Rules and regulations which are fixed for equipment. In the middle, not 5 digits, but today's 11:30.
It is only reiteration of such orders which are passed from many years. That is the golden rule. That the rules cannot be altered during the process of recruitment. ಹೌದೌದು.
They are already in the service, my lord. They are already service. They are already service, my lord. They are not disturbing anything. They are also paying the salary also, my lord. Only to subject, because, my lord, there are so many candidates are there, my lord. Condition, my lord, that is 3.5 years, my lord, relaxed to the reduced to 3 years. Those candidates was selected. He is objecting the same. That is the thing, my lord. It is going, the discussion is going on, my lord. Entire, my lord, list has to be, my lord, altered, and they are in the service, my lord. They are not. No, there is no urgency for him, my lord. I don't know why they are already in service, my lord.
By virtue of this order, they have been.
Yes, my lord. They are.
They have been appointed.
Yes, my lord.
ಮತ್ತೆ 2022 matter.
Next week, my lord, or 19th or 20th, my lord.
At the request of the learned government advocate, finally release this matter on 19th of November.
Please.
CF 43, file living matters, Sachin M. Mahajan.
For partition. And my lord, there was a counter claim. Suit came.
ಶಿವಾನಂದ್ ಪಾಟೀಲ್, ಅಮರ್ ಕುಮಾರ್, ಅರುಣ್ ಕುಮಾರ್, ಅಮರ್ ಗುಂಡಪ್ಪ.
Where is for remand?
Why two RFS?
The judgment, my lord, in the case of Kerala Agro Seeds came where, my lord, suit and counterclaim, there was a requirement to file, my lord, 2 separate appeals. Initially, my lord, by paying separate court fees and, my lord, making separate prayers, I had filed 2 unified appeal. I should not face any technical hurdle, my lord. In that regard, I was, my lord, constrained to file an application, seeking permission to withdraw part of the appeal and then, my lord, file afresh. That is how, my lord.
2012.
Please, my lord.
Order sheet. Furnishing of order sheet of this case. Memo dated 13/10/2022. ಯಾರ್ ಫೈಲ್ ಮಾಡಿರೋದು? For furnishing copy of order sheet in RFA 2/00061 of 2016. ಯಾರ್ ಫೈಲ್ ಮಾಡಿರೋದು ಮೆಮೋ ಅದು? Appellant. They have furnished. ಅದನ್ನ ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ? They have furnished a copy. ಈಗ ಯಾಕೆ ಬರ್ಬೇಕಿಲ್ಲ? They have already furnished. Along with memo ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Now, in the appeal, my lord, they have disputed the relationship. Sufficient material is filed by way of additional evidence to show, my lord, that I am the son of a son, which requires consideration. Ultimately, the matter may have to go back, my lord, for consideration afresh. Even they have filed an application, my lord, for additional documents. I have also filed application for additional documents. And, my lord, the documents are voluminous, for which, my lord, cross-examination, my lord, is necessary. Since there is dispute of relationship and, my lord, the nature of documents that are filed, where, my lord, there were earlier suits between my father and, my lord, who now they claim he is not my father, my lord, I'm an outsider. There was litigation between us. There are certain documents, my lord, where he has admitted that, my lord, I am the son, my lord, of the deceased person through whom I am, my lord, claiming the right in the property. And, my lord, there were several criminal cases in which the other side prosecuted me as the son, my lord, of the person whom I am claiming to be. It is in that regard, my lord, I am producing these documents.
And what are the documents they are placing?
They are placing, my lord, with respect to a counterclaim. In support of that, my lord, what has happened was, the father of the plaintiff and the defendant number one, they are brothers. Now, the father of the plaintiff, he married, my lord, the mother of the plaintiff, who was already, my lord, married to another person. Now, that confusion of relationship, my lord, now my relation is attributed to that person. Even though my father during his lifetime has clearly and categorically admitted that I am his son. Now, taking advantage of that, now they want to rely on that material to show that I am a stranger, outsider. Whereas, my lord, I am trying to rely upon material where there are, my lord, several deals and correspondence between me and my father to establish that I am the son, which requires, my lord, probably, my lord, evidence and cross-examination is certainly required. He may seek instructions, my lord. My only endeavor is, my lord, that lengthy argument is probably not required. If I may, my lord, take your lordships through the documents.
Since additional documents are.
Yes, yes. They may take instructions, my lord, and it can be disposed of, my lord, and the next week.
Finally, at the request of learned counsel for the respondents, release this matter on 20th of November 2024.
Meanwhile, regarding the counterclaim dismissal, my lord, they are making, my lord, my application for stay is pending in the connected RFA. Let them at least, my lord, give an oral statement before the court that they will not precipitate before the Tahsildar. I am told, my lord, on daily basis, my lord, there is a problem on the ground. ಸ್ವಲ್ಪ our assurance ಕೊಟ್ಟರೆ ಸಾಕು sir. If they can.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ learned counsel for the appellant submits that the impugned judgment is passed, holding that the appellant plaintiff,
please,
is not able to establish relationship with the prepositors. Full stop. Therefore, during the pendency of this appeal, additional documents are sought to be brought on record to establish the fact of the relationship of the plaintiff with the prepositors. Full stop. Learned Counsel would further add that having regard to the voluminous documents sought to be produced by the appellant by way of additional documents, the matter may be, the matter may have to be remanded back to the tribunal,
Trial court.
trial court, to consider the additional documents. Full stop. ಅದಾದ್ಮೇಲೆ ಇದನ್ನ ಹಾಕ್ಬೇಕು. Finally at the request. Yes.
They can at least communicate their client, my lord, not to precipitate, my lord, the matter before the Tahsildar. ಈ stage ಅಲ್ಲಿ, my lord, it may not be appropriate on my part also to press for the IA for stay, because your lordship will be taking up the matter next week. ಸ್ವಲ್ಪ assurance ಕೊಟ್ರೆ ಸಾಕು ಸ್ವಾಮಿ.
ಅವ್ರು ಹೆಂಗೆ ಪಾಪ ಅವ್ರ
ಅಲ್ಲ, they can communicate, my lord, to the.
No, at least if his senior was there, we could have asked him. Papa, it will be difficult for him to say.
I am not seeking, my lord, anything to be brought on record. He can only communicate, my lord. I am not seeking, my lord, anything to be brought on record. My only request is, my lord, let them communicate to the trial court counterpart not to precipitate ಅಷ್ಟೇ, without bringing it on record.
ಹೆಂಗ್ ಹೇಳೋದು?
If you can give assurance, my lord.
They have given a short date.
Please.
Yes.
ಇವಾಗ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, ಸೂಟು ಹೋಗಿದೆ, ಆ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಇರೋ ನನ್ನ ಹೆಸರು ಪ್ರಾಪರ್ಟಿನ ಅವರು ಮ್ಯೂಟೇಷನ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. ದಟ್ ಬಿಕಮ್ಸ್ ಅ ಡಿಫಿಕಲ್ಟಿ.
Seal number 44, Ashok R. Kalyani Shetty.
ಪಾಸ್
ಪಾಸ್ ಓವರ್ ಯಾವ್ದಕ್ಕೆ?
44.
Release this matter on 14th of November.
Seal number 46. R.S. Siddhapurkar.
Lordship, I seek for a short adjournment in this matter, Lordship. Seniors unwell, it may be taken up next week, Lordship, any day.
At the request of learned counsel for the appellant, release this matter
Pick any date, Lordship,
on
on 14th,
14th
please.
of November.
Oblige, Lordship.
Seal number 47, additional SPP.
Not full. We were discussing that at least in these kind of matters where the state has filed appeal, we should proceed. You proceed madre, they will come.
Once again,
Yeah, we are not even able to dispose of one appeal, criminal appeal.
the warranty would be made.
Okay, anyway, it's a state appeal. We will see.
Which date should be? Name of two things.
ಕೊಡ್ತಾ ಇದೀವಲ್ಲಿ ಡೇಟ್ಸ್.
Dates regular ಇರ್ತಾವಲ್ಲ sir, but.
Matter is called out. There is no representation for the respondent. Release this matter on 14th ಅಂತ ಹಾಕೋಣ. Let us see, please. 14th of November.
Seal number 48, Basuraj Kareddy.
ಏನು ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್, ಕೋರ್ಟ್ ನೋಟಿಸ್ ಆನ್ ಅಪೆಲೆಂಟ್ ನಂಬರ್ 1 and 2. ಏನಕ್ಕೆ? Why court notice?
Since he was not present. Case of land user.
Matter is called out. There is no representation for the appellant. Full stop. It is seen from the records that there has been no representation for the appellant. From a long time, and therefore, by order dated 30/6/2021, this court directed court notice to be issued to the appellants. Full stop. Appellants have been served, and yet there is no representation for the appellant. Full stop. Name of learned counsel Shri Basavaraj Karaddi is reflected in the cause list. Full stop. Next para. Release this matter on 14th of November 2024. Full stop. If there is no representation for the appellant on the next date of hearing, the appeal will be dismissed. Yes.
Seal number 49, Sudhir Kulkarni.
Huh?
Two MFAs, one RFAs filed. The dispute between two wives. There is suit filed by the daughters of first wife. Suit is decreed 1/5, 1/5, 1/5. ಎರಡನೇ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಆಸ್ ಪರ್ ದಿ ರೇವಣ ಸಿದ್ದಪ್ಪ ಕೇಸ್. ಈಗ ಸ್ಟಿಲ್ ಇದ್ರೂ ಕೂಡ ಅವ್ರ ಮೊದಲನೇ ಹೆಂಡತಿ ಮಕ್ಕಳು ಇನ್ನೂ ಒಂದೊಂದು ಎಕರೆ ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ತೀವ್ರಿ ಸೆಟಲ್ಮೆಂಟ್ ಬೇಗ ಮಾಡಿಬಿಡುವ ಅಂತ ದೇರ್ ಪ್ರಪೋಸಲ್. ಎಲ್ಲಾನು ಮುಗಿದ್ಬಿಡು.
ಎರಡನೇ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿಲ್ಲ, ಬರಲ್ಲ ಆಸ್ ಪರ್ ರೇವಣ ಸಿದ್ದಪ್ಪ ಕೇಸ್. ಫಾದರ್ ಸೇರ್ ಫಾದರ್ಗೂ 7 ಎಕರೆ ಬಂದಿದೆ. ಅದರಲ್ಲಿ ದೇ ಆರ್ ಎಂಟ್ರಿ ಅಲಾಂಗ್ ವಿತ್ ನಮಗೂ ಬರುತ್ತೆ ಅದ್ರ.
ಫಾದರ್ ಇಸ್ ಅಲೈವ್.
ಅಲೈವ್
ಅಲೈವ್
ಅಲೈವ್. ಸೊ ಅದಕ್ಕೆ ಎರಡನೇ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ ಸೇರಿಲ್ಲ. ಫಾದರ್ ಪ್ಲಸ್ ಫಸ್ಟ್ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ ಸೇರ್ಕೊಟ್ಟಿದೆ. ಅದು MFA ಅಂದ್ರೆ ಒಂದು ಅವರು ಡಿಗ್ರಿ ಫಾರ್ ಡೈವರ್ಸ್ ಕೇಳಿದ್ರು, ಅವ್ರಿಗೆ ಡೈವರ್ಸ್ ಗ್ರಾಂಟೆಡ್ ಟು ದಿ ಹಸ್ಬೆಂಡ್ ಅದು ಮಾಡಿದ್ರು. ಅವರು KBL ಇದ್ದು ರಿಟೈರ್ಡ್ ಆಗಿದೆ, ಈಸ್ ಪೆನ್ಷನರ್. ಅವ್ರಿಗೆ ಎರಡನೇ ಹೆಂಡತಿ ಈಸ್ ನೋ ಮೋರ್, ಇವನ್ ಟೇಕಿಂಗ್ ಡಿಗ್ರಿ ಯೂಸ್ ಇಷ್ಟು ಅವ್ರಿಗೆ ಹೇಳಿದ್ವಿ ನಾವು. ಬಟ್ ಅದರ್ ಸೈಡ್ ಏನಂತಾರೆ, ಅದರ್ವೈಸ್ ವಿಲ್ ಗೋ ಆನ್ ಮೆರಿಟ್ಸ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್.
MFA ಹಳೆಯದು 2014, 2015.
ಅದು ಎರಡು ಸೇಮ್ ಅಂತ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಅರೇಂಜಿಂಗ್ ಪಾರ್ಟಿ ಸೇಮ್ ಅದಂತ ಕನೆಕ್ಟ್ ಅವರು
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು. ಬಟ್ ಓಲ್ಡರ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ದಿ MFA.
ಓಲ್ಡರ್ ಮ್ಯಾಟರ್ಸ್. ಅದು ಮೆಟ್ರಿಮೋನಲ್ ಕೇಸ್ ಬೋತ್.
ಬಿಟ್ವೀನ್
ಅಲ್ಲ ಮೆಟ್ರಿಮೋನಲ್ ಕೇಸ್ ಹಸ್ಬೆಂಡ್ ವೈಫ್ ಡೈವರ್ಸ್ ಪೆಟಿಷನ್
ಕೇಸ್ ಬಿಟ್ವೀನ್ ಹೂಮ್?
ಹಸ್ಬೆಂಡ್ ವೈಫ್.
ಯಾವ ಹಸ್ಬೆಂಡ್?
ಅಪಲೆಂಟ್. ಅಪಲೆಂಟ್ ಇಸ್ ದ ವೈಫ್ ಇನ್ ಒನ್ ಕೇಸ್ ನಲ್ಲಿ. MFA ಫಸ್ಟ್ 15ದಲ್ಲಿ ರೈಸಿಂಗ್ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಯಾವುದು ಫಸ್ಟ್ ವೈಫ್?
ಹೌದು, ಫಸ್ಟ್ ವೈಫ್. ಫಸ್ಟ್ ವೈಫ್.
ಫಸ್ಟ್ ವೈಫ್ ಅಂಡ್ ದಿ ಹಸ್ಬೆಂಡ್.
ಹಸ್ಬೆಂಡ್.
Petition for divorce was filed
by the husband. That is allowed. That is allowed. Allowed ಆಗಿದೆ. That was challenged before this court by the wife.
ಇಲ್ಲಿ ಅಲ್ಟಿಮೇಟ್ಲಿ ಈಗ ಈ ಕಡೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ, ಆ ಕಡೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ?
ಫಸ್ಟ್ ವೈಫಿಗೆ 4 ಜನ ಮಕ್ಕಳು. ಅವರಿಗೆ 3 ಜನ ಗಂಡಸು ಮಕ್ಕಳು, ಬರೀ 4 ಜನ ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ. ಅವರು
ಇಲ್ಲಿ 4 ಹೆಣ್ಣು, ಅವ್ರು 3 ಗಂಡು.
ಇಲ್ಲಿವರೆಗೆ ಅವರೇ ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಪ್ರಾಪರ್ಟಿದ್ ಏನ್ ಬರ್ತದೆ ಎಲ್ಲ ಅವರೇ ನೋಡ್ತಾರೆ. ನಮ್ಗೇನೋ ಏನಾಗ ಕೊಟ್ಟಿಲ್ಲ. ಸ್ವಲ್ಪ ಮೇಂಟೆನೆನ್ಸ್ ಅವಾರ್ಡ್ ಆಗಿತ್ತು, ಅದರಲ್ಲಿ 3 ಮಂದಿ ಮದುವೆ ಆಗಿದೆ.
ಲಕ್ಷ ಡೈವರ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪರ್ಮನೆಂಟ್ ಎಲ್ಮನಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, 10 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ. ದಟ್ ವಾಸ್ ಚಾಲೆಂಜ್. ಅದು ಹೆಚ್ಚಾಗಿದೆ ಅಂತ ಅವ್ರು ಬಂದಿದ್ದಾರೆ.
ಅವ್ರು ಅದನ್ನು ಫೈಲ್ ಮಾಡಿದ್ರು.
ನಮ್ಗೆ ಡೈವರ್ಸ್ ಬೇಡ ಅಂತ ನಾವು.
ಅಲ್ಲ ಇವಾಗ ನೀವೇನೋ ಹೇಳ್ತಾ ಇದೀರಾ ಒಂದ್ ಎಕರೆ
ಈಗ ಅವರಿಗೆ ತಂದೆಗೆ 7 ಎಕರೆ ಬಂದಿದೆ. 1/5 ಅಂತ. ಅದು ಅವರೇ ಇಟ್ಕೊಂಡ್ರು ಸರಿ.
ಟೋಟಲ್ 21 acres.
36 acres ಲ್ಯಾಂಡ್ ಇದೆ.
36.
ಅದರಲ್ಲಿ ಏನೋ ಒಂದು ಸಮ್ ಲ್ಯಾಂಡ್ ಮಾರಾಟ ಆಗಿದೆ. ಎಷ್ಟು ಸಮ್ ಎಕರೆಯನ್ನು ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ. ಅವರು ಪರ್ಚೇಸರ್ಸ್ ಆಲ್ಸೋ ಪಾರ್ಟಿ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಸ್ವಲ್ಪ ಐ ಹ್ಯಾವ್ ಟು ಪುಟ್ an end to the litigation once for all.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾವು ಯೋಚನೆ ಮಾಡ್ತಾ ಇರೋದು. See now if there are 7 shares almost equal, then I think they also will not have any objection. ನೀವು ಇವಾಗ ಏನ್ ಪ್ರಪೋಸಲ್ ಕೊಡ್ತಾ ಇದೀರಾ, if it works out to that much, then it will be an equitable share.
ಅಲ್ಲ ಈಕ್ವಲ್ ಅವರಿಗೆ
ಕರೆಕ್ಟ್. We do not know. Please think over.
ಅಷ್ಟು
ಅವ್ರು 3 ಜನ ಇರೋದು ಆ ಕಡೆ.
3 ಜನ ಇದ್ದಾರೆ.
4 ಜನ ಇದ್ದೀರಾ ಹೆಣ್ಮಕ್ಳು.
ಒಂದು ಮನೆ ಅವ್ರಿಗಿದೆ. ಒಂದು ಮನೇನೇ ಇದೆ. ಆ ಮನೆಯಲ್ಲಿ ನಾವೇನು ಕೇಳಿಲ್ಲ. ಸ್ವಲ್ಪ ಅದ್ರಲ್ಲಿ ಮಾಡೇ ಇಲ್ಲ. ಅದ್ರ ನಮಗೆ ಮನೇನೂ ಇಲ್ಲ ವಾಸ ಮಾಡಕ್ಕೆ.
8 ಆಗುತ್ತೆ. ನೀವು ತಾಯಿಗೂ ಒಂದು ಶೇರ್ ಇಟ್ಕೊಂಡ್ರೆ 8 ಆಗುತ್ತೆ. ಹಂಗಾದ್ರೂ ಮಾಡಿ, ಅದು ಮಾಡಬಹುದು. ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ಗೆ 5 ಬರುತ್ತೆ. ಅವ್ರಿಗೆ 3 ಆದ್ರೆ ನಿಮ್ಗೆ 5 ಶೇರ್ ಬರುತ್ತೆ.
ವಿಚಾರ ಮಾಡಿ,
ಯೋಚನೆ ಮಾಡಿ.
Only problem is, my lord, in view of the law laid down in the Revan Siddha versus Mallikarjun case, the issues born from the second wed law, they are solely entitled in the share of the father. That is what the trial court judgment, sir. No, I agree. I agree with the. I agree, sir.
Please see the situation.
I agree.
Husband has filed a petition for divorce. Divorce has been granted.
I agree with that.
Well, ಇದೆ. So ಇದನ್ನು ನೀವು ನೋಡ್ಬೇಕು.
I agree, sir.
So I think it is almost if it is coming to the same, then we can convince the other side. They can't ask for half share.
ಹೇಳ್ತೀನಿ.
Not possible.
Not possible.
So ನೀವು 5 ಅಂತ ಇಟ್ಕೊಂಡ್ರೆ ಅವ್ರ 3 ಬಂದ್ರೆ ಸರೋಗುತ್ತೆ ಅಲ್ಲಿಗೆ.
You will get more than 20 acres.
ಹೌದು.
ಅದು ವಿಚಾರ ಮಾಡಿ ಪಾರ್ಟಿ ಕಳಿಸಿಕ್ಕೆ I will convene.
Please, you also convey it to your senior and say this is what was discussed. That kind of a proposal.
Parties present ಇರ್ಲಿಕ್ಕೆ ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು will keep the party present. Party present on date.
ಅಲ್ಲ ನೀವೇ ಮಾತಾಡ್ಬೋದು.
ಅಲ್ಲ ಒಂದ್ ಸ್ವಲ್ಪ ನಾವು ಹೇಳಕ್ ತಮ್ಮ ಮುಂದಾದ್ರೆ ಸ್ವಲ್ಪ ಅನುಕೂಲ ಆಗ್ತಾನೆ.
Release this matter
12-13 ತಾರೀಕು ಯಾವಾಗ ಇಡಬಹುದು?
On 13th. Allama, it is not for hearing. To enable the parties to come before the court.
ಅಲ್ಲ ನೀವು ಪರ್ಚೇಸರ್ಸ್ ಇದ್ದೀರಾ? ಅವ್ರದ್ದೇನು ರೋಲ್?
13th of November 2024. Full stop. All the parties are directed to be present before this court on the next date of hearing.
Bless.
Seal number 50 Vinayak Apte.
Every 1 week accommodation, sir. I want to file application, sir, for appointment of commission.
Commissioner.
Land only is a suit for partition, dismiss. A land only is.
Time is granted.
Obliged.
At the request of learned counsel for appellant to file necessary application for appointment of commissioner.
Seal number 51 Ajay Kumar AK.
Yes. ನೀವು ರೆಸ್ಪಾಂಡ್ ಇದ್ದೀರಾ? Specific performance.
It's your watch. It is.
ನೀವಿದ್ದೀರಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಫೈಲ್ ತಗೊಳ್ಳಿ. ಇನ್ನೊಬ್ರು ಇದ್ದಾರಲ್ಲ.
RS
ಸಿದ್ದಾಪುರ್ಕರ್.
Spot number 2 RS Siddhapurkar.
Who is the contesting respondent? ಇವರೇನಾ?
Bani.
Ready? Matter is called out. There is no representation for respondent for 2.
I agree for respondent number 2.
ಇದೀರಾ? ಬೇಡ ತೆಗ್ಬಿಡಿ. You are the contesting respondent.
Yes.
At the request of learned counsel Shri Vinayak Apte, release this matter.
21.
21, your lordship.
On 21st of November.
Yes.
Seal number 52, Ganesh Subhash Chandra Kalaburagi.
Your lordships, in this matter, in the connected matter 52.1 and 52.2, your lordships, the first appellant has expired. 2 weeks accommodation, your lordships, I'll file necessary application along with details of LRs.
For the appellants submits that the appellants in
Appellant number 1 in 52.1 and 52.2, your lordship.
are no more. Stop. Therefore, learned counsel prays for a short accommodation to file necessary application. Stop. Release this matter
25th.
19th of November.
Death certificate recently has expired, your lordships. 17th of October, he has expired. 25th, it could be taken.
25th of November.
Great.
Yes.
Seal number 53, Ganesh Nayak.
Conviction appeal means 302 offenses.
Ganesh Nayak.
Matter is called out. There is no representation for the appellant. Release this matter on 25th of November.
Seal number 54, Rajesh Doddamani.
Also.
ನಿಮಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ? ಕಾಪಿ ಸರ್ವ್ಡ್ ಆನ್ ದಿ ಸ್ಟೇಟ್ ಅಂತಿದೆ.
Admit time is conviction will be.
Same order.
Seal number 55, Biradar Kalyani.
40,000 on the previous hearing date.
Huh?
As towards the arrears of maintenance, I have received rupees 40,000 on behalf of wife. And the remaining amount is 30,000. As per the undertaking given by the husband, the expiry due date is 25th of November. It will be 2 months. When he has filed on 26th September, with an undertaking to clear the entire amount within 2 months, which will be over on 25th November. I have already submitted written document, a brief written document to assist the honorable court to dispose of the appeal, because it was with the intention to debar the appellant. They have filed this the diverse proceedings before the trial court exclusively to debar the appellant wife from the maintenance allowance. I have submitted written document on previous date, my lord.
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಯ್ತು? ದುಡ್ಡು ಕೊಟ್ರ?
40,000 ಕೊಟ್ರ ಸರ್, 40,000 ಕೊಟ್ರ. 40,000 ಕೊಟ್ಟ, 40,000. ಇನ್ನ 30 ಕೊಡ್ಬೇಕು, 30.
ಇನ್ನು 30
ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಇನ್ನ ಮತ್ತೊಂದು ತಿಂಗಳ 35 ಆಗ್ತದೆ. ಪ್ರತಿ ತಿಂಗಳ 5,000. 25ಕ್ಕೆ ಮತ್ತೆ 35 ಆಗ್ತದೆ. 25 ತಾರೀಕಿಗೆ. A little 5-4 days.
Then we will have it on 27th.
25ಕ್ಕೆ ನಡೀತು ಸರ್. ನಡೀತು ಸರ್
25 ಮುಗಿಲಿ.
ಸರ್ 25. ಆಮೇಲೆ I have my written document can be taken on record.
Matter is called out. There is no representation for the respondent. Full stop. However, learned counsel for the appellant submits that on 30/10/2024, the respondent has paid a sum of rupees 40,000 to the appellant. Full stop. However, a sum of rupees 30,000 is still remaining to be paid by the respondent.
As on date. As on date.
As on date. Full stop. Next para. Release this matter on 27th of November.
And my written document can be taken on record.
ಏನಕ್ಕೆ?
Andre final arguments.
ಇವಾಗ ತಗೊಳ್ಳೋದ್ರ ಅರ್ಥ ಇಲ್ಲ. Only if the arguments commences, we should see all that. Yes.
First door matter. Seal number 35.
Matter, my lord, your lordship is directed me to get the instruction, my lord, on 23/10/2024. Regarding the, my lord,
That 1 acre 18 guntas.
Yes.
Some documents, my lord, we collected, my lord, that is not clear. But it is mentioned that, my lord, ownership is the jailer garden. Jail garden is the owner.
ಹೆಂಗೆ ಅಂತ
That's why, my lord,
ಅದೇ
they are asked to
see,
fill.
that is also the observation in the impugned order.
But the independence day, my lord, that was the required. That is the, my lord, contention of our.
Correct. See, for construction of jail itself, it was acquired.
Yes.
But what was acquired was a certain extent. And according to the records, 1 acre 18 guntas were there remaining even after acquisition of the said lands. For that one, they are asking for compensation.
So the list of the, my lord, declared the national highway authority, survey number money is passed for movement, my lord. Mark this, my lord, this is only one. That is, my lord, shown in survey number 51 is the also.
ಏನಿದು?
That is the, my lord, particulars of the, my lord, survey number past the national highway.
ಅಂತಿಮ ಪ್ರಕಟಣೆ.
ಇದು NHA ಅಲ್ಲ, ಸ್ಟೇಟ್ ಹೈವೇ.
ಹೆದ್ದಾರಿಯ, my lord,
ಸ್ಟೇಟ್ ಹೈವೇ.
ಹೌದು.
ರಾಜ್ಯ ಹೆದ್ದಾರಿ. ಅಂದ್ರೆ ನಿಮ್ಗೆ ಬರುತ್ತೆ.
ನೀವೇ ಅಲ್ಲ.
Already, my lord, that was, my lord, acquired and formed the state highway.
It is.
That is the document, my lord, we are requested to.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಪರಿಹಾರ ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ.
Whether it is paid or not, or acquired long time, that has to be ascertained. Instructed.
May I make one submission? They have, the acquisition is done for jail garden, my lords. The entire property they have taken under their custody, my lords, under 28 acres, 28 guntas was taken completely as jail garden, my lords. In acquisition proceedings, last tabular column, it's mentioned as jail garden only, my lords. So the question of paying compensation will not arise. Reason behind, and they say that jail garden was acquired for the state purpose and the state were having the entire property. So the question of paying the compensation by, again, for the state only, my lords, because the property was, as according to their records, my lords, the property was vested with the state only after acquisition.
No award is passed.
Let's see, my lord, all the records, my lord, is old records, my lord, that is the reason, my lord. Earlier, my lord, is some other department, but it is handed over to the PW department recent. So those documents, my lord, is not available.
Correct. ಆ ನೋಟಿಫಿಕೇಶನ್ ಕೆಳಗಡೆ 28 acres 28 guntas
Yes,
were acquired
subsequently.
for formation of the jail only.
That notification, gazette notification, I have produced, my lords.
ಅಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ there is no dispute.
No, my lords. Yes, my lords.
They also admit that it was 28 acres 28 guntas.
Yes, my lords. Yes, my lords.
But there were more extent of land, that is 1 acre 18 guntas remaining.
Yes, my lords. The acquisition was for 27 acres, 10 guntas. my lords.
Total
Oh,
28.
28 acres, 28 guntas was the total extent of the land, my lords. In that 27 acres, 10 guntas was acquired, my lords. And we have received compensation to the extent of 27 acres, 10 guntas, my lords.
On the previous occasion, we have noticed the submission of the learned counsel for the appellant, that even in terms of the revenue records, the appellant was the owner of 28 acres 28 guntas in survey number 51. Full stop. An extent of 27 acres 10 guntas were acquired for construction of central jail.
Please.
Full stop. Therefore, it is the contention of the appellant that the remaining 1 acre and 18 guntas of land have been utilized by the respondents without acquisition and without payment of compensation. Full stop. The matter was adjourned at the request of the learned government advocate. Who was directed to secure instructions as to how the respondents are in possession of 1 acre and 18 guntas without acquisition and without payment of compensation. Full stop. Next para. Today, learned government advocate submits that the State Highways Authority is in possession of 7,700 square meters of land in survey number 51. Full stop. Next para. The question therefore is how the State Highways Authority came in possession of the said extent of land. Full stop. If it is clear that the respondents, be it through the jail authorities or the State Highways Authority, are in possession of any land belonging to the appellant, then they are required to pay compensation. Full stop. Next para. Finally, at the request of learned government advocate, release this matter on 19th of November. Full stop. We will be constrained to dispose of the appeal, having regard to the material made available at the hands of the appellant.
Obliged.
ರೂಲ್ ಸಿಗ್ಲಿಲ್ಲ, ಕಳಿಸ್ಲೇ ಇಲ್ಲ ಅವರು. ಇಬ್ಬರೇ ಕೂಡ ಇಲ್ಲ. ಮತ್ತೆ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿದ್ರೆ ಮತ್ತೆ ನಾವೇ ತರಿಸ್ಬೇಕಲ್ಲ. ಮ್ಯಾನ್ಯಲ್ ರೂಲ್ಸ್ ಆರ್ಡರ್ ಸಿಕ್ಕೇ ಇಲ್ಲ ಅಂತ. ಕೊಂಚ ಆರಾಮೈತಿ.
ಬಸರಡಿ ಹಿಂಗ್ ಕೂಡ ಕೊಡಂಗಿಲ್ಲ ಅಲ್ಲಿ.
Hello.
ಹಾಕಿದ್ದೀರಾ ಇರ್ಲಿ ಬಿಡಿ ಬಿಟ್ರಲ್ಲ ಮಾಡಿ
ಪೆನ್ಸಿಲ್
delay application, delay application, delay. Good. Ready, sir.
Hello, brother.
Sir, you.
Ah.
CL number 1, government advocate. Office objections for first time.
Office objection regarding my lord, full cast title in the CD application, that is my lord. Regarding merit, my lord.
Huh? ಏನ್ರಿ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ವಂತೆ
ಅಲ್ಲ full cast title my lord.
ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ವಂತಲ್ಲ ಕಂಡೋನೇಷನ್ಗೆ.
That is the.
ಏನ್ ಮಾಡ್ತೀರಾ?
Regarding merit, my lord, your lords.
Merit ಮೇಲೆ ಹೆಂಗೆ? How to take it on merit when there is a delay?
That's true. I will, in connected matters, my lord, CD is filed. Yes. ಅದರಲ್ಲಿದೆ.
ಎರಡರಲ್ಲೂ ಇಲ್ಲ. That order was passed on 18th of December 2023.
Yes, that's why, my lord, that thereafter, my lord, writ appeal was filed. Then, my lord.
Condonation of delay application ಹಾಕಿಲ್ವಲ್ರಿ?
I'm sorry, man. I'm sorry.
ಏನ್ ಮಾಡೋದು?
One short accommodation, man. Short accommodation, any date, man. Any date, one short accommodation, man.
Really, what is the grounds for review?
Malad, the consent about the review concern, Malad. My lordship is, as I'm fully aware, there was a market, supermarket situated in Kalaburagi. There was a site was through auctions purchased by the petitioners, and thereafter
some reasons they are unable to construct the building on the national monument area. So therefore, they came to the High Court by way of writ petition direction to the High Court to direct the Deputy Commissioner to allot the alternative site. After heard this, my lord learned single judge and came to be a division bench. In the division bench is directed the state government to be an allot the alternative site 20 into 40. My lord, in this circumstances of the case, we have filed the review petitions, only limited prayer before your lordship. There is one, the same supermarket area, particularly when public litigations was filed in the division bench of the principal bench. In the principal bench is held that in the fact of the case, in this case, my lord,
What is this SLP 15129?
this SLP, my lord, the High Court of this,
Copy?
yes, I am submitting.
Why have you not furnished it along with the petition?
It is made annexure ಮಾಡಿ.
Huh?
Annexure C, my lord, Annexure C.
Annexure?
C, my lord.
See, page 38.
Annexure C is the dismissal of the SLP.
SLP is dismissed and filed by the Vishwanath. He is one of the petitioner before the Supreme Court against the High Court order. High Court order in favor of us, we are going to be.
Mention madro SLP. What is this SLP? 15129 of 2007. Adena idu?
Yes, please, same.
Yen direction?
Well, we are going to say that this, it is, the division bench of this honorable court is going to be helping us. That is only, we are bringing kind notice of this honorable court, my lord. My lord, this is the division bench order. If lordship.
ಒಂದು SLP ನಂಬರ್ ಅಲ್ಲ ಅದು, ಇವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಇಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್.
ಯಾವ್ದೋ ರಿಟ್ ಪಿಟಿಷನ್ ಇದ್ದದು.
Public litigation, writ petition number, my lord. So writ petitions against the writ petition, public litigation petition order was filed in the SLP. SLP confirmed the public litigation order. So we are relying on the division bench of this honorable court.
Where is that?
Yes. Annexure, my lord, copy. Annexure A, my lord. Sorry. Annexure B, my lord, page number 22. Sorry.
Why are you doing like this?
Sir, the RP 20075 first RP 20075.
That is correct. Lordship find out ಮಾಡಿದ್ದು ಅದರಲ್ಲಿ ಕಾಪಿ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ ನಾವು. ಅದರಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅದು. That is our fault only. We are agreed with that. ಈ ಕಾಪಿ ಸಾಹೇಬ್ರ ಹತ್ರ ಇಲ್ಲ, ಇವಾಗ ಕೊಟ್ಟಿದ್ದಲ್ಲ. ಲಾರ್ಡ್ಶಿಪ್ ಹತ್ರ ಇಟ್ಲಿಕ್ಕೆ
ಯಾವ್ದು ಯಾವ್ದು? ಡಿವಿಷನ್ ಬೆಂಚ್.
ದಿಸ್ ಕೇಸ್
SK ಕಾಂತ, ಅಶೋಕ್ ಕುಮಾರ್ ಜಾಜಿ, SK ಕಾಂತ. Public interest litigation is
Yes, madam.
Yes. This is confirmed by the Supreme Court.
Supreme Court.
What is this?
The page number, my lord, in the lordship order, my lord.
It is a petition filed in the nature of public interest litigation, wherein the challenge is, in substance, is to the allotment of sites number 145, 146, and 147. Subject matter of this petition, which were vesting in the state government to the 8th respondent by way of sale. In WP number so and so is concerned, the challenge is to one of the 3 sale deeds executed in favor of the 8th respondent.
May I make submission, my lord, with the, so that this fact of the case I'm assisting this honorable. My lord, the supermarket area, it is belongs to actually the jail. Jails. It's a jail. So that ultimately the government is decided it has to be renovated and it has to be shifted. So that shifted to some other place, and after that there was the empty place here. So therefore all the properties have been sold out in this case. In particular, this case which I'm relying my lordship, in this case, there is a 3 auction purchaser was unable to make a payment on this particular property. So once they are unable to make a property, then the other persons is approached to the chief minister and deputy chief minister in the various writ petition. On their recommendations, the property was being sold. On that basis, the public litigations is filed in the High Court saying that it's everybody rights is there, public property in the fair market, it should be sold through auction only. So that therefore the High Court is held that because of the recommendation of the ministers, even auction property cannot be sold like this. Although ultimately in this case. So what we are going to be extracting this case, my lord, once it's even auction property, my lord, there is an alternative site is for concerned about us. So many applicant in this case. So only the 7 persons before this honorable court, my lord, if they are going to be asked even in the future also, the site what lordship is directed 20 into the 40. So the specific area for that also getting the disputed in future because we allotted for A person one site and they may demanded by the B person on the same site also. So ultimately the review concerned my limited prayer before your lordship, my lord. Auction property, it should be not be an alternative site. So that's what I wanted to be. So a prayer, my lord. Para number 18, it's a concern in this case, my lord. The observations of this honorable court in the para number 18, page number 17, my lord. My lord.
Page number?
Page number 17, my lord, para number 18.
Judgment illa, Sahib.
Judgment illa, correct.
ಅಲ್ಲ ಅದು ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ. They have given a copy of order passed in a public interest litigation.
I unconditional apology, my lord, not made you to lordship this order, court order, my lord.
ಅಲ್ಲ ನೀವು ಮಾಡ್ತೀರಿ ಕಂಡೋನೇಷನ್ ಡಿಲೇ ಹಾಕಲ್ಲ ಇದು ಮಾಡಲ್ಲ ಏನು ಹಾಕ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
I unconditional apology, my lord. With an application, my lord, I will.
How is it that only allotment of 3 sites were under challenge in the public interest litigation?
Please, my lord.
145, 146, 147.
It is only the 3.
Why only 3?
Then time that is only the 3 auction of the property, my lord. Then time. So only the 3 auction, other property was not been under the process of auction. So therefore that the ultimately even chief minister allotted, that was High Court has held that you can't take the because as a fair market it should be available everybody to the public, and that the chief minister order recommendation was set aside.
ಇದು ಯಾವಾಗ ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿತ್ತು?
My lord, this is 1988. This is auctions, my lord. This case
open auction.
Open auction 1988, my lord.
Auction ಅಂತರ ಮುಗಿತಲ್ಲ ಮತ್ತೆ.
Auction is correct, my lord. We are
allotment. This cannot be compared to this. It's not an allotment.
My lord, here also there is allotment how it is comes to
open auction.
Agreed, my lord. In this case also open auction was there, but auction bidder was not paid the amount within the time limitation. So once it is not paid amount, then the auction property is without litigation. So therefore they went to the Supreme Court to directions to this. I mean, they approached the CM to allot this site to somebody else. Auction property only. Ultimately, in this case also public litigation is a public auction only.
Yes.
And the highest bidder was unable to be make the payment as per the stipulated time. So then auction property is nothing but cancelled. So thereafter they went to the CM to be and get approval for this the allotment.
See, we are not concerned with this one, sir.
Yes.
What are the facts in our case, the present case?
Our case concerned.
We have recorded that there was a open auction conducted by the respondent authorities during the year 1988-89.
Please, my lord.
the petitioners had paid the entire sale consideration immediately after the bid was accepted by respondent authorities. It is not disputed that a sum of rupees 1,25,000 and 1,34,000 respectively were paid by the petitioners for a plot measuring 20 into 40 feet, square feet in the year 1988.
Absolute, this order is, we are agreed verbatimly, nothing is remains in this. Why we are going to be say that, my lord? Lordship is pointed out is a correct only. Auction property is a paid amount, they are entitled. Therefore, Lordship is held that the moment once you paid the amount, he is an entitled.
Yes.
Then we have taken the grounds before your Lordship then time. So the intention auction is correct only, but the situation we don't know that monumental is going to be an objecting from them. Now, monumental, national monumental, which auction property was nearby there. So national monument is objected for them not to be build any building there. So therefore, they approached to the Honorable High Court in the writ petition, saying that yes, you allotted or auction we purchases.
Correct. You give them alternative site and the direction site.
That's what. So at that time we have taken the ground saying that alternative site is not possible. We are going to be make a payment because site is going to be dispute. But anyhow, that order is comes to be this Honorable Court, and the directions has given alternative site now. Now the limited against this, the order Lordship is, only thing is we are saying that once the allotment is given, auction property is there, it cannot be alternative site to be allotted. As per the observations 18, if it is there, the Lordship is convinced, then we have a case. Otherwise, we have no case. Page number 18, page number 17, para number 18. That is only the limited, my lord. Otherwise, we have to be processed with further proceedings of directions of this Honorable Court. Page number 17, para number 18. Apart from that, the fact that the government order referred to the above contemplated auction of the site without the following fair and transparency procedures. The applications made by the allottee to the Honorable Chief Minister and for the public department and recommendations.
Case is
the same
Why are you
supermarket.
reading this one?
No, the same supermarket area only. Area the same area.
ಈಗ ನಾವು WA 200188/23 ಒಳಗೆ ನಾವು ಆರ್ಡರ್ ಏನ್ ಮಾಡಿದ್ವಿ ಅದನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ತೊಂದರೆ ಏನಿದೆ ಅಷ್ಟೇ ತಾನೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ತೊಂದರೆ ಏನಂತಂದ್ರೆ ತಾವು ಇದ್ರಲ್ಲಿ 7 ಜನ ಇದ್ದಾರೆ. ಈಗ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರ ಪ್ರಕಾರದಲ್ಲಿ ಆ 7 ಜನಕ್ಕೆ ಸೈಟ್ ನಾವು ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಾಗ ಅಲ್ಲೇ ಅಮಾಂಗ್ ದಸ್ಟ್ ನಾವು ಒಂದು ಯಾವ್ದೋ ಒಂದು ಎಕ್ಸ್ ಪಾರ್ಟಿಗೆ ಪರ್ಟಿಕ್ಯುಲರ್ ಏರಿಯಾ ಮಾಡಿ ಇದು ಅಲಾಟ್ ಮಾಡಿದ್ವಿ ಅಂತ ಫಾರ್ ಅ ಮೂಮೆಂಟ್ ವಿ ಆರ್ ಗಿವನ್ ದ ಲ್ಯಾಂಡ್ ಅಂತ ಅನ್ಕೊಂಡ್ರು ಕೂಡ ಬಿದವ್ರು ನನಗೆ ಅದೇ ಲ್ಯಾಂಡ್ ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಸೊ ಬಿದವರು ಲ್ಯಾಂಡನ್ನೇ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿದ್ ನನಗ್ ಬೇಕು ಅಂತ ಡಿಸ್ಪ್ಯೂಟ್ ಶುರು ಆಗುತ್ತೆ. ಅದರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕೇಶನ್ ಆರ್ಡರ್ನೇ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ನಮ್ಮದ್ರಲ್ಲಿ. ಸೊ ಒಂದು ಡೈರೆಕ್ಷನ್ಸ್ ಸೇಯಿಂಗ್ ದಟ್ whatever the state government is giving to the alternative remedy, they are giving without any dispute, is going to be number 1. Lordship ಏನ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ? My lordship,
ಅಲ್ಲ ನಿಮ್ಮ ಅಫಿಷಿಯಲ್ ಅನ್ನ ಅವತ್ತು ಕೋರ್ಟ್ಗೆ ಕರೆಸಿ ಕೇಳಿ ಹೇಳಿ ಅಂತ ಹೇಳಿ ಅವ್ರು ಹೇಳಿದ ಮೇಲೆನೆ ಮಾಡಿರೋದು. I think some of the official was present in the court on that day.
Officer was present before the court.
ಅವತ್ತು ನಮ್ಗೆ ಅದ್ರ ಇದು ಇವಾಗ ತಾವು ಹೇಳಿದ್ ಕರೆಕ್ಟ್. ಅವತ್ತು ನಮ್ಗೆ ನೋಡ್ಲಕ್ ಆಗ್ಲಿಲ್ಲ ಆ ವಿಷಯದಲ್ಲಿ. ವಿ ಆರ್ ನಾಟ್ ಎಜುಕೇಟೆಡ್ ಆನ್ ದಟ್ ಟು ದ ಫೇರ್ಲಿ ಸಬ್ಮಿಷನ್ಸ್.
See, you can't compare an allotment made at the instance of the ministers with the allotment made in terms of the directions issued by court of law.
Court is, we are considered, my lord. We are agreed with
You are
that.
now required to make the allotment in terms of the directions issued by this court.
Please, my lord.
What was found in the public interest litigation was allotments were simply made at the directions of the ministers.
Correct.
That is why the division bench found fault with that.
Yes, we have
That is not so in the present case.
No, we have taken opportunities before your lordship now. By way of this, at least the directions to the petitioner to accept whatever we give at the land, because that should not be again the litigations. For example, A1 allotted XYZ place. So C and B is demanding on the same, then they will come to the court also. Ultimately, it will never end that. So that the directions also is required, whatever their requirement also there. So one land is, suppose we are implementing of this order code.
Direction now.
Malad, the directions by this honorable court, Malad. Para number 7, Malad, page number 15.
One nimsham. Before that,
So before that, 6, para number 6.
please read paragraph number 6.
6, Malad.
Yes.
Having heard learned counsel for the complainants and learned additional advocate general so and so for the state, for the supermarket committee, and on the pursuing of the appeal papers, this court is a considered opinion that the impugned order passed by the learned single judge is on the basis of the acceptance of the offer made by the petitioners, neither in the respective of the affidavit, if the state and supermarket committee were indicated to accept.
Not inclined to accept.
Inclined to accept the offer made by the petitioner, then the objection should have been raised before the learned single judge. During the course of these proceedings, this court had recorded the submissions of the learned counsel for the petitioner complainant on the basis of the certain objection sought to be raised. At this hand of the state and it is authorities that 30 into 40 square feet, the site cannot be allotted to the writ petitioner. Since what was allotted them was only the 20 into 40 square feet site, we have directed that this contention then the respondent and required to be an allot alternative site measuring 20 into 40 feet to the petitioner complainant. However, since it was undertaken by the writ petitioner complainants and that way they were prepared to be pay sum of rupees so and so, the difference amount of rupees 30 into 40 site, we had directed the respondent to authority to consider the same now. Thus, state and supermarket committee are opinion that the market value of 30 into 40 site supermarket area, which is sought to be allotted to the petitioner, would be the very greater value, and they cannot be a position of the allottee of the same. We are constrained to hold that the state of supermarket committee is bound to allot alternative site measuring 30 into 40 square feet, the site to be petitioner complainant. With we dispose of the writ appeals, once again the directing the state to the supermarket committee to allot the site measuring 20 into 40 square feet supermarket area to writ petitioner and complainant are expeditiously and possible, and they any rate within the period of 4 weeks from the source.
Yes.
But here also that the site, even assuming that the allotment, it's a bound to be allotment, there is no question. And then the again the among the other petitioner or complainant, their dispute arises. So therefore, once the directions, whatever the state is given to them, they have to be consideration so that it will be going to be the end of this litigation. If the review is.
So your ground in the review petition is that such a direction was issued by the division bench in a public interest litigation.
Correct.
That you cannot make allotments just like that at the directions of the ministers. Whatever has to be done in a transparent manner.
Please.
By holding a public auction.
Agreed.
Now, we find that directions has got nothing to do with the directions issued by this court. These are not directions issued by ministers.
Agreed.
These are directions issued by the court.
Court is binding on the state.
Will be bound by it.
Yes.
And please proceed. We don't find any reason to review or order.
Please.
Barkal.
Malad, if your lordship is given directions with the right site also, whatever the state allotment, so that among their dispute, it may be an end of the litigation.
You know?
You convince those people. There is an order already. You convince those people on that and do it. Why we should order?
Allala, my lordship, ಏನಾಗುತ್ತಂದ್ರೆ see state government one allotment ಆದ್ಮೇಲೆ, so this honorable court order is we have been complied. Number one, number after the complaining, that's the site
ಈಗ
allotment itself is
ಹೇಳೋದು
going to be disputed
ನೀವು
by the
ಹೇಳೋದೇನು
other
ಅಂದ್ರೆ
parties.
ನೀವ್ ಹೇಳೋದೇನು ಅಂದ್ರೆ ಈ ಸೈಟ್
For
ಗಳನ್ನ
corner
ಬೇರೆಯವರಿಗೆ
area,
ಈಗಾಗಲೇ
a
ನಾವು
person is
ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ
allotted.
ಅಲ್ವೇ?
My lordship.
ಈ ಸೈಟ್ ಗಳನ್ನ ನಾವು ಈಗಾಗಲೇ ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ, ಹೀಗಾಗಿ ಮತ್ತೆ ತಟ್ಟೆ ಶುರು ಆಗುತ್ತೆ ಅಂತ ನೀವ್ ಹೇಳೋದು ಅಲ್ವೇ?
ಅಲ್ಲ, ಈಗ ನಾವು ಸೈಟ್ ಯಾವ್ದು ಇವಾಗ ಫ್ರೆಶ್ ಆಗಿ ಕೊಡುವಾಗ, ಫಾರ್
ಹಾ.
ಎಕ್ಸಾಂಪಲ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಪರ್ಮಿಷನ್ಸ್ and a person is allotted one corner area.
ಸರಿ.
That they be wanted to be, I want this, they should not be raise the query and again disputes. Because
ಅಲ್ಲ ಅಲ್ಲ ಈಗ
Not,
2040 ಯಾವುದು
that
ಅಂತ
is
ನಾವು
what-
ಏನು ಹೇಳಿ
how are you allotting this supermarket sites now?
my lord, now it's a auction, we are going to be allotting with a plan.
For what can you put for auction?
My lord,
What can you put for auction? Only those sites which are available, you will put for auction. If this site is already allotted in terms of the directions of the court,
no,
how
no,
can you put it up for auction?
my lord, this site,
One can also ask, no, you please put that site for auction ಅಂತ ಯಾರು ಕೇಳಕ್ ಬರೋದಿಲ್ಲ.
ಇಲ್ಲ ತಾವು ಹಾಗಾದ್ರೆ ಯಾವ್ದು ಅಲಾಟ್ ಮಾಡಿದ ಸೈಟ್ ಇದೆಯಲ್ಲ, ಆ ಸೈಟ್ ಹೋದ್ರೆ ನಮ್ದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲ ರೆಸ್ಪೆಕ್ಟಿವ್ ಪಾರ್ಟಿಗೆ. They don't want to be that site. Why they don't want to be ಅಂದ್ರೆ, they are unable to construct the building because nearby adjusting to the national monument area ಇದೆ. They can't utilize for the commercial also.
ಅದಲ್ರಿ, ಅದ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. That is why we have directed you to allot an alternative site.
Alternative site, what we are giving, they have to be accept. That's what my prayer.
ಮಾಡಿ.
They should not raise the question. That's what the
ಮಾಡಿ.
observation is
All right.
there.
All right. Please read paragraph number 7 once again
Of lordship.
of our order.
for order. You allot the sites ಅಂತ ಹೇಳಿದೀವಿ, ಇಂಥದ್ದೇ ಸೈಟ್ ಅನ್ನು ಅಲಾಟ್ ಮಾಡಿ ಅಂತ ನಾವು ಹೇಳಿಲ್ಲ.
With this,
Eh.
we dispose
ಹಾ.
the writ appeals once again.
Once
directing
again,
the state
direct the state and the supermarket committee to allot sites measuring 20 into 40 square feet in the supermarket area to the writ petitioners as expeditiously as possible ಅಂತ ಹೇಳಿದೀವಿ. ಹೌದೇ? ಇಂಥದ್ದೇನೆ ಮಾಡಿ, ಕಾರ್ನರ್ ಸೈಟ್ ಅನ್ನೇ ಮಾಡಿ, ಈ ಸೈಟ್ ನಂಬರ್ನೇ ಮಾಡಿ ಅಂತ ನಾವು
ತಾವು
ಹೇಳಿಲ್ಲ.
ಹೇಳಿಲ್ಲ. ನಾವು ವಿ ಆರ್ ಎಕ್ಸ್ಪೆಕ್ಟಿಂಗ್ ಫ್ರಮ್ ದಿಸ್ ಕೋರ್ಟ್ ಟು ಬಿ, ನಾವು ಏನ್ ಅಲಾಟ್ ಮಾಡ್ತೀವಿ ಅದನ್ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಲಿ ಅಂತ ಲಿಟಿಗೇಷನ್.
What we have said, sir, we have not given them the choice
Uh-huh.
that you will be permitted to choose ಅಂತ ನಾವ್ ಹೇಳಿಲ್ಲ.
ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮೈ
Why
ಲಾರ್ಡ್ಶಿಪ್ ಇಸ್
unnecessarily reading something into it which is not there.
in the
You allot the
supermarket
sites which
area,
are not in
area,
dispute.
the writ petition ಅಲಾಟ್ ಅಂತ ಹೇಳಿದ ಅಷ್ಟೇ.
ಅಷ್ಟೇ. Allot at 20-40 site ಅಷ್ಟೇ ನಾವ್ ಹೇಳಿರೋದು. Allot it. They have to accept it.
As per the directions of
ಅಷ್ಟೇ.
this honorable.
ಅಷ್ಟೇನೆ.
These
ಮಾನ್ಯುಮೆಂಟ್ ಏರಿಯಾದಲ್ಲೇ ಬರುವಂತ ಸೈಟ್ ಅನ್ನ ಅಲಾಟ್ ಮಾಡಬೇಡಿ ಅಷ್ಟೇನೆ. ಬೇರೆ ಇರ್ಬೋದಲ್ವೇ? ಯು ನೋ ದಟ್ ದೇ ಕೆನಾಟ್ ಬಿ ಅಲಾಟೆಡ್. ಬರೋದಿಲ್ಲ ಅಲ್ವೇ?
ಸೂಪರ್ ಮಾರ್ಕೆಟ್ ಏರಿಯಾ ಅಂತ ಹೇಳಿದೀವಿ ನಾವು ಅಷ್ಟೇ.
ಹೌದು,
ಕರೆಕ್ಟ್. ಈಗ ಸೂಪರ್ ಮಾರ್ಕೆಟ್ ಏರಿಯಾದಾಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಮಾನ್ಯುಮೆಂಟ್ ಏರಿಯಾ ಇದೆ. ಈ ಉಳಿದಿರೋ ಜಾಗದಲ್ಲಿ ಯಾವ್ದು ಮಾನ್ಯುಮೆಂಟ್ ಗೆ ರಿಲೇಟೆಡ್ ಹತ್ರ ಇಲ್ಲ, ಅದನ್ನ ನೋಡಿ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. ಅದ ಎಂಟೈರ್ ಏರಿಯಾ ಸೂಪರ್ ಮಾನ್ಯುಮೆಂಟಲ್ ಏರಿಯಾ ಇದೆ.
When you allotted the sites earlier, objections were raised that it comes within the prohibited distance and therefore they will not be permitted to put up any shops or any construction. That is why we were required to give an alternative site.
ಹೌದು.
Where is the question of you allotting the same sites now?
ಈಗ ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ ಇನ್ ಸೂಪರ್ ಮಾರ್ಕೆಟ್ ಏರಿಯಾ ಆದ್ರೆ ಅಲ್ಲಿ ಪಕ್ಕದಾಗಿಲ್ಲ ಮಾನ್ಯುಮೆಂಟ್ ಇರೋದಕ್ಕೋಸ್ಕರನೇ ನಾವು ಬೇರೆ ಕಡೆ ಆಲ್ಟರ್ನೇಟಿವ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಕ್ಕೆ ಅವತ್ತು ಅವರು ಒಪ್ಕೊಳ್ಳಿಲ್ಲ.
I think you have been misled. These review petitions have come up for compliance of office objections. Full stop. No application seeking continuation of delay has been filed by the appellants. Full stop. Nevertheless, comma, since urgency is pleaded by the learned additional advocate general that contempt petitions have been filed by the respondents and they are pressing for orders, comma, it is requested that the matter may be taken up urgently. Full stop. Next para. Learned additional advocate general submits that in an earlier round of litigation, comma, wherein public interest litigations were filed in the year 2006 and 2007 in writ petitions number 16568 of 2006 and 15129 of 2007, questioning the indiscriminate allotment of sites in the supermarket area, comma, a coordinate bench of this court, comma, at Bengaluru at the principal bench disposed of the writ petitions on 31st of October 2019. Noticing that the government order referred, comma, contemplate auction of the sites comma, without following a fair and transparent procedure. Full stop. It was noticed that sites were allotted on the basis of recommendations made by the concerned ministers for the Public Works Department and at the recommendation of the Honorable Chief Minister. Full stop. Having regard to the law laid down by the Honorable Apex Court in the case of Akhil Bharatiya Upbhokta Congress versus State of Madhya Pradesh and others, bracket early 2011, close 5 SCC, page 29. It was held that such an action prevented the other eligible persons from making a competing claim and applying for allotment of sites. Full stop. It was therefore directed that the state government has to act as a trustee of public property, and therefore disposal of public property must be done in a fair and transparent manner, providing an opportunity to all the interested persons to participate in the process. Full stop. It was found that the allotments made therein were contrary to the law laid down by the Apex Court. Full stop. Consequently, it was declared that the sale of sites number 145, 146 and 147, which were the subject matter of the public interest litigation, were in violation of Article 14 of the Constitution of India. Full stop. Consequently, the state government was directed to take action such as correction of the revenue record, entry of the name of the state government in the revenue record, etc. Directions were issued to the state government to initiate action for repossessing the said 3 sites. Full stop. Next para, learned additional advocate general would further submit that the persons who were aggrieved of the said orders passed by the ordinate bench of this court approached the apex court in special leave to appeal (C) numbers 30221 of 2019. Full stop. The said special leave appeals special leave petitions were dismissed by order dated 3/2/2020, finding no ground for interference. Full stop. The learned additional advocate general would therefore submit that the grounds raised in this review petition is on the basis of the orders passed by the division bench in the public interest litigation and the orders passed by the Honorable Apex Court, upholding the orders passed by the coordinate bench. Full stop. It is submitted that these aspects of the matter were not brought to the notice of this court earlier. Full stop. Next para. On hearing the learned AAG and on perusing the review petition papers, we are of the considered opinion that the orders passed in the public interest litigation was in a different context. Full stop. The public interest litigation, the subject matter of the public interest litigation were sites number 145, 146 and 147 of the supermarket area. Full stop. It was found that allotments were made in favor of the private respondents therein without following a fair and transparent method. Full stop. However, in the case on hand, admittedly, the respondents herein have participated in an open auction conducted by the authorities. Full stop. We have noticed in our earlier order that the open auction was conducted by the respondent authorities in the year 1988-89. Full stop. The respondents were declared successful bidders and they paid the entire sale consideration immediately after their bid was accepted by the respondent authorities, by the appellant, by the authorities in the appeal. Full stop. It was not disputed that the respondents herein had paid a sum of rupees 1,25,000 and 1,34,000 respectively for allotment of a plot measuring 20 into 40 square feet, in the year 1988. Full stop. However, objections were raised from another quarters, namely the archaeological department, that the property fell within the prohibited zone of the archaeological sites and remains, and therefore the respondents were not put in possession of the properties. Full stop. These facts clearly establish that the case is totally different from what we find in the public interest litigation. Full stop. The respondents have been knocking at the doors of this court for nearly 3 decades. Full stop. We do not find any justification for the review petition. Full stop. Next para. At this juncture, learned Additional Advocate General would submit that the respondents should not be permitted to pick and choose a particular site for allotment. Full stop.
ತಮ್ದ ಆರ್ಡರ್ ನಾವು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತೀವಿ.
We do not find any such directions given by this court in paragraph number 7 of our order. Dated 18th of December 2023. Full stop. We have directed the state and the supermarket committee to allot sites measuring 20 into 40 square feet in the supermarket area to the respondents. Full stop. Next para. For the reasons stated above, we dismiss the review petition, while also noticing that no application seeking condonation of delay has been filed along with the review petition. Full stop. The review petition is accordingly dismissed.
Grateful. I apologize, my lord, embarrassing situation, my lordship.
Already namga
Matter and opportunities we have taken, my lord. And
now
we,
that the other side also is not there,
yeah, please.
we can say something openly.
Please.
We are still not able to understand what exactly is the problem.
Actually,
problem ಏನು?
ಅಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಅಂದ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಓಪನ್ ಆಗಿ ಹೇಳ್ಬೇಕಾದ್ರೆ ಆಸ್ ಪರ್ ದಿ ಒನ್ ಆಫ್ ದಿ ಆಫೀಸರ್ ಇನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಅದು ಹಾರ್ಟ್ ಆಫ್ ಸಿಟಿಯಲ್ಲಿ ಇರೋದ್ರಿಂದ ಸೊ ದಟ್ ಗೌರ್ಮೆಂಟ್ ಆಫೀಸ್ ಮಾಡಿದ್ರೆ ಜನಕ್ಕೆ ಬಂದು ಹೋಗೋದಕ್ಕೆ ಒಳ್ಳೇದಾಗ್ತದ ಸೈಟ್ ಬಿಟ್ಟು ಅದು
20-40 ಸೈಟ್ ಕಂಡ್ರಿ.
ಅಲ್ಲ ಟೋಟಲಿ ಇದೆ
20-40 ಸೈಟ್ ಅಷ್ಟೇ.
ಬಿಗ್ ಒಬ್ಬೊಬ್ರದ್ದು 20-40 ಬಟ್ ಬಿಗ್ ಏರಿಯಾ ಇರೋದ್ರಿಂದ ಒಂದು ಆಫೀಸ್ಗಳು ಆಗ್ತವೆ ಜನಕ್ಕೆ ಬರೋದಕ್ಕೆ. ಸೊ ಅದು ಈ ಬಿಕಾಸ್ ಆಫ್
ಕೊಡ್ಬೇಡ್ರಿ, ಎಲ್ಲಾದ್ರೂ ಇಲ್ಲ ಒಂದ್ ಸ್ವಲ್ಪ ಬೇರೆ ಬೇರೆ ಜಾಗ ನೋಡಿ ಕೊಡ್ರಿ.
ಸೊ ಹಂಗೆ ಹೇಳಿದಕ್ಕೆ ಸೊ ಗೌರ್ಮೆಂಟ್ ಆರ್ಟ್ ಆಫ್ ಸಿಟಿ ಇರೋದ್ರಿಂದ ಜನಕ್ಕೆ ಬಂದು ಹೋಗೋದಕ್ಕೆ ಹೆಲ್ಪ್
ಅದನ್ನ ಇವಾಗ ಯಾರು ಏನ್ ಮಾತಾಡಕ್ ಬರಲ್ಲ.
ನಾನೇನ್ ತಾವು ಓಪನ್
40 ಸೈಟ್ 3 ಜನನಾ? ಎಷ್ಟ್ ಜನ ಇದಾರೆ ಇಲ್ಲಿ?
7 ಮೆಂಬರ್ಸ್.
7 ಮೆಂಬರ್ಸ್ ಎಷ್ಟಾಗುತ್ತೆ?
ಅದಕ್ಕೆ
ಸೇರ್ಸಿದ್ರು ಎಷ್ಟಾಗುತ್ತೆ?
ಬಿಕಾಸ್ ಅವ್ರು ಇಷ್ಟೊತ್ತಿಗೆ ನಕ್ಷೆ ಮಾಡ್ಬಿಡೋರು. ಈ ಕೇಸ್ ಇದ್ದಿದ್ರಿಂದ ನಕ್ಷೆ ಮಾಡ್ಲಿಲ್ಲ. ಸೊ ಅದು ಅಲೋಕೇಟ್ ಮಾಡಿ ಗೌರ್ಮೆಂಟ್ ಆಫೀಸ್ ಮಾಡೋದಕ್ಕೆ ಮಾಡ್ಲಿ.
We have given you the discretion. Please find out somewhere the allotment can be made in some
grateful 100% we are good.
Inconsequential places.
100% we are willing to bear. We are willing to bear. But idralli
give it in a very prominent place. Nim kodi anta ನಾವು ಹೇಳು ಇಲ್ಲ. And we have not given them the choice to choose. ನಾವು ಹಂಗೂ ಹೇಳಿಲ್ವಲ್ಲ.
ಅದನ್ನೇ ಅಕೇಶನ್ ತಗೊಂಡ್ಬಿಡ್ತೀವಿ
ಮಾಡಿ.
ಅಲ್ಲ ಪಿಕ್ ಅಂಡ್ ಚೂಸ್ ಅನ್ನೋದು ಬೇಡ.
ಎರಡು ಕಾಮನ್ ಆರ್ಡರ್
ಅಲ್ಲ ಅದು ಪಿಕ್ ಅಂಡ್ ಚೂಸ್ ಅನ್ನೋದು ವರ್ಡ್ ಬೇಡ ಅಂತ.
ಅದೇ ರೀ ನೀವು ದಯವಿಟ್ಟು ಅವರಿಗೆ ಆತರ ಚಾಯ್ಸ್ ಕೊಡ್ಬೇಡಿ ಟು ಚೂಸ್ ಅಂತ.
ಆಯ್ತು.
That is why we have said we have never given that choice to them.
Please, my lord. Grateful, my lord. We are the
tomorrow, my lord, I am leave, my lord. My colleague will be appear before lords. Tomorrow, my lord.
ನಾಳೆ ಇದೆಯಾ ಮ್ಯಾಟರ್ ಅದು?
ನಾಳೆ ಅಲ್ಲ, ಬೇರೆ ಮ್ಯಾಟರ್. I am on the leave, my lord, tomorrow.
ಆಯ್ತು.
My colleague will be appear.
I'm sorry, my lord. Grateful to my lordship.
Thank you, brother.